first part was the second part. I don't remember. So how was this? Yeah.
Very high. There was the one one tweet back to summary.
Date on it.
Date is the wrong. But otherwise, it's perfect. Okay.
It was
Visitors here, neither one of them are here to speak. One is an intern from Leah Wilson's office, and the other is Foster.
born with born just
Oh, the person sitting in the back of the room is the lost officer.
You're ready whenever you are.
All right, good morning, everybody.
Good morning.
Oh, man.
Good morning.
Good morning.
Good morning.
Okay, great, thank you. All right, welcome, everybody. We're going to go ahead and get started. As usual, we'll look to Mimi to do the roll call.
All right, Justice Edmond.
Here.
Toby Rothschild.
Here.
Joyce Raby. Andrew Arruda.
Present.
Simon Boney.
Here.
Okay, thank you. Tara Bird.
She's up here. She is here.
Judge Wendy Chang. Abhijit Shavan.
Present.
Jean Clausen.
Here.
Johan Schroeshagen.
Here.
Margie Estrada. Lori Gonzalez.
Here.
Bridget Grammy.
Here.
Andrew Kuchera.
Present.
Joanna Mendoza.
Here.
Kevin Moore.
Here.
Heather Morse.
Here.
Daniel Rice.
Present.
Alan Rodriguez.
Here.
Daniel Rubens.
Here.
Mark Tuft.
Here.
Angelina Valverde. Joshua Walker.
Here.
Thank you.
Okay, welcome to everybody who's here in the room. Good to see you again, and thank you for those who are joining us on the phone. First thing that we typically do is call for public comment. By the way, before we go on, I should acknowledge a couple of people who have joined us in the room. We've got a couple of visitors. Johnson, you want to introduce yourself?
Hi, yeah, my name is Johnson, and I'm going to be sitting in for Leah Wilson, and I look forward to the meeting.
As I understand it, you've just graduated from UCSB, true? Congratulations. This is a perfect reminder that we need to turn our mics on. And we have someone who's joined us in the back. You want to introduce yourself?
If I must. My name is Eli Edwards, and I'm at Santa Clara University School of Law. I'm the Emerging Technologies Research Librarian for the Law School Library.
Oh, wonderful. Well, welcome. We're glad to have you. Okay, we open with a call for public comment. Is there anyone from the public who would like to comment on anything on our agenda today? Hearing none, we did get an email communication, and I'm going to turn to Randy to fill us in on that.
Posted in your agenda materials was an email from Jeannie Doi, an immigration practitioner. In the email, concerns are expressed about what's described as potential irreparable harm to vulnerable immigrants from predatory consumer practices that is believed to be possible risk of recommendations that would open up the practice of law to non-lawyers. And it is something that I think is representative of a sort of precursor of what we can expect to get when these recommendations are in fact put out for public comment. And I did actually look at some of the discipline statistics with Mia's assistance, and we did find that in the last two annual discipline reports in the area of unauthorized practice of law complaints, we see about 150 or over 150 non-lawyer UPL complaints in the area of immigration law. And so the concerns being expressed here are real. I don't think we can just dismiss it as being a lawyer who's being protectionist about their turf, seeing a recommendation that might create inroads into that. And I'm hoping that one of the takeaways from this is that as we go forward today and we articulate the cons to these recommendations, that we actually put on our thinking caps and try to come up with some of these real-world concerns that will come back to us and to the board when these things go out for public comment. And so what's being expressed here by an immigration practitioner about the so-called risk of harm from notario type activities, you can imagine that a trust and estates practitioner will say, well, if you open up to non-lawyer entities, all of a sudden there'll be groups selling living trusts to people who need it, or pushing wills on people who should have a living trust. Now that happens with negligent or nefarious lawyers already today, but add to the picture non-lawyers. And same thing with regard to, say, other areas of law. They will parade their horrible as to what could happen, and we need to be able to anticipate that. And to the extent we have recommendations that have cons and it says none, in order to sort of represent that we have really conscientiously thought about the consequences of what we're recommending, the ability to fill that in with something genuine is something that I think we should strive for. And just talking about the pros and cons, I want to touch on one thing that came up in our pre-meeting, and that is that some of the cons include rebuttals of the cons. And I think it might have been maybe an AIUPL, but the sense of some of the subcommittee chairs was that, and some of the task force leadership was that perhaps we should not be including rebuttals to cons at this time, particularly if it's only going to be selectively, because I don't know what inference you're going to take away from that if you have certain cons that have no rebuttal. It also sort of is an optics issue because it might detract from the perception that we are objective at this point and that we're really putting out a menu of options if we're trying to say, here's this con, but it's not a true con because. And so I think the consensus was that if you have an answer to a con, build it into the pros. At least that way it doesn't look like we're creating straw arguments for the negatives about what we're recommending. And so instead of a closing sentence in your con that says, but this is not a true problem because, add something to your pro that says, and to the extent there's concern that, the certification and standards that we're imposing will address that. And I think that will help. One last thing about the reports and recommendations coming out is that when we vote in the afternoon, staff is going to ask that we be authorized to make non-substantive, stylistic, or technical changes. So many of the explanations right now are written using phrases like the subcommittee concluded that, or the subcommittee believes, or determines. And what we would do before we present this to the board is we turn it into the task force, because we're going to be voting on all of this in the afternoon, and it should be the task force has found, or the task force believes. We might also be making some other non-substantive changes to the extent that recommendations are a little bit inconsistent, particularly, say, how we refer to the entity regulation model that we're talking about. Sometimes we refer to the approved provider, other times we say the certified registered entity. And so staff, before it turns it around to the board, will go through and try to harmonize some of the word smithing that we're doing in the recommendations. But that's it on getting this stuff out for public comment.
Okay, is it fair to assume that we all agree that it's, we're willing to let the staff do the cleanup on our various reports in order to make them look consistent before they go to the board? Okay, I see nods all around, so that's what we'll do. Anybody have any questions of Randy on what he just said before we move on? For the chair's report, all I'm really going to report out is what we're going to do today and what you can expect. In just a few minutes, we're going to break up again into the subcommittees. The goal, and then we have 90 minutes from 10:30 until noon. The goal of each subcommittee is to finalize your recommendations, to make sure that we've got not only the recommendations, but the explanations as well, with the pros, the cons, and explanation about how the recommendation responds either to the charter or to the Henderson Legal Landscape Report. Make sure that all that's voted on. This afternoon, that's what we'll do as a large group. We will discuss each one of the recommendations, and there will be separate votes on the recommendation itself, the pros and the cons, so that we will come away with a full product that can be taken to the Board of Trustees on July 11th. Each person, each subcommittee should designate somebody to be your spokesperson this afternoon for each one of your recommendations. I think the goal will be, because we've got 8 to get through, some are way easier than others, I think. The goal should be that the original person presenting the recommendation should do it in just a couple minutes. And then we'll open it up to a fuller discussion. And in some, like I said, some I think probably won't be much discussion necessary, and others will probably need quite a bit. Okay. I'll let you know later where the subcommittees are going to meet. Any questions you have about any of that, what we're doing today? Okay, Randy, how about the staff report?
I just want to confirm what's coming next. And so this is the last meeting we have before our tentative report and recommendation is due to the board. The board will consider it on July 11th. It's going to be at about 1:30, 2 o'clock. It'll be the first open session matter taken up by the board on that meeting day. And we have confirmed our leadership participation in the board presentation. So Justice Edmond, Toby, and Joyce will be all there to present the report. We'll have Professor Moore as our rules ethics expert to answer any questions in that regard. And we're also trying to round up a tech-savvy person to also back us up in that regard. So if we can get a tech person to help cover the tech questions that the board might have, that would be great. All members of the task force are welcome to attend the meeting or view it. It will be live streamed, but the main presentation team is pretty much accounted for. We are asking simply that the recommendations be issued for a 60-day public comment period, and that we be authorized to have a public hearing. So to the extent that the action today is picked up by the media or other interested persons or stakeholders, and you get questions, the answer is the action taken today did not settle or dispose of any question or issue or policy reform. It was really to authorize more information gathering. So to the extent we're talking about abrogating UPL limitations, changing fee sharing prohibitions, changing the advertising rules, all of that is really the opening volley for a discussion, and that's what our action is today, and that's what we're asking from the board. We do have a meeting in August that was added to the calendar. On August 9th, we have a meeting at which we will receive presentations from primarily folks who will help educate us on really what is going to be the fleshing out of these recommendations at the implementation stage, which will be by another body. But we have Jillian Hatfield from University of Toronto Legal Design Lab and Margaret Hagan from the Stanford Legal Design Lab. And they will both be talking to us about sandboxes and other forms and methodologies for considering regulatory change. And we will also have Colleen Cotter, the Executive Director of Legal Aid of Cleveland, which is one of the LSC grant recipients for developing legal technology tools. And so we have at least those 3 on tap. I think I'm going to touch base with Justice Edmond later today to see if we want to add one more, because we might have room for one more. The other thing we would be doing at the August meeting, and we do need a quorum for that. We won't need it for the next day for the public hearing, but for the meeting we'll need a quorum. The other thing we'll be doing is taking a look at any public comment received by that time. Unfortunately, the State Bar's experience is that public comment comes in right at the deadline more often than not. It's rare that we get early public comment, but if we do have something in, we will talk about it at the August meeting. The day after, Saturday, August 10th, is the planned public hearing, assuming the board authorizes it. And at that hearing, we don't need to have a quorum, but we invite as many members of the task force who are available to attend to be present and to serve on the public hearing panel. It isn't necessarily something that is intended to be interactive, but there may be testimony given, and there might be questions you have about that testimony that if you're there and you can ask it on the spot, it'll be recorded by the court reporter, and that exchange will be transcribed, and the clarification that you're able to get out of that person will be memorialized. So the more people, the better to serve on the public hearing panel.
Can I just mention one?
Sure.
I'm just gonna mention one thing, and I'm gonna mention it now, but you'll probably get another email from staff, that if you will be joining the August meeting remotely, to let us know ahead of time. Let your subcommittee liaison know so they can make sure your location is noticed on that agenda.
And that's all I have for the immediate future. There'll be the report to the board July 11th, our meeting on the 9th, and the public hearing on the 10th.
Randy, have we been able to confirm that anybody from the ABA is going to participate in the public comment, either the ABA Center for Innovation or April or?
April is on board. Art Lockman, we've been in communication with him, and
Yeah, Art and at least one other person, and probably more, will be there and prepared to either comment, or if there's anything particular we want them to talk about, we can let them know and they'll follow through.
the most recent email floated was that they might be asking for a special set time, and I'll have to figure out how that can work. I think we can accommodate them. But it's busy because the ABA convention is in town, so getting a special set time. And we are reaching out additionally to Dennis Rendelman, who is the attorney for the Center of Professional Responsibility. Soon we will have a Californian, just a side note, at the Center on Professional Responsibility, Teresa Schmid, formerly of State Bar OCTC staff and longtime member of the Los Angeles County Bar Professionalism Ethics Committee, and currently a member of COPRAC. She has ascended to becoming ethics counsel for the center. So to the extent the ABA might be able to assist or provide input, we have an inside person.
Perfect. Randy, I'm sure you said this and I missed it. What time is the meeting on Saturday?
The public hearing, I don't know if Lauren's in the room, we were shooting for the afternoon. Is it still approximately 2 o'clock for the public hearing?
Yes, tentatively 2 to 5-ish.
Okay. Yeah, it'll be tentatively set for 2 to 5. If there's a special set that we arranged, that could change the time, but right now plan on it for being Saturday around 2 to 5.
Terrific. Okay, any questions for Randy? Comments? All right, hearing none, I think the only action item we have at this moment is the approval of the action summary. As I understand it, there is an amendment to the action summary that is on the board.
Sorry, the wrong date made it on today. But beyond that,
All right, with the corrected date, is there a motion to approve the action summary?
So moved.
All right, I'll take it as a moved and seconded. Okay, terrific, thank you. Mimi, do we need to do a roll call
Yes,
vote? Okay.
because people are remote, so we have to do a roll call vote
Please.
for everything. Justice Edmond,
Yes.
Andrew Ruda.
Yeah.
Simon Bomey,
Yes.
Tara Bird.
Yes.
Judge Wendy Chang, Abhijit Chavan. Jean Clausen,
Yes.
Johan Felsheiken,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Gremy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Brady, Daniel Rice,
Yes.
Toby Rothschild,
Yes?
Alan Rodriguez,
Yes.
Daniel Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, and Joshua Walker.
Yes.
Thank you.
Okay, we are pretty much right on time for the breakouts of each of the subcommittees. According to my notes, the Rules and Ethics Opinions Committee is going to stay here in this room. UPL-AI is going to go upstairs to the 8th floor, room 8A. And ABS-MDP remains on the 4th floor but the boardroom wall will divide the space to create a room.
Can I also mention one thing? Some of the subcommittees that are in the other rooms, you guys may finish earlier than the people in the main room. Take your stuff with you so you don't come back in to collect them if you start lunch early or whatever, so that it's not disruptive.
Okay, everybody know what we're doing? All right, thank you very much, and we'll see you back here at noon.
Okay, so first we need someone to take notes.
I can do that today.
Great, thank you. Do we need to do another roll call?
Yeah.
Okay. Tara Bird, here. Kevin Moore.
Microphone?
Here.
Johann Dolshagen,
Here.
Lori Gonzalez,
Here.
Andrew Kushera,
Present.
Daniel Rice,
Present.
Alan Rodriguez.
Present.
And a call for public comment.
Hello?
Hello?
Oh, yes, hi, Nick Rishwain, I'm here, I'm listening.
Oh, hi.
Nick, can you spell your last
Did you
name?
want public? Yes, it's Rishwain, R-I, S as in Sam, H, W-A-I, N as in Nicholas.
And did you want to present any public commentary for the subcommittee?
Oh, no, I'm sorry, I thought you just wanted to know, who were taking attendance, that you wanted public comment on who was listening in.
Yeah, we wanted to know that too.
Okay.
Thank you.
Thank you.
And approval of the action summary from May 13th, 2019?
No, June 3rd.
Oh, from June 3rd. Am I looking? Oh, approval of the action summary from June 3rd.
Your motion?
I'll make a motion.
Second.
Who's second?
Tara Bird, here?
Yes? Kevin Moore?
Yes. Approved.
This is the meeting. If you're putting us on hold or muting us, you are feeding music into the call. Hello?
If they're on hold, they won't be able to hear.
Yes.
Nick's still on, maybe we can ask who's on, it's just Kevin, Johan, and Nick.
Nick Rishwan?
Well,
Johan, are you still on the call?
Yes, I'm here.
Okay, it's not him.
Listening to music, though.
yeah, so are we.
Nick, are you still on the call? Yeah, I'm gonna tweet at Nick. Hold on.
Oh, do you know who he is?
Yeah.
Oh, thank you.
Oh, that is funny.
He works for expert witness company local to somewhere
Looks like
here.
it went away. Tell him to walk on over.
Yeah.
Okay.
Nick, are you back on the call?
Okay.
Yes, I am.
So I think you put us on hold and we listened to some lovely elevator music.
Oh my, I'm so sorry, I will not let that happen again.
I heard you were local, so you're welcome to walk on over and hang out with us in person.
So
Okay.
sorry about that.
That's okay. Thank you.
So I'll finish the vote. Johan Drolshagen, this is on the action summary.
The answer is yes.
Lori Gonzalez,
Yes.
Andrew Kushera,
Yes.
Daniel Rice,
Yes.
Alan Rodriguez.
Yes.
Is that everyone? Okay, Randy, do you have a suggestion for how we should proceed with what we have left?
Don't we have to approve May 14th also? Or,
I thought we did that
oh, did we?
on our
Or the,
call.
yeah.
Did we do that?
I can't remember if we did it or we decided to defer doing it.
No, it was approved at the last one.
Okay. Okay, so
My suggestion is we start with the recommendations that we had more or less resolved at our last subcommittee meeting and
5.4.
finalized the supporting explanation, the materials that we're going to be providing for the public comment period, and the explanation with the pros and cons.
Is that 5.4 that you're
The
referring to?
5.4, and then we can do the
So 1.1 is largely done, isn't it?
yeah, maybe that one we could just knock it off in terms of, because I don't think we're going to touch anything on the black letter of the recommendation. It was really just the final write-up. So that's low-hanging fruit. You can grab that one. Go to 5.4, and then the two that we've included that are relatively fresh are the advertising and the 5.7.
Okay.
So we can
So let's
wrap
do
it up with those.
Yeah, so let's do that last. Okay, so do we need to make any more motions with regard to these? Or
Well,
do-
the motion would be to approve the recommendation with the provided explanation.
So I move to approve the recommendation for the adoption of new comment 1 to the rule of professional conduct 1.1, inclusive of the identified pros and cons.
Second?
So we'll vote Tara Bird,
Yes?
Kevin Moore,
Yes.
Johann Drolshagen,
Yes.
Lori Gonzalez,
Yes.
Andrew Kuchera,
Yes.
Daniel Rice,
Yes.
Alan Rodriguez.
Yes.
Okay, so let's now turn to 5.4, Alt 1. And this is our, sort of what we called our compromise to the task force as a whole. We anticipate there are some more radical proposals, and this was the proposal that we believe that would allow more fee sharing, but still protect the public. And this does not include anyone investing finances into a law firm. It does not include equal co-ownership of a law firm. Does not include State Bar oversight of, well, I guess they already have oversight of the firm, but of non-attorneys owning a law firm. The responsibility still rests with the lawyer, but this was what we felt expanded the rule in a way that would still protect the public, but increase access because now attorneys could partner with more non-attorneys and possibly fee share with other entities, non-attorney entities.
I'm sorry, can I ask a clarifying question? So where does it say that there's non-equal ownership, I guess, between lawyers? So lawyers have to have the majority ownership, is that?
Yes, so let's take a look. There's so many drafts that I just can't quite recall where because I think you missed the meeting.
I did, yeah.
Where we sort of finessed that.
Tara, is it the case that we're approving one of the two recommendations for 5.4 but not both? Is that right?
No, we're seeking to have them both included as part of the menu of options.
So these are two separate revisions to 5.4?
Yes.
Alt one
Separate.
and alt two?
Yeah, Alt 1 and Alt 2 are separate and completely independent proposals, one being more radical than the other. And can anyone find this faster than I can?
What are you looking for?
The provision that we settled on as to, if whatever we settled on as to how the split would be between the owners of a business. We were debating whether it would be 50-50 or 51-49. and I can't remember the conclusion he came to.
Kevin, if you're on the line, I think we considered all of the various options and then we decided to duck it by being silent on it.
I think you're right.
Is that what we ended up doing?
Come back. I'm having trouble. It's coming through a little garbled on my end, Randy. If you could just perhaps speak a little slower.
Yeah,
Sorry.
so what we're talking about is the concept in the rule that it permits, if you follow the requirements set forth in the rule, ownership interest and fee sharing with non-lawyers in the law firm, in the law practice, but we omitted any specificity as to what that percentage might be, leaving open the possibility of non-lawyer dominant ownership.
Yeah, I think that's correct, and we discussed it for some time, right? And then ultimately, we said that, you know, it doesn't matter how you split up a board, but the attorney whose name is on the document is the attorney who gets to be the shot caller. So we kind of reached the conclusion that, you know, even if you had 51% ownership of attorney and, you know, 49 non-attorney, even as practice goes now, you still can't have an organization full rank over an individual attorney's ethical obligation, an obligation to the client. So on that basis, we said, you know, let's not put in these rules.
Thanks for clarifying. That was very helpful for me.
Okay, are there any other questions on this? I sort of find the recommendation is drafted to be a little hard to follow.
Yeah, I'm not actually sure what the proposed rule is. Do we have a clean version of that somewhere?
Yeah, it's in, if you printed the agenda materials.
Is it in recommendation in that file number 2, I guess, 2-point recommendation _ adoption?
Yes, it's at the end.
It's at the end of the file?
I believe so.
Okay, so that'd be page 16? Yes, okay, so I think page 16 is the proposal. Thank you for that.
Well, pages 13 through 15 is attachment 1. That's the clean version of the proposed rule.
Okay.
And then 16 through 18 is the red line version, showing the changes to the current rule.
Okay, perfect, thank you.
And the one thing with this report and recommendation is, and I'm just stating the obvious, is that we have provided in line for the actual substantive changes individual pros and cons. So we don't have an overarching pro and con to the main recommendation. To the extent the rule effectuates a substantive change, we set forth the pros and cons at that point in the materials. And so these rule recommendations are a little bit different from the other task force recommendations. And in fact, I think when we voted it in the main meeting, I'm going to ask that staff be authorized to flesh out the actual recommendation statement to do a 2-sentence summary of what is alternative 1, so that the person who's reading it cold doesn't have to find the clean version to know what we're talking about.
Yeah, and it may be helpful. I mean, I would even approve just, you know, a reorganization of it, just so that it's a little cleaner to follow. But in any event, the content's there. So just sort of to summarize for everyone, you know, I'm looking at the red lines on page 16. You know, we've added this that includes but not limited to fee awarded by the tribunal or received in a settlement. That's pretty distinct from what was proposed. I think we drew this from the ABA, right? And they had it to where it was just fee award. So this expanded that because you could resolve a matter, and we did not want a court to be required to be involved. We also included this language: employed, retained, recommended, or facilitated employment. We hoped that that would include just really broaden the scope of who can share. Again, the original proposal in the ABA version was focused on a particular case regarding the ACLU. and this really expands it. We were trying to think of churches, as Alan proposed. We were trying to think of incubators. We also discussed incubators, or using that word, but decided that it was too, we didn't want to narrow it that much, and it was, people might not understand what that meant. But we did limit it in that it must qualify for Section 501c3. There was also discussion amongst our committee as to whether it should be so narrowly focused, and perhaps it should include other Section 501 or other nonprofits such as 501c6s. I think there's a list of, 18 or something. And so that's something that I wanted to ask in public comment, whether that was overly narrow. 6 basically refers to subdivision B, which we came up, I think, like a few months ago, and that outlined when an attorney could share fees. So I'll let everyone look at that themselves. So does anyone have any comments that have not already been vetted? Anything they see is wrong?
So I just wanted to, the last meeting was a little crazy, I think, with both these rules, and I spent a little time thinking about the pros and cons of both rules a little more since our last telephone meeting. And I just wanted to point out from a con perspective for me, subsection B1, the idea that the firm's sole purpose is providing legal services to clients, I think could have a really chilling effect on some really cool, innovative ideas that are available if law firms are partnering with other disciplines. So in an elder law practice, for instance, or estate practice, actually putting firms together with other services, such as helping elderly people apply for Medicare and Medicaid, or providing social workers. There are lots of services that can be partnered with legal that address needs that often lead to the legal issues to begin with. And this goes on in every type of law, in my opinion. So I just wanted to point out that sometimes in our effort to protect, we are regulating ourselves right out of some really creative ways to provide better options. So I don't know if we ever discussed that as a potential con, but I wanted to throw that out. Because I think there's some people trying to do those kind of things right now.
Yeah. So I think that the MDP section will address that, but I do think that's a fair con for this proposal. I also wonder whether, the 501c3, limitation kind of goes with maybe some of that. If it's for profit, then it would really fall under MDP. Still a con, but maybe they'll address it. And if it's nonprofit, maybe we're overly limiting that. So I think that that's definitely a fair con. And I just also want to point out one more addition, which is the comment number 4. And we drafted this comment specifically to address the idea of the incubators, which is, the way this comment is written, it's a nonprofit organization that provides physical facilities and clerical assistance, and we had the incubator in mind when we drafted that.
Yeah, and this is Kevin. If I could just jump in here. If you're talking about provision of non-legal services, that is something that we need to hold on to for the discussion of Rule 5.7, which talks about law-related services.
But I do think
and again, that's arguably the province of the ABS NDP committee, subcommittee, that they've looked into, and some of their recommendations would touch on that.
Mm-hmm. Right, but I do think it's still fair to say that that's a potential con to this rule, even though it may be, outside the purview of what we tried to do here. I think it's still fair to say, okay, but this, if this change was taken alone, it wouldn't necessarily address this point. So I think it still fits in within the comments.
It's a con to the rule, but in stating that con, you have to recognize these rules have to be read together. You can't read a rule in isolation, just like you can't read these subsections in isolation.
Sure.
Because as explained in the pros and cons, the subsections work together in order to provide the necessary protection to the clients.
Sure. But one of the things we discussed in our pre-meeting meeting is that we will not be making all the counterpoints to the cons in our list of cons. We're just going to lay out the cons, and we will lay out the pros, and the report will notify the public that we recognize there are counterpoints to all of these items. We're just trying to prepare a fair assessment of both sides. And so I think, Kevin, your counterpoint is also fair, but if we're separating cons v pros, Lori's statement would go into the con column, and we would have a counterpoint to that at the end of the day. Randy?
Kevin, I'm looking at your memo where you've got the pros and cons below B1. And in the pros, it says that number 2, it avoids the negative implications of a full-fledged MDP, which was the type of reform that was rejected by the House of Delegates, the ABA, that was considered by California but never went anywhere. And then in the cons, you have a con number 2 that says, see pro number 3 above. Could we add a con number 3 below that just includes Lori's statement that the limitation to a law firm as defined in the rules may limit the ability of law firms to partner with other disciplines and other professionals to provide other services in the absence of a Rule 5.7 or other mechanism for providing those services?
I think that's...
Yeah, that's fine.
Do you have it on the screen? Okay, so the limitation, or how about the limitation in paragraph B1?
Can that same comment also apply to the limitation that I raised in
Incubator?
No, in A5, that it must qualify under a section 501c3. I think they're the same, similar concepts. I mean, in both situations they're limiting.
Okay, well, let's wordsmith it here and see if we can lift it and also copy it into would be page 4. There's 3 cons for A5, and let's see if we can add it there as well. Oh no, we're going to write it here first and copy this over to the A.
Okay.
So the limitation stated in paragraph B1, restricting fee sharing to a law firm as defined by the rules may limit the ability of law firms to join with other, what did we say? Is it other professionals or other
services?
Other service providers?
Service providers or disciplines.
Other service providers or disciplines. That would offer valuable services to clients, but would not be provided in a law firm, provided by a law firm. So this fee splitting is inherently limited to the activities of a law firm in the practice of law. And so this con is saying, if we didn't have that limitation, you might be able to expand what is offered to clients.
Right. And then, can we just copy that?
Everyone's okay with that language as is?
Yeah, I think it's fine. I mean, it's just a...
Would it be worth throwing in something about, one of the things is that this is going out for public comment. This isn't something that I think a lot of people think through. But there are suggestions and potential models that partner services that lack of these services sometimes cause legal problems. I'm not wordsmithing very well, y'all. Maybe it doesn't mean all of that. I'm gonna leave it up to the subcommittee to decide. But I think the idea of partnering legal services with other services to reduce the need for continued legal services is what this rule prohibits. If it's only a law firm providing legal services.
I don't know that we need to get into that. I mean, I think that the point is stated here. I mean, right, the real point is, look, the con to this limitation is that it's a limitation, right? I think that's kind of the point, and I don't think we need to get into the nuances of the various types of limitations.
Okay.
And I think this, what you guys wrote is fine. I don't think we need to wordsmith a.
And you want to put the same exact language for A5, right?
So,
Econ to A5.
Yeah, I mean,
Same language.
That's not quite exact.
Econ number 4 to A5. So after the first one, we just have to adapt it for here, which would be
The limitation in A5,
the limitation in 5 restricting fee sharing to a 501.
501c3s.
Should we say nonprofit, 501c3?
I don't think it matters. It's the same thing.
And then we can get rid of as defined.
Maybe too limiting.
Sorry, again, Tara?
Just maybe too limiting
Maybe too limiting.
Yeah, and we can
by
say
excluding other nonprofits.
excluding other nonprofits. And sort of as a placeholder, you can delete the rest of it, but you can put in something here that just says the task force welcomes comment on expanding the type of organizations that ought to be permitted for this fee sharing exception.
I like that, thank you. Thank you. Anything else? I think those were both good additions. Okay, I will make a motion to approve the subcommittee's recommendation for the adoption of the proposed rules 5.4 alternative 1 with the pros and cons as amended today.
I'll second.
Tara Bird,
Yes?
Kevin Moore,
Yes.
Johann Drolshagen,
Abstain.
Lori Gonzalez,
Yes.
Andrew Kuchera,
Yes.
Daniel Rice,
Yes.
Alan Rodriguez,
Yes.
Actually, we probably should pause and say who would be the designated 2-minute sort of elevator pitch person for this when we get to the afternoon.
I nominate Tara.
I'll do it. I would normally nominate Kevin, but I know it's hard by phone.
Okay, and how about for 1.1 comment?
I nominate Alan.
Okay.
Okay, so moving on to Alt 2, I nominate Lori.
Wait, we go by the nose on the, finger on the nose deal. All right.
It must be a thing from the South.
This is if you don't want to do something, not it, put your finger to your nose, yeah.
Okay, so Alt 2, AKA Chernobyl. And
Objection to that.
Yeah, I was gonna say, Johan, go ahead. We probably have the same exact
Yes.
objection.
Terry, you're putting an awful lot of color into your comments about how you're labeling these things, and you and I have had a separate conversation on this that I had out of courtesy for you. I don't appreciate it.
The nuclear option was eliminating 5.4 entirely. Alternate 1 is baby steps, and alternate 2 is very middle of the road. And I don't want any coloring past that.
Okay. My recollection of the discussion on Alt 2 was that that it was really driven by Lori and Kevin assisting with the drafting. So this is your game here for Alt 2, and what do you want to do?
It's very fair what Johan is saying, and I think we made a joke, Kevin made a joke about titling it Sharon Noble, and I think that's fine for our, same as not it with the finger on the nose. But the reality is, as this goes out for public comments, the idea that this is going to blow up the legal field hurts what we're trying to accomplish, which is really to present some very new and innovative ideas. So I'm with Johan on that. I think we have to be careful, our words do matter. I know that both rules feel like major changes to the legal field. That is a perception, and we all get our own perceptions of that. There are going to be people in the public and within the legal space who feel that 2 doesn't go far enough. And so I agree, let's be a little careful. You know, our discussions have been very friendly, and we all are here with the same heart and mindset.
So to clarify, it was that description, it's not the proposal itself.
Right.
Okay, that's fine.
And I won't use that word outside of drinks after this committee.
Totally fine. I didn't know if that was the issue, which was not clearly explained, or whether you felt this rule as we drafted it didn't meet your expectations.
No.
So you're okay with this proposal?
Yes.
Okay, great. Thank you.
So we did, our media person who was at some of our prior meetings, Teresa Riano, she did do a media blast. I think there was like 20 plus media folks who were invited to sit in on the meeting today. And I did get a call from someone at Law 360 who said they wanted to be watching the stream. And so when we do get back into the main session, I think the best way to shorthand this rule is to call it the client consent model for fee splitting. I think that is neutral, I think it's descriptive, and we don't have to say things that suggest any sort of explosive consequence. So 1 is the limited or narrow fee splitting proposal, that's Alt 1, and the second one is a broadly stated client consent model for fee sharing.
And one of the things I've used in my brain to help me separate them a little bit is really Alt 1 is I know it doesn't exactly mimic the former proposed ABA rule, but it does mimic a past ABA suggestion. Is that fair? And Kevin, that I'm looking at the ceiling, meaning I'm looking at you. Is that fair as a way to identify that too? Because I think that's important as well as we start talking about
Okay, what I was going to suggest, since I don't think it has any place on page 2, the first full paragraph. You're talking about the pros and cons of this alternative 2, but you have a con for alternative 1. I would take that entire paragraph out. I don't think it's accurate, and I think it's misleading. There's no point in talking about this here if there is a change in the 5.4 memo that we just, for alternative 1 that we just approved. If you want to put in a general overall, sort of reorganize and put an overall pros and cons, put this in there. But I don't think this paragraph belongs in this particular memo for the recommendation.
I don't disagree with that at all. This was written, you know, it was more written in the style of a memo. So I think if we can add that language to a con to alternative 1, I have no problem with that. Johan and I both worked on this, so Johan, how do you feel about that?
But I also disagree with the last sentence of that paragraph. It is in the legal profession innovative. You might not view it as innovative or new thinking, but it is new thinking in California, which has had this prohibition on fee sharing for decades or even a century or more. So it is innovative. To just make a statement like that, I don't think is accurate.
So how can we restate that statement that says, because that's I agree that's a perception. In my perception, it's not. In your perception, it is. So maybe there's a way to deal with it that way. What if we took a... Sorry, go ahead, Johan.
So just one of the things, part of the reason for Alternative 2 was to show the entire spectrum of what was available. I'm not trying to change the format right now. I actually think we should only make a recommendation of one of the alternatives, but demonstrate the entire spectrum. Short of doing that, because I think we're too far down the road to go back to that, there is a lot of logic in Alternative 2 that is intentionally and specifically contradicting the existing 5.4 and Alternative 1. So making reference to it, I don't think should be taboo. And the level of innovation, whether it's incremental or grandiose, is really the point. I think it's the exact point why the task force is here, is to find that spectrum and to find out where larger efforts toward innovation can actually move the needle on this.
I think maybe we can just, what if we just say this, I don't know that we need to reference Alternative 1. I think that they should each stand on their own, because, they are two separate ideas. But maybe just say, this proposal is I'm not a wordsmith person, but is I'm trying to say it in a not like insulting way to the other ones. Not that it's more innovative, but is it more drastic?
Well, I think if we're talking about this specific paragraph, maybe there's a way to capture what Kevin is saying, and just, I see where Kevin is saying, the sentence reads, this proposed change, while considered by many in the existing legal sphere as a major shift, it's stated as a matter of fact, is not innovative or new thinking. Maybe we can just add in, could be considered by those outside of the legal sphere, or maybe some other version of that as not innovative or new thinking.
Okay, let me, Randy, can I ask you a question?
Yeah, I'm here, Kevin.
Okay, is the report going to be one of your good, succinct reports summarizing all the work of all the subcommittees? And then each of these memos and the memos of the other subcommittees, would they be attached as attachments to the report? Or do you envision that you're going to meld all of these into a single report? They will become the body of the report.
Yeah, the current draft of the agenda item simply lists the black letter of the recommendations, and then the section that follows that is the individual supporting report. So this report will be in the body of the agenda item as the explanation and support for this recommendation.
Okay, what if this...
The attachments might include other things. And so, for example, for the recommendation that says we're not going to be redefining UPL, that has its own report and recommendation, but we're going to be attaching Judge Chang's analysis as something that will be available to the board members to read in case they're not familiar with all of the law on UPL. But the things that we're approving actually go in the body of the agenda item, at least in the current draft.
What if this just says, Alternative 2 takes it a step further than Alternative 1?
Okay. I think the report should probably have at least a paragraph that explains that there are two alternatives, both of which are being put out for public comment, and and that the task force is seeking comments on both of these reports. Then let the reports speak for themselves. You don't have to denigrate one or the other, because I would like to maybe, add a paragraph to the other memo and say alt 2 goes off the rails by going too far. I mean, this is just a modest proposal. I think let's eliminate this where we're taking shots at the proposals, because I just think that this is inaccurate, what's stated in this paragraph. And I don't think it's necessary. All we're trying to do is get input. As Randy mentioned at the beginning of the meeting in the staff report, this is further information gathering. That's what we're trying to find out. We want the input from the public, whether they be lawyers or non-lawyers, technologists who are interested in entering the legal services field. We want their input. We don't have to make a statement that we think one or the other of these is crazy or not at this point. Let the public give us those statements, and then we can respond to those statements.
So I agree with Kevin, and I think if we just eliminate that paragraph, that the next one stands on its own to make the statement, which is Alternative 2 is meant to create a major shift in Rule 5.4 around ownership and fee sharing with very limited regulation. I think that sentence is strong, and I think it really encapsulates what the goal of Alt 2 was without any reference.
I'm not going to fight this out because I don't think it's worth the fight, but I am going to just point out that all of these meetings are public. We have a very long memo that has a lot of wordage that I have been very vocal about that I think doesn't represent the full subcommittee's thoughts about what actual concerns there are, public concerns, as we move forward with these thoughts. So there's a wealth of times the subcommittee has made statements that from an innovator's thinking and sort of side of the coin hurts this process as people try to make comments. Kevin, I respect and understand what you're saying. I'm not going to argue about taking this out, but even the simple fact that we started off this meeting calling this Sharon Noble, and this is part of the public record here as well, is how often this language has been colored with the existing model of thinking. And we were invited into the space by you guys, and we're very happy to be here to bring this kind of thinking to the table. And I think this is part of that thinking. So I'm going to just throw that out there so it's on the record, and then I'm fine if we take it out.
And I just want to apologize for the Chernobyl comment, because Johan did email me, but I misunderstood what he was saying. I didn't realize he was saying that's an inaccurate description of this rule. I thought he was saying this rule isn't what we wanted to propose, and I was confused in that, and so I apologize for perpetuating that.
No running for public office for you, Tara.
That has been established a long time ago.
I'll vote for anybody who's willing to say, hey, I might not have done that right.
Would a fair compromise be not deleting the entire paragraph, but maybe just even the last sentence in that paragraph?
I like the last sentence. I agree with taking out the last sentence. I do think that recognizing this is based on some existing, part of the beauty of this task force for me is that it brings people to this task force who would not normally be invited. This is not made up. This is what is innovative, and within the charter itself, it talks about how bringing people who are not licensed to practice law, this is part of how you protect the public, or this was the purpose. At least is how I read it. So I think, go ahead, sorry.
Sorry, maybe it's this proposed change, while considered by many in the existing legal sphere as a major shift, is a continuation of ideas that, like, just kind of deleting that.
Deleting the not
innovative or new.
Not innovative or new thinking.
Right.
Kevin, can you see that change?
No, hold on a second.
Because I agree that Alternative 2 starts off really strong and conveys kind of a difference between, and the fact that there's an Alt 1 and an Alt 2 to begin with, I think conveys the change.
Okay. It never was evaluated. It wasn't discussed because it never went out to the full ABA for discussion. Wasn't
I
put
think we just
before the
get rid
House
of the
of
last
Delegates in
sentence.
the ABA.
I think we should just get rid of the last sentence, and that keeps the explanation that Lori wanted, which was that it started with ABA and it hits out strong. I mean, that's a great, if I was drafting this as my personal brief, I wouldn't want that first paragraph because it weakens your argument, your point, your IRAC, your issue is Alt 2 is meant to create a major shift. That is your header. And so that's personally what I would do. But if you don't want that, then I at least think we should get rid of the last sentence in that first paragraph. Sorry.
So Kevin, and maybe part of this is that I've mischaracterized how the ABA dealt with this. I recognize Kevin as the authority in the room on rules. And so Kevin, is it that it says it was a proposed rule change recommendation and it actually wasn't? It was just a discussed?
Yeah, it was one of about 6 or 7 different areas of major revisions to the ABA rules that were discussed by the Ethics 2020. They ran out of time. They had a time limit. And this was a rule that they just made a decision based on the fact that multidisciplinary practices had been soundly rejected a little over a decade before. They weren't going to pursue that to pursue what they viewed as the more important revisions, which dealt with, discovery. And this is where the comment 8 about a lawyer's duty to be familiar with technology came in. This is what they were trying to do. They were trying to make lawyers aware of their duties with respect to technology. They did an exploration. They had subcommittees like we've had subcommittees, and they just made a decision. We don't have time to address this. Here's our issues paper. These are the issues that have to be addressed. Perhaps the ABA can appoint someone in the future. They haven't done that. So to say that this is something that was never implemented by the ABA, it was never put before the ABA, so there wasn't the possibility of it even being considered. And to say that it was a discussion that went on, I think is inaccurate, because it was a discussion of one subcommittee of a larger commission. But the commission was comprised of maybe about 18 or 20 lawyers and judges from around the country. But it wasn't put before the full body, and there wasn't an opportunity for public comment to be submitted by members of the profession or the public. So that's why I'm thinking this paragraph is inaccurate. I think that you can say that it was discussed by the Ethics 2020 Commission, but the way this says it suggests that this is something the profession rejected, but the profession never had an opportunity to consider it.
Well, I'm not sure that's what it says. I think you have more knowledge than anybody in the room and maybe everybody put together about how these things work. And from a very public, less informed of the rules model, that's certainly not what I intended it to say. It was discussed by the ABA. It never happened. That's the reality. And the idea that the profession didn't implement it because it didn't go out for comment, ultimately the ABA has done lots of things that, the reasons it chose not to do this, again, this is just based on this idea has been out there for some time. It has never been implemented by anyone anywhere. And while it does create a change, the fact that no one's even been willing to make that change up to this point is telling to me. So I'm not sure I think it's worth totally going off the rails on this. And I'm just gonna go back out and point out, we have lots of materials and all this crazy stuff that don't represent my view of how these things work. So I think we can put it to a vote, or we can, if everybody doesn't care to remove it, as long as I don't know.
I mean, does anyone have a problem with this? You could just end it at ideas. Proposed change, while considered by many of the existing in the legal sphere as a major change, is a continuation of past ideas.
I'm good with that.
Same.
And then end it after
No
ideas.
objection.
It's a continuation of past ideas.
Kevin, I'm not opposed to the idea if you want to take the first sentence
Yeah.
and make it sound, fix it so that it is a better representation of what happened.
This is Randy. Particularly since we're going to be inviting the ABA at our public hearing to address us,
Yeah.
we would lose credibility if it looked like we were misstating their past consideration, or if they even perceived that somehow we were denigrating their past consideration.
I mean, I'm still in favor of removing the whole paragraph. I
Probably
think
save
we
it just to
should-
remove.
I think
that
we're spending
first.
a lot of time wordsmithing
Yes.
this, that I don't think it adds anything. And if you think that it should have a reference to it, we could just say,
Joanne might feel differently, but I'm gonna say for the purpose of getting the comments that we're looking for, if Kevin feels this strongly and there's some concern about the ABA, I'm okay with removing the paragraph. Provided we aren't making major changes to the rest of the prose, because that is part of the prose for me.
I don't have any problem with the remainder. So, hearing no problems with the remainder?
We have a motion.
Vote to remove.
We
Okay.
just need to vote it out.
So I move that the subcommittee's recommendation of proposed Rule 5.4 Alternative 2 be approved with the amendment that the paragraph starting with Alternative 1 and ending with the word discussed is removed.
Tara, I'm sorry, one thing this has is the pros but not the cons in it. So this as it's written does not include any cons, and we're certainly not gonna, even I'm not gonna suggest there are 0 cons to this rule. So, I don't know.
Although that might not be inconsistent with what.
I think the cons will stand on their own. I don't know that we need to add them unless Randy or
Well, the structure of the other memoranda all have a con section, so we should at least have the con heading and be able to reference.
Get ready, Kevin.
Well, maybe we can make this really short and sweet, Cons are similar to those, are they similar to those in Alt 1?
Yeah, but we don't want them we want them to be able to stand on its own, so maybe we could either pull from it or.
Well, first of all, I think you could have a general, like, a simple statement that, that there would not be enough regulation which could harm the public.
Let me see what's in the other document, maybe it's confused.
Or maybe let those that just feel that there's a con here state their.
I was just trying to move this along. I mean, we have like 28 minutes and we have another rule to get through.
I don't have a con, is what I'm saying.
Huh?
Don't you have the 7s as well as the
Yeah, we have
5.7?
the advertising and the 5.7, so we.
Okay.
Although with those,
Even worse.
those will really be just the concepts.
Not the actual.
We won't
words.
be trying to wordsmith anything.
Kevin, could you give us maybe 3 or 4 cons right off the top of your head, very succinctly and awesomely, to add to this document?
Uh,
I think we lost you, Kevin.
Well,
I think,
Okay, I think one is, the regulation issue is the most important. I mean, the last,
just said this, Kevin,
I move that you first number the, instead of bullet points, number the pros above.
Okay,
Right, let's start with that.
So instead of bullets, we'll have 1, 2, 3, 4, 5, 6 numbered paragraphs for the pros.
Yeah, okay, because at least in number 6 and number 1 would say, with respect to number 1, although there is the purported oversight by a licensed legal professional,
With respect,
there is no, it's with respect to number 6, the pro number 6.
Kevin, I think we were gonna not reference the pros or the cons when we were listing the pros and cons.
Correct.
Is that right? So maybe you can just say there isn't enough oversight without actually referencing the other side?
Well, I think oversight by a legal professional
right, but
is not regulation.
we don't need to reference, we don't want the pros and cons to reference one another.
Fine, okay, fine. But there is no mechanism for regulating the non-lawyers under this proposal.
Okay, yes, that's.
And then can you also?
Because it doesn't provide the same kind of incentives that alternative 1 does by reference to Rule 5.1.
okay, I'm missing some words. You kind of got garbled for a second. Because it doesn't provide the same kind
Okay, so it doesn't provide the same kind of incentives for lawyers in the firm, or for lawyers to control the conduct of non-lawyers. Or just, as in alternative 1's.
Can we just say in reference to the rule that you're talking about, instead of saying, again, we're not comparing, I think, Alt 1 and Alt 2 to each other. Isn't that why we just pulled out a whole paragraph?
Correct.
Well, there's the incentives in Alt 1 is there's a big incentive for lawyers because they're going to be subject to discipline for engaging, for permitting the non-lawyers to control their independent judgment and so forth. And it's explicitly stated in the rule.
So
So
can can I read you what's written here? Because I think it, can you see it, Kevin? I think that hits on what you're saying. The con is very succinct, and
there is no mechanism.
Yeah, I think that's good. Can we also add, drawn from Alt 1 is there's little or no concrete evidence that such a radical, there's little or no concrete evidence that this proposal would increase access to justice.
can we add that to the Alt 1 as a con as well?
It's in Alt 1.
Oh, as a con? Okay, yeah. Sorry, I missed that.
I'm trying to read other cons from Alt 1.
Say that about everything.
Okay. Of should be or.
Of should.
In number 2.
Oh, yeah.
Sorry.
I think because this is a discussion that has happened a lot, another potential con is that a lawyer's professional judgment could be impeded. I think that's a fair con on this one because it's certainly something we've heard I've heard during these discussions. Is that fair? Do you want to add something to that, Kevin?
Okay, could we go back to number one? We're not going to refer back to alt one. But if we're saying the same kind of incentives, the first thing you're going to say is same kind of what incentives?
Yeah.
So it doesn't provide it doesn't provide the incentives
Can we reference
in
the
Rule
adequate.
5.1.
Just say, does not provide adequate incentives.
I'm not a big fan of saying adequate incentives. Can we just reference the incentives in the rule?
In
I
Rule
think you were,
5.1.
I think you
yeah,
say 5.1.
in Rule 5.1.
Yeah.
Well, if you don't
This-
have all the
this is-
systems and direct oversight, you could be disciplined.
That's an
That's your
incentive,
incentive.
maybe incentive isn't the right word.
To provide the protection, I don't know, or the,
Ethical obligations.
I think the connotation of the word incentives is a little bit
Yeah.
misleading. So it's like, what, 5.1 says you get something for doing something, you know what I'm saying?
Yeah.
I just don't think that's,
There's no message.
it's essentially control we're talking about, right? Is there a word we can use? Does not provide the
Okay,
ability to control the conduct of non-lawyers, as referenced in Rule 5.1, something like that?
How about instead of control, use the word supervise.
okay.
And just leave it at that, just supervise the conduct. Not provide the incentives as in Rule 5.1 and 5.3.
So change it to as in,
So
and then
the
5.1 and
incent-
5.3. For lawyers to supervise the conduct of non-lawyers.
And with respect to number 3, I'm not sure that's accurate because paragraph C of the alt 2 states as a requirement that there is no interference with the lawyer's independent professional judgment.
Kevin, we're friends. We agree on stuff.
Yeah, I agree with Kevin. I'd delete number 3.
Yeah.
I don't know that.
Okay, can we just go forward with these two? I mean, I would like to move on if we can.
It's quite possible somebody might come up with another suggestion for a con at the plenary session.
Right.
I'm betting we'll get some more.
I'm just suggesting for right now, otherwise we're not gonna get to the other.
Yeah, we gotta get
Okay.
these ones.
Can you tell when I get hungry? Because I'm starting to get hungry.
So you made a motion, she seconded it, but that's a friendly amendment, what the changes we
Friendly
made.
amendment is approved.
And then,
I approve the friendly
who
amendment.
seconded it? Was it Lori?
Right,
Okay,
second.
all right, cool.
Tarbird.
Yes.
Could you change in the second bullet point, or it's now number 2, change the word citizens to public? Because it's not limited, justice is going to be provided not just to citizens, but also to non-citizens.
The public, right?
I was gonna say no to this friendly amendment, but now I can't. I will be shamed.
Well, I'm looking forward to all of you amazing state bar doing your thing and fixing all that wordsmithing. Thank you for catching that, Kevin.
Okay.
Kevin Moore?
Yes, I'm here.
We're voting.
We're voting.
Voting.
We're voting.
On alt 2.
Yes.
Johan Drolshagen.
Yes.
Lori Gonzalez.
Yes.
Andrew Kuchera.
Yes?
Daniel Rice.
Yes.
Alan Rodriguez.
Yes.
Awesome.
Passes.
Okay. So now we have, is it 5.7? Is that correct?
Yes.
And this is this Kevin and Andrew's memo? Is that correct?
So Andrew's memo was a recycled memo from, I don't know, I think it was February or March,
Right,
where he
earlier.
was just explaining about what Kopak was doing, and actually that opinion has actually gone out for public comment now.
Sure. Yeah, have a citizen.
Wait, it's already what?
It's gone out for public comment since then, since the last meeting where he brought it up.
Oh, like on our website?
There's an ethics opinion that's provided as background, and that ethics opinion is now in process at the stage where it's out for public comment. So that's the only update to the
Okay,
period.
real public, okay. So I wasn't really involved in the discussion about 5.7 and what, I think you had some discussions with Kevin about this.
Yeah, so Kevin, at the last subcommittee meeting, I think it was ABS MDP, Mark reiterated his concern that the task force be able to take a closer look at 5.7 and the advertising rules that were revised last August by the ABA following the April study of the advertising rules. And the idea of including these on the rules subcommittee agenda was, it's more or less like a white paper approach, that we believe that there is the possibility that adding a Rule 5.7, even though the bar is in process with an ethics opinion on the topic, nevertheless is something that the task force should consider to be included in its final reporting recommendation. And so the modest, very, very sort of neutral approach to 5.7 and the advertising rules is just to put out the supporting materials and frame it as a request for public input on to what extent, if any, the task force ought to be recommending adding a 5.7 with this item, and then for the advertising rules, considering the changes that are in the August 2018 version of 7.1 through 7.5 in the model rules. We know a majority of states haven't picked up on those yet, but some have, and we would be recommending that California also be one of the ones early out of the gate to look at those advertising changes that the ABA made. But I don't think we're at the point where we're going to wordsmith a proposed rule as an illustration draft. We just want to get out the thinking of the task force on both of those topics represented in these two memos. And I think that would satisfy the concern that we get public comment back on both of those possible rule changes and be able to tackle them when we come back after the comment period is over.
Okay. Could we just take them separately?
Yes, definitely. I just wanted to save time and do the background on both.
Yeah. No, I agree that there isn't time to wordsmith, and I don't think the discussion has gone far enough. But I think I would particularly like input on 5.7. But my question, Randy, is how would we go about encouraging that input, that people would provide us with input on the rule? What materials would we put out to them? I don't think we should put out that memo that Andrew and I did, which is largely historical and talks about California in a certain degree. It should just be something like maybe a 1 or 2 paragraph memo with maybe a attachment, the ABA Model Rule 5.7 attached. This is what we're interested in pursuing, and maybe identifying some of the pros or cons.
We could do that, although we'd have to have either something on the table for the afternoon vote or authorize someone to finish it based on the directions that we would get. The appeal that I saw with including this, again, it's sort of like a white paper approach, is that the people who are considering providing input would be able to see how California has handled this so far in its case law, and how it's continuing to handle the same issue through an ethics opinion. And I think that's the biggest sort of factor that someone ought to consider in deciding, do we also need the rule? Because one of the criticisms of the rule is that it's very rigid when it says that a lawyer is not subject to the rules of professional conduct when. And we have case law and an ethics opinion that is a bit more nuanced than the hard and fast Model Rule 5.7. And I think you only get that when you read something like what we have here. Anyway, but that was my thought.
I think that we can just sort of maybe go through this really quick and maybe just do some cutting. For example, I think we can cut the introduction, which seems to be very internal facing, about our breakout sessions and stuff. And this memo does not make a recommendation as to whether the task force should recommend the adoption, right? I think all that can come out, and that we can start with the purpose of the rule, and then then we have the model. And I guess you're saying, or Randy was saying, that it's doesn't really fit within California, but at least it would give us something to put forward. And I'm just like looking at this as I go through it, but the stuff after that seems to make good sense.
Sorry, what term?
Okay. Yes, I think it's going to be really hard to try and do that right now. In terms of the introduction, I would take out the first two paragraphs of the introduction. I agree with you, but the last paragraph, at least in some form, and I would recommend that we delegate to Randy the task of maybe massaging that, and I would try and contribute as well. I'm traveling right now. I couldn't really do it that well, but I'll do my best to do something over the next few days to try and shorten this to some extent. But I agree with Randy. I understand Randy's viewpoint that we should have a little bit more of the history and an explanation that this isn't as easy an issue in California as it would be in other jurisdictions, because California has a substantial case law that has addressed the very issue that's addressed by Rule 5.7. So we have to work within those confines.
I mean, I don't know if we need the paragraph on the history of the ABA House of Delegates in 1991. That's a lot of information. I don't think that that's necessary either. Then you could start with state adoption maybe and disciplinary actions, like the California focused stuff. I mean, people can't read all this. This is like 36 pages. Like, we're trying to make these simple for people. This is not simple for anybody to read. So I don't think it needs to be this robust, and I do think we can shorten this a bit here before we vote on it, so that.
I think if you want, you can take out the disciplines actions as well, because they're not all California related. They go more to the ABA principles, so you can get rid of history, discipline actions, but then keep the California law.
Yeah, okay, and what about the first and second rules revisions commissions? I mean, that to me seems like it could go. But yeah, keep California case law and other authority, and keep law-related or non-legal defined. And then I think that takes us into what would be pros, which would be categories of non-legal services a lawyer might provide. And lists a number of things.
Kevin, what do you think about getting rid of First and Second Rules Commission? The reason why I'm asking is that at least some of the commenters that we would expect on this topic would be from the ethics committees, and of course the ethics committees might say, well, didn't the First and Second Commission consider this? If they did, why didn't they have the rule? And at least if we have it up front, they don't have that great big question mark impeding their evaluation of the proposal. You say, oh, okay, now I remember why we didn't do this with the rules that were just adopted by the court in November. This was their past reasoning. But it isn't essential. You definitely could drop it because the issue on the table is, well, what do you think now? As opposed to what did those two groups think before?
I mean, none of the other stuff we're putting forward is this robust, is it? I mean, this just seems like information overload relative to all the other proposals that are going forward, right?
It is, but it is, there's, in the package of materials, the rule proposals actually have the heavier amount of stuff than some of the other materials. And this one, we don't have an illustration draft that we're actually leveraging, so it kind of makes sense that we'd be a little bit more explanatory if we're not going to give them a version of the rule that we're thinking about.
I disagree. I mean, would the idea be that these 36 pages become part of it? Because, you know, again, to a person, to most people who, they're probably going to be attorneys to be fair, but, you know, to people that are going to be opening and reading this, you give 36 pages of something compared to 2 pages of something, which am I going to think has the greater weight? I'm going to think it's the 36 pages, even though I might read the 2 pages first. So I just think that that it needs to be distilled down to an approach similar to what we've taken from the other items or the other issues, even if, you know, we don't have an example here, because there's still something here for people to comment on.
What I would suggest is we get rid of the attachment, which is the updated 618 memo on the ethics opinion, and make that just an enclosure to the agenda item, so it doesn't appear as part of the discussion of the recommendation. That whole section would be separate. If anybody wanted to go there and read it, it would be among the supporting enclosures, similar to how we're going to include Judge Chang's UPL memo in support of the others. That way we cut out everything that starts with that memo, including the text of the opinion that's out for comment. It would,
is that page 19?
It would end, what page is it in there? I'm looking at my hard copy.
This is all separate pieces, so
Yeah.
I don't.
It would end after the attachment 2, which is the first Rules Revision Commission draft. But if you get rid of the section on the Rules Revision Commission draft, then that would come out too.
Okay, yeah, I think.
You could do that.
So that ethics opinion section be taken out then?
That brings us down to just, you know, 10, 11 pages, I think.
Yeah,
And
yeah,
that
about
makes
12
more
pages.
sense, and it's more in line with, actually, when you cut the other stuff, it'll probably bring us down to more like 8 pages.
And then just add a C, the enclosure for the one that's out for comment. So with those deletions, can you authorize Kevin to work with staff to finesse it so that it doesn't look sort of
Yeah, with the,
disconnected? We will get rid of the disciplinary actions. We'll get rid of the history. We'll move the Andrew Tuft memo as a separate part, as supporting materials, and it will end with the summary.
yeah.
Does that sound okay, Kevin?
Fine. That's fine.
With the specific direction that less is more.
Yeah.
So I think we need a motion, right? I'll move that memo analyzing Rule 5.7 be included in our proposals for public comment after removing the specific items that we discussed. I don't think we need to itemize those, and specifically authorizing Kevin and Randy to make revisions so that it is more consistent with the formatting and approach of our other rules, but that it specifically note that this language is not our proposed language.
Second.
Who's second?
Ellen?
Ellen.
Tara Bird.
Yes.
You have a minute and a half for the advertising rules.
Yes. Kevin Moore.
Yes.
Johan
Yeah,
Johan Drolshagen.
Yes.
Lori Gonzalez.
Yes.
Andrew Kuchera.
Yes.
Daniel Rice.
Yes.
Alan Rodriguez.
Yes.
Okay. 5.7, and Randy, can you sort of summarize both, but is this the same? You want us to take the same or similar approach to this one?
That's correct. The concern was that if we don't put something in the tentative report, we won't get any comment, and we wouldn't be able to really, with a sort of informed perspective, either propose it to the board to consider for implementation or not propose it. And so we want to be able to say that under consideration by the task force are the changes that the ABA made to the advertising rules in 2018, so that when we're at the public hearing, there'll probably be people in favor of those changes. They can explain why they would work for us and further our interest in innovation and broadening access, and then we can take that back and work on it in the fall to maybe have a more specific proposal to adapt these changes. And so, for example, one of the recent changes we made to the advertising rules that we took from the pre-August 18 model rules was that we defined a prohibited direct contact solicitation as including a real-time electronic contact. But we now know, having looked at all the different innovative online delivery models, that real-time electronic contact is sort of a given for some of the new delivery systems. So if you have an online matching service or online lead generation, that's all happening real-time electronic. There's nothing in person or by telephone anymore. And so the ABA has chosen to take that out of their direct contact prohibition. There is no prohibition against real-time electronic contact. And that would be something this task force can consider to allow those innovative models to not be chilled by the fact that a lot of the contact is happening online.
Yeah, and this was one of the rules that we kept trying to get to in our meetings and never quite got there. So I definitely think that this needs to be included. Although again, I hope we can distill it so that it's less than 59 pages. So is there a way in here that this can be shortened to something that, is tangible? Like, I don't know that do we need I don't think we need their red lines, right? We just need to know what their rules are. That appears that it will eliminate a lot of this material. I'm just kind of going through it real quick, and I'm seeing mostly red lines and drafts. And if that's correct, then we can, I see lots of committees and sections. I just see a lot of extraneous materials here.
Yeah, if you want to authorize, again, Randy and Kevin to put the template on top of it, if you look at just the page that says, it's with the two from Kevin that was from April 18, and then there's the listing of the attachments. If you want to pick and choose which one of those to be the support for this, I think that would be enough guidance for us.
Yes.
We definitely want the first one, which is the clean versions of the August 18 version of the model rules. So I think we want the first bullet to be
And I think
included.
the third, the model rule red line version, comparing it to, comparing ABA. We want our current rule compared to the ABA current rule.
I think that's what the third bullet is.
Is it?
Kevin, is that correct?
I'm sorry?
Is the third bullet of the attachments to your April 18th memo, ABA Model Rules 7.1 to 7.3, red line comparing the ABA Model Rules to California Rules 7.1 to 7.5? We exclude the comments because that could be just a mess, but the black letter is what we're comparing It will show how the ABA has consolidated the specialization topic so that it's not in a separate rule.
Yeah, I mean, the reason we just, for that one, the reason we just did the comparison to the text is because the comments are so different. You would end up with just about 30 or 40 comments that are stricken, some of which are moved other places. It would just be a complete mess and you really couldn't follow it.
Yeah, that's
So that third one, it's, you know, comparing the ABA model rules to the California rules shows the difference between the two and what would be involved at a basic level. The main thing is going to show what you just mentioned, Randy, about the real-time electronic contact, and that would be the most important thing to show.
Okay, and we have either the ABA resolution, the second bullet attachment, or the excerpt from the book describing the differences. I'm leaning towards the excerpt from the book because the ABA resolution
way too long.
was very long and it's readily available at the ABA's page where they give you the history of these recent changes. You can get that resolution and report there that has the April report. But
where does the excerpt from the book start?
Excerpt from the book. You have pagination on
Oh, I think it says chapter 7 information
Page
about
45?
49 of the actual total thing.
Yeah, it actually is captioned descriptive comparison of ABA model rules 7.1 to 7.3, and there's a bracketed thing that gives the citation. And
so
I think that's short enough and better than using the ABA report since the ABA report is available online.
Yeah, I mean, I would say, I would still suggest that maybe you take a look at it if given the opportunity and see whether maybe you can extract information from that to fit into our pro and con model as opposed to just using it as is, because it is still long. I don't know that we need the history going back to 1989, but I will let you make, you know, there's still a lot more historical context in there than I think is necessary for our purposes. So to the extent you can extract it and distill it and just get the points out there, I think that would be preferable for me. Does anyone else have any particular thoughts on that one way or the other?
Kevin, is the main point about the history that we've never had advertising and solicitation rules formulated along the lines of the ABA approach until the November 2018 rules? Previously, we had unique 1-400 approach, and it was only as recently as the rules adopted and made operative last year that we even tried to reorganize our rules to fit the ABA approach. And if we can just say that in 2 sentences, then we don't need to have the other sections that specifically summarize the 89 rules or the 92 rules.
Yeah, I think if you look at page 49 of 59, you have the preliminary note about the 1989 rules. And then you could keep that, and then I think, but I can't say for sure right now without reading each section because I know there's some cross-references. But I think for the most part, like Tara recommended, we can remove the sections on the 1989 California rules. We should be able to do that.
Okay.
And I can do that.
I see a long, I see a long section right at this whole lower 3/4 of page 50 of 59 probably can go, because then we can jump directly to the 2018 rules.
And to avoid confusion, we can probably remove the table on the standards for now as well, because that's a big part of that comparison.
Yeah, I would be an advocate, even if we take the ABA changes, to keep the authority that the court would give to the board to adopt standards. I don't think that should go, but we don't have to have the table.
That's that first table, but I think the other tables would show where the comments ended up from 7.4 and 7.5 would be helpful.
Yeah, because that was part of the major surgery that they did in the model rules. And
Right,
rather than
exactly.
reading about it, the tables make it very easy to track what ended up where. Why do they have 2 less rules? How did they get from 5 rules to 3 rules? I think the tables help.
Yeah, the content is still there. I mean, but they just eliminated 2 extra rules.
Yeah.
Which we could do. Okay.
Are we ready for a motion?
Okay.
Did you want to make the same kind of motion that to delegate to Randy and me to revise these 2 attachments, the red line of the text, ABA text to California rule, and the excerpts from the Zittrain and Moore book, and let us do that, and that will be included in the proposal.
Yes. Do I need to restate it, or does that count as a motion?
It's close enough.
Okay, we'll take that as
clean it up for the action summary.
Great, I'll second.
Could I ask just one more question?
No.
And Randy, maybe, or Kevin, my recollection is that the April proposal was even more advanced, went further than what the ABA ended up with.
I think that's right.
And I wonder if it would make sense for us to look back at April's original proposal, as well as what the ABA did with it, rather than just looking at the ABA's resolution of those questions. And we do have on our commission the expert, because Mark was the chair of the April.
Okay. I'm just wondering, did the April suggestion actually, the stuff that was rejected by the ABA, did that go to access to justice?
I don't.
That's what I'm trying to remember. And
Yeah, I don't remember that. We could certainly ask Mark and find out.
Yeah, I think we can put in this motion. Again, this is an information gathering report.
Yeah.
We don't have to put in explicitly that that's what we're going to do, but it's certainly something that we can do.
Yeah.
I don't think we need to add that to what goes into the report that's going to go out in July. But I think that would be something that we probably should do just to see if there is anything there that might be relevant.
Good.
That's a good point, Toby.
Okay, we can certainly in the explanation or the introduction add the explicit reference to the origin with April and maybe include a link to, is it online somewhere, the original April advertising proposal?
I'm sure it's on their website.
Okay.
Yeah, I have a copy of it as well.
Because that actually is where this started.
Yeah.
Okay, so let's vote on that motion. Seconded. Tara Bird.
Yes.
Kevin Moore.
Yes.
Johann Drolshagen.
No.
Lori Gonzalez.
Yes.
Andrew Kuchera.
Yes?
Daniel Rice.
Yes.
Alan Rodriguez.
Yes.
So I think that's it, if I'm not mistaken.
We completed the agenda.
Is there somebody to report on
Oh, yeah,
these
yeah.
others?
How do you want to handle the reporting of those two? I mean, I kind of think you should do it,
We
Randy.
can do it together, Randy and Kevin, or if Kevin has to sign off, then Toby can help me out.
Okay, thank you. Does that cover everything?
Did we have a pitch person for the 5.7?
They're gonna I think you guys are gonna handle both of
Yeah.
those,
Okay.
since they're kind of different.
Sorry, that was Joe.
Okay, so Alan, you'll do the comment 1.1, the 5.4 Alt 1. Did we have the 5.4 Alt 1? Tara?
Yeah.
And 5.4 Alt 2, Lori? And then 5.7 and 7.13, Toby, Randy, and Kevin. Cool.
I'm assuming everyone voted yes.
Where's that?
Okay, just so you know.
We had a no vote from Johan on the advertising rules. Everybody else, yes.
Is that it? Okay, so just so you know, I spoke to Justice Edmond. Lunch was supposed to go from 12 to 12:30. She's given us from now until 12:45. And then if you aren't done with lunch, you should still come back in here and eat while working because we don't have a lot of time. So she pushed back the end of lunch to 12:45.
Okay.
And I think
Okay, clarification sake, I'm going to hang up now, but I'm going to call back in at 12:45 your time.
correct.
Is that
So we're gonna get
Okay.
food and come back here, right?
Yes.
okay?
Okay.
Super.
Thank you.
Thanks, Kevin.
Thank you.
Johan, will you be
Okay.
joining us
Bye-bye
at
now.
12:45?
12:45, no problem. I'll be early.
Okay, thank you.
Sit down here.
I'm just thinking in that case, the incubators.
Okay, I think we're gonna get started. Mimi is going to do another roll call.
Justice Edmond,
Here.
Toby Rothschild,
Here.
Joyce Raby, Andrew Aruda,
Here.
Simon Boney,
Here.
Tara Bird,
Here.
Judge Wendy Chang, Abhijit Shaban,
Present.
Jean Clausen,
Present.
Johan Drolshagen,
Here.
Margie Estrada, Gloria Gonzalez,
Here.
Bridget Grammy,
Here.
Andrew Kuchera,
Present.
Joanna Mendoza,
Here.
Kevin Moore,
Here.
Heather Morris,
Here.
Daniel Rice,
Present.
Alan Rodriguez,
Here.
Dan Rubens,
Here.
Mark Tuff,
Here.
Angelina Valverde, Joshua Walker.
Here.
Thank you.
All right, thank you all very much. I understand there were some very productive subcommittee meetings, and we're going to go ahead and get started. The way we're going to proceed is I have a chart here that we're just going to go down and we're kind of mix it up. So rather than sticking with one subcommittee being on the hot seat for 4 or 5 recommendations, we'll just bounce it around. So the way we should do it is someone should present a recommendation and we should take a vote on that recommendation. Some of these have already been passed before by the entire committee, but I understand that there are some tweaks to some of them. So I think it doesn't hurt to just go ahead and take another vote on each of the recommendations. And then separately have a very brief presentation about all of the rest of the supporting material, which includes how it relates to the charter, the pros, the cons, any other background material, and we'll take a vote separately on all of the background material after full discussion in case somebody wants to make some changes or suggest some revisions. Okay, everybody understand? Okay, we're going to start with item B1, which is UPLAI. Anybody?
Sure, it's actually UPLAI.
UPLAI is item number B1.
All right, that's Dan and myself. And I think, Mimi, do you have that up on the share screen?
Is your mic on?
That should be now. There we go. Great. And again, our recommendations 1 and 2 have already been approved. If we go down, let's the task force does not recommend defining the practice of law, and I believe we have a red line here. We have tweaked some of the pros, so I'll go through that specifically, just in the interest of time. We added that the safe harbor recommendation provides certainty for those meeting the criteria of the safe harbor. So it's an alternative to defining UPL. We just wanted to clarify that. We also changed the cons in kind of conformity to what Randy had mentioned before. We are adding that the lack of a precise definition of either the practice of law or the unauthorized practice of law, UPL, creates uncertainty to the public and for potential providers. So not only does the lack of a UPL definition for potential providers, either on one side or the other, the practice definition, but it also might have a deleterious effect in terms of the public. So we just want to make that clear. That's it.
Okay, Mimi, can you go back to the top? Please.
And Your Honor, did you want to re-vote on the recommendation or just approving the language below?
Why don't we start with the recommendation? What you're saying is that's already been approved by the committee and you made no changes.
It's also been approved by the task force.
I mean, the task force as
Yes.
a whole. Randy?
If they made no changes, we can stand on the prior vote from
Okay.
April or May and just approve the materials below.
Okay, so then now, the materials below, is there any discussion about the recommendation? Maybe somebody else wants to raise another issue. We've already proved it, let's go on. The materials that are attached, discussion. Joshua, are you moving approval?
I'm moving for approval.
Second.
And it's been seconded. Discussion. Hearing none, we're ready for a vote? Maybe we need to take a roll call?
So the motion is to approve recommendation and report in its entirety.
Yep.
Please.
Is that okay? Okay, cool. Justice Edmond?
I think
Okay,
that
sorry.
typically don't vote.
Andrew Rita?
Abstain.
Simon Boney? Tara Bird?
Yes.
Judge Wendy Chang? Abhijit Sivan?
Yes.
Jean Clausen? Yes. Johan Drolshagen?
Yes.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morse?
Yes.
Joyce Rady? Daniel Rice?
Yes.
Toby Rothschild?
Yes.
Alan Rodriguez?
Yes.
Daniel Rubens?
Yes.
Mark Tuck?
Yes.
Angelina Valverde? And Joshua Walker?
Yes.
Thank you.
Progress. Thank you. Okay, we're going to go now to the Rules Subcommittee and go to item C1. That is adoption of a new comment 1 to Rule of Professional Conduct 1.1. That has already been approved by the entire task force. Are you proposing any revisions to it?
Just on mine, it says B1, which is why I was confused.
The
That's the
subcommittee
subcommittee.
had different letter numbering than the full task force.
So there's been no changes to the prior approval by the task force. There are some pros and cons, which I think we've already discussed. So if there's anything in particular anybody would like for me to address, happy to field any questions. Yes.
And the pros and cons were not originally included in our motion, so that's why it's
Oh, I see.
considerably.
Right.
So we've got how the recommendation relates to the charter, the pros, the cons, and you're not proposing any changes to what's in our materials?
Correct.
Correct.
Okay. Are you moving approval?
I move to approve.
Second?
And I take it that your motion is to move approval of the, do we have to start with just the background?
They,
We can do the whole thing, right?
well, they previously approved the recommendation, so like we did with the first one, we could just be adopting their materials.
Why don't we just adopt everything so we don't have to record both votes?
I think you told Mimi to go ahead and have the first vote be for the whole thing.
Okay.
So
Do the
approval,
whole thing.
so the motion is to approve the recommendation and its report. Okay? Andrew Ruda,
Yes.
Simon Boney,
Yes.
Sarah Bird,
Yes.
Judge Wendy Chang, Abhijit Sivan,
Yes.
Jean Clausen,
Yes.
Johan Droshagen,
Abstain.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morris,
Yes?
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Daniel Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
Okay, and just so everybody's clear, the approval of each of these is simply to take them to the Board of Trustees in order to request that they go out for public comment. That's essentially what each of these votes is. All right, matter number 3 will be ABS MDP, item number D1.
Oh, you mean? The subcommittee met, we talked about this recommendation. We decided it really doesn't make sense to send this out as a recommendation for public comment because all it does is acknowledges the scope of the charter and what we all understand it to be. So it would be better made as background in the ultimate report as opposed to going out for public comment. So with that, I would move that the task force not make this a formal recommendation, but make it as background only.
So Randy, is that clear what the recommendation is?
So the direction to the task force staff is just to adapt what we have and make sure it goes into the report so that the board and anyone else who's reading the report will know that this was part of our consideration. But we're not putting it out there as if someone has to agree with this as a recommendation.
Exactly.
We can do that.
Perfect. Okay, discussion. Everybody understand the motion? Basically, all the materials that are materials relating to D1 will be in the request for public comment just as background, but will not be formally put out as a recommendation or full public comment. Any discussion? Mimi?
Andrew Ruda,
Yes.
Simon Boney,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang, Abhijit Sivan,
Yes.
Jean Clausen,
Yes.
Johan Droshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morris,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuff,
Yes.
Joshua Walker.
Abstain.
Thank you.
Okay, now we're going to skip in the ABS MDP subcommittee to item D4, which is the models being proposed would include individuals and entities working for profit and would not be limited to not-for-profits.
That's me. This recommendation was already approved by the full committee. There's been no changes to the recommendation since that approval. We are not proposing any changes as it pertains to the charter piece or the pros. However, to the cons, we are recommending and didn't take any action yet on removing the word trickle down from the last sentence. And so I guess we would want to first, before we move to approve the package, that we would first want to move to approve the removal of the trickle down word out of the cons section, or open up for any comments.
Okay, is that a motion to remove the word trickle down from the cons?
Correct.
Thank you. Is there a second?
Yes.
Okay. Any discussion? Okay, let's vote just on that and then we'll vote on the whole package.
Andrew Ruda,
Yes.
Simon Bowman,
Yes.
Sarah Bird,
Yes.
Judge Wendy Chang, Abhijit Shaban,
Yes.
Jean Clausen,
Yes.
Johann Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Daniel Rubens,
Yes.
Mark Tuft,
Yes.
Angelina Valverde, and Joshua Walker.
Yes.
Thank you.
All right, so now I'd like to move for approval of the package of the recommendation and its report.
And it's a motion. Is
I'll
it second? Okay, it's been moved and seconded. Any discussion? Mimi?
Andrew Ruda,
Yes.
Simon Bowman,
Yes.
Sarah Bird,
Yes.
Judge Wendy Chang, Abhijit Shaban,
Yes.
Jean Clausen,
Yes.
Johann Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuft,
Yes.
Joshua Walker.
Yes.
Thank you.
Okay, we're on a roll here. The next is going to be item D5 from the ABS MVP group.
That's me. This has to do with the recommendation regarding whereas in traditional practice and law firms perform legal and law-related services under the current regulatory framework with the intention of expanding access to justice through innovation with the use of technology and modifications in relations with non-lawyers. This had been approved previously by the task force, however, the committee is recommending changes to the text of the recommendation as it appears on the screen. Basically, there are two. As changed, the recommendation would read, lawyers in traditional practice and law firms may perform legal and law-related services. The word may has been added before the word perform. And the second change is continuing with that sentence, which reads, under the current regulatory framework, rather than have the words with the intention of expanding, those words would be stricken and substituted with the words, but should strive to expand access to justice through innovation with the use of technology and modifications in relationships with non-lawyers. That is the recommendation of the subcommittee, and I move for the adoption of the recommendation with these changes.
Okay, it's been moved and seconded.
Who seconded? Me.
Any discussion? Okay. So the motion is to approve as amended, as reflected on the board, the recommendation. Mimi, you want to take a vote?
Andrew Ruda,
Yes.
Simon Bowman,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang, Abhijit Shaban,
Yes.
Jean Clausen,
Yes.
Johann Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Daniel Rubens,
Yes.
Mark Tuft,
Yes.
Angelina Valverde, and Joshua Walker.
Yes.
Thank you.
Mark.
The task force, of course, recommends that staff revise the descriptions recommendation in accordance with these changes. And I'm sure they will. That's not a motion, that's just an observation on the radar line. Madam Chair, the next issue would be how the recommendation relates to the charter. Should we vote on that separately?
I think we take all the background materials generally.
At one time, okay, so how the recommendation relates to the charter is spelled out here. There are no changes from what is in the materials. The same is true with respect to the pros and the cons. If there's any questions about those, we can entertain those now. But I would move the adoption of that background material.
There's a second.
I'll second.
Okay, and discussion. Okay, Mimi, I think they're ready for a vote.
Andrew Ruda,
Yes.
Sunny Bowden,
Yes.
Tara Byrne,
Yes.
Judge Wendy Chang, Abhijit Sivan,
Yes.
Jean Clausen,
Yes.
Johan Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes?
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, and Joshua Walker.
Yes.
Thank you.
Okay, we're gonna move on to UPLAI and talk about agenda item B4. Communications under an approved program should receive the same or equivalent protections afforded by the attorney-client privilege and the lawyer's ethical and immediate confidentiality.
So interestingly enough, I think this actually ties into. There we go. So interestingly enough, I think this actually ties into the email that the larger task force got as background material. We do want to provide consumers with the same level of protection ethically that lawyers provide today through the rules of professional conduct. So the idea is to mirror to whatever degree is possible the existing rules. And we made a couple tweaks to the pros and cons, I believe.
Okay, you want to start by moving the recommendation?
Okay. The recommendation has been approved. Yeah, I think that's been approved by the whole.
It says not yet.
No,
Oh,
It
sorry.
is not yet voted.
It was only approved by the subcommittee.
Okay, then I move to approve the recommendation.
Just second.
Okay, it's been moved and seconded. Discussion. Mark?
I find the recommendation confusing in the sense that it reads, communications under the approved program should receive the same or equivalent protections afforded by attorney-client privilege. Attorney-client privilege is a rule of evidence that's found in the Evidence Code 954, and the holder of the privilege is defined in 952. There are other privileges that might be comparable. And I'm thinking specifically of the LRS client privilege, which is a separate privilege in the Evidence Code, it's under 965. If I'm out there reading this recommendation, I'm not clear on what's being proposed. Is it the view of the task force that the program actually receive the same protection afforded by attorney-client privilege, which carries with it a lot of issues, in my view, or something equivalent like the LRS privilege, which is protection for those communications, but is not the attorney-client privilege. So, if I were writing this, or if I were the one that was promoting this, I would recommend a privilege similar to the attorney-client privilege, but not the attorney-client privilege, because it wouldn't fit. So it'd be something more in line with the LRS privilege or something like that. I don't know how to write that, but I just think that the wording is confusing to me, and I think it will be to those who comment on this proposal.
Sure.
I can't find these in my materials. I'm sorry, where should we be looking? B4? I don't know, I don't.
I
main
say-
In the main ADL's agenda, not the subcommittee agenda.
It's page 12 of the full agenda.
I could speak.
Yeah.
Yes, Randy.
Mark, what you just said, I think the latter part was my understanding when the subcommittee was discussing it. That the gist of the recommendation was that if we're gonna go down the path of allowing persons who aren't currently protected by the attorney-client privilege to engage in communications with consumers or clients, and we want those consumers to be candid with the legal advice provider, then there ought to be something evidentiary-wise to protect it, as well as something like the affirmative duty of secrecy under 60680 and confidentiality. So it was really the latter of what you said, that we're not trying to make the round peg of the attorney-client privilege fit the square of non-lawyer delivery. We want to have a recommendation that says, if you're going to do this, you have to create something. The same way they created something for the LRSs for the same reasons, to encourage candid communication.
I presume that's what the committee means, but I would then recommend you take out the word "the same" or. They ought to have equivalent protections, is what you're saying, and I don't disagree with that. But there was some comment made in one of our earlier meetings that there could come a time when artificial intelligence is so advanced that it really takes the place of the lawyer. And I don't want to get into that discussion because we're not there yet, but it seems to me, for purposes of this recommendation, it ought to be an equivalent protection to attorney-client privilege and 60680, not the same.
Yeah, that reflects my understanding from the subcommittee. I think that's a reasonable change, and I'd support that. So I move to remove the same "or" from that recommendation.
All right, so it's a friendly amendment. Joshua, is it
Second.
acceptable to you?
Yeah, as well. I think if there are objections from Abhijit or other members of the subcommittee present, please object. But I think that's a reasonable change. I also think if we're through a miracle able to use and want to use the same, it's probably covered in this too. The second thing I would add is, again, our goal is to provoke discussion, and it's not dispositive the exact manner we're going to be implementing this. So I think it's a good change.
Here.
So it's not clear to me, and my understanding is probably that this is taken along with some of the other recommendations. So approved program refers to something, but it doesn't tell me in this as a standalone what it refers to. So I don't know what an approved program is, and that is kind of confusing because my subcommittee, for example, has each proposal is very standalone. And so I think it would need to be very clear to the public when they're reading something, whether it's meant to be taken in connection with another proposal out there or whether it's completely independent. So either this should be fully contained or it should specifically refer to or describe, direct me to somewhere so I know what an approved program is.
Yeah, so this was one of the things that we were hoping would be embodied with all of these votes, is that an authorization to staff to clarify and harmonize the separate recommendations so that if they refer to things like the subcommittee, it's no longer at the subcommittee level, it's the full task force. And if they refer to the task force's consideration of an entity regulation model with an approved provider who's in a safe harbor, then we would define that up front in the report and we would drop in the pseudonym for that in each of the recommendations so they're all referring to the same thing.
So, I still don't have clarity on what an approved program is. I don't know if this is an approved tech program. I don't know if this is if there's lawyer oversight. Because I guess one issue I would have was, do I want to extend the attorney-client privilege to a good tech product that doesn't have any attorney involvement? And so I think personally I would need more clarification to be able to comment on this.
So our intention is certainly that that this goes along with the sort of the information about how you get to an approved product. And also I just mentioned that we did make a distinction between communications with the provider in general, which, you know, you could have some products that are not law-related services, and those would not be protected. But you would want some sort of protection for the products that are approved and are effectively legal services.
Lori. This is Kevin. Could I make a suggestion?
Sure.
If you go back to number 2, in line 3, where it's talking about technology-driven delivery systems, if you put the phrase legal services between technology-driven and delivery systems, and then refer to use that same term in 4 that says communications between a client and a technology-driven legal services delivery system under an approved program. So you're relating back to number 2.
Yeah, I mean, I think we could use defined terms that may be something we have to do in the cleanup and normalization of all these rules as opposed to.
I think that was
I'm concerned about using the phrase legal service provider, because that's talking about a non-lawyer human being or something like that. Whereas a lot of this stuff you're talking about, isn't it like artificial intelligence, where it's possible in some instances a human being might not be involved?
That's right, yeah. So I would say that's friendly.
So, Kevin, give me the exact language. So communications.
Okay, go back into number 2. Where it says in the 3rd line, and it's talking about certified, registered, approved entities to use technology-driven legal services delivery systems to engage in authorized practice of law activities.
So you would add it.
Just add.
Communications. So you wanted to look something like this?
Communications with.
Communications with.
Well, just to be more specific, communications between a client and the entity.
Yeah, unfortunately, it muddies the language a little bit. It's not every communication with the entity.
Okay. So originally what I said was the technology-driven legal services delivery system.
You want to go back to communications with? Involving.
I think you just changed.
Client communications with, but client communications with state certified or qualified communications.
I think this is clearer and reflects my understanding.
Yeah, and the authorization is there too, because we've got authorized in there. I think that's fine. I don't have an objection. Heather, Abhijit, others?
Yeah, because you're saying it's receiving the employment protection, so if you're sending something that's not privileged, it's not going to be covered. So whether it's a legal communication, versus, having just your general name, like serial number, so I do think it balances out.
Were we removing?
Okay, Dan, you're okay with that language?
Yeah.
And Joshua?
Yes. I move to approve the revised language.
Okay, any further discussion? Lori, sorry.
I
remember.
So maybe this is just a con to throw into this rule, but at first I want to make sure I'm understanding it correctly. I think this rule is suggesting that any of these potential new entities are required to have the same or similar privileged communications, which usually requires a lot more.
Brian,
It's much harder to create a secure platform for communications than it is to not. And so one of my concerns with this rule is I can foresee a lot of ways clients would be willing and very okay with waiving privilege if it meant a lower cost of the service itself. So does this rule require any of these new entities then to maintain that level of privilege, or does it allow the client to waive that privilege? And if it doesn't, then I would suggest that's a con to this particular rule.
So we, if I can address that initially, we talked about this at great length. And I remember your comments at the last several meetings actually, and having been a paralegal and outside the profession as well, I appreciate them. Our view was that we have to preserve the confidentiality to a great extent. The privilege itself is held by the client anyway, so there's more control. But waivability should not be easy at all. So we don't think you can go and do a click of terms of use and then forever waive all of your rights. We think that like medical information, legal information is a certain amount of thing, but one of the cons we have Mimi, I don't know if you can go to the cons here, are, I mean, I don't know if they're direct quotes, but they're very much, we're very much concerned about raising the cost of doing business. And we're profoundly concerned about that. We did view this as a legal consumer protection issue that's really, that we have to be careful of.
Okay, I think I just wanted to address that as a con then. I think it's already.
So, and then just one more note on that. So we talked about the security and confidentiality and procedures around that in another recommendation. This is really just the sort of the concept around privilege, not the mechanism to deploy that technologically.
Just so you guys know, previously in your materials, there were no cons listed. These are three things that came up at this meeting. So if you didn't get a copy of it, I don't know if they passed all copies, but you should probably review what's on the screen before you vote to approve the report part.
Yeah, we did add all these as well. Yes.
I just looked, my page says none.
Yeah.
Hence the hand.
Revisit it.
Yeah, so I'll briefly review these cons. So, like you mentioned, granting this privilege does incur some cost. The second point there is essentially looking at that cost to the overall administration of justice. The first one is looking at that cost to the provider itself. And then the third point is really more about, like, we don't know if this is even going to be respected in other jurisdictions at the federal level, for example. As a technology provider, I could get a subpoena from the feds, and I may not be able to protect my customers in federal court. That may happen. That's a whole unknown area of law. To litigate that, to go to federal court, imposes costs on the provider, and of course, that provides uncertainty for the client as well.
Mark, are you going to make a comment about something up on the screen?
I am.
Okay.
I can wait.
Thank you. Let's take a vote on the recommendation originally and then move into the background material. So is there any further discussion about the recommendation itself as amended, as reflected on the screen? Okay, Mimi?
All right, Andrew Arruda,
Abstain.
Simon Boney,
Yes.
Tara Bird. Yes. Judge Wendy Chang, Abhijit Chavan,
Yes.
Jean Clausen. Yes. Johan Droshagen,
No.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Ellen Rodriguez,
Abstain.
Dan Rubens,
Yes.
Mark Tuft,
Abstain.
Angelina Valverde, and Joshua Walker.
Yes.
Thank you.
Mark?
My
My comment goes to the con section. I think just picking up the point that's been discussed here, it should be included to the public, and that is that there could be approved legal services delivery systems involving non-lawyers in which there is no expectation of confidentiality or privilege. And you are imposing a restriction on that. We've heard discussions from Professor Sandeverd and others that there are things that can be done that would constitute the practice of law currently that may be permitted, that the consumer has no expectation of confidentiality or privilege at all. So I think in the con section, that should at least be mentioned as a possible con, as making this overly restrictive for all the variables that are out there.
Yeah, thank you, and I agree, and from other nods in the room, I think others agree as well.
Yeah, again, I want to reiterate that this is the recommendation is to open the discussion of the implementation. When we get down to the brass tacks, I think we have to be much more comprehensive and analytic about exactly how these things are going to be implemented, what classes of data may or may not be included. Our goal was to set a theme, not to resolve on the exact method of implementation in terms of the transcription of the ethical rules and the privilege.
Yeah, I mean, there's what, a couple hundred or more years of tradition and rules and such that establish privilege. So we're not gonna fix it right away, but we want to, yeah, again, bring to the floor that that this should be something that consumers at baseline, if they're receiving a legal service, should expect to receive, the same sort of thing.
And it's not our intention to expand or contract these concepts as applied to this particular technologically mediated instance. It's our goal to give due protections, but not to overprotect. So again, I think we're very sensitive to that question, that comment.
Just so that we've got a clear record, Daniel, have you moved the approval of the background information that we're discussing?
He hasn't yet.
Not yet, no.
Would you like to?
I would love to.
Okay.
So moved.
Joshua?
I'll second.
Okay. So it's been moved and seconded. Discussion, Lori.
And I'm just sort of clarifying, the idea really is to help these potential entities that may be certified by some regulation, something that we're still going to figure out down the road, that those people would, we're trying to allow those entities to create the same type of privilege, but it's not necessarily, the idea is in the real implementation is still to give control of waiver of that privilege to the consumer, correct?
Yes, I would agree with that.
Yeah, and there are constraints on how it can be waived. It's not going to be like Facebook, Cambridge Analytica.
It's not going to be in the terms of agreement where people are just, click here, that you agree to it. It's got to be some way that it's explained to people, because a lot of the people who are going to be utilizing this type of technology might not have the sophistication to really know and understand what privilege is. So it's going to have to be something that we expressly explain to them before they can waive, that individual can waive that
Would it
privilege.
follow the same obligations that lawyers have in terms of getting waivers?
Yes.
We're not
That would
suggesting
be
you're
the
going to
intent.
impose new ways.
No.
It won't be any more burdensome than
No.
what lawyers have to go through at this point. Okay.
No, it's basically saying that if you're choosing to not go to a lawyer, walk into a lawyer's office and write a check and hire a lawyer, but you're going to go utilize this technology, that you as a consumer are going to have an equivalent protection if you go to the technology versus going to the lawyer. That you shouldn't, we should not be putting the people of California in a different position, saying that if you use technology, you're not going to get the same protections that you would if you went to a lawyer. So we
Unless
wanna
they
make sure.
choose to waive
Unless they
this.
choose to.
Correct.
That's right.
Well, but you would choose to waive that with a lawyer as well. So it's basically saying we're going to transfer that to the technology as well. We don't want the consumers to lose that.
The reason we didn't say there has to be identity in terms of how this is carried out is there may be situations where you want a technology provider to have privileged information from two parties. Again, not recommending this, but it is possible. Certainly we can contemplate a situation in which a technology provider has privileged data from two different parties,
but they wouldn't be able to use the information of one party against the other that's also in their system unless all kinds of things have happened, right? So we want to make sure there's flexibility in how we implement, but to preserve the same equivalence.
Further discussion? Bridget?
I just wanted to make sure, there we go. I just wanted to make sure that the last bullet that we just added reflects Mark's concerns, because I thought I heard you say more than that, Mark, as far as that it may be overly restrictive, or do you think that covers it? I just wanted to make sure.
No, that doesn't capture my point.
Give me language.
I thought you were saying you were concerned that it may, it
there
may
may-
apply to situations where confidentiality wouldn't have been expected in the first place, but it may end up becoming more restrictive than necessary.
Yes, there may be delivery systems that are authorized that don't have expectations of confidentiality or privilege, and that if literally this recommendation could be overly restrictive on permissible delivery systems.
Yes, I think the first part is right, and then it would just be, you just need to add a comma to the end.
Should we note for the record that it sounds like you and Lori agree?
You're always on top of things.
Don't worry, it's early in the meeting, we got plenty of time.
So, Mark, what are you proposing? We add to the end of this or in place of this?
And that the recommendation may be overly restrictive, period.
I think you want to get rid of the word that. If the technology providers and non-lawyer, the consumer may have no expectation of coverage, and the recommendation may be overly restrictive.
I think that's captures it.
Just a little nit on my part. So the way this reads right now, the consumer may have no expectation of confidentiality. Just as a layperson, that's like, oh, really? I don't get any confidentiality. If you sort of are reading over that quickly, it I don't know. I'd slow that sentence down a little bit and say maybe like the consumer may be able to waive their expectation of confidentiality or something like that. Just so that it's clear that there is an expectation of confidentiality by default, but they can waive that in certain situations. I mean, the word may is doing a lot of work there.
Okay, I'm not trying to take away from your point. It depends on the program. There may be certain programs that are authorized for which there are no expectations of confidentiality.
Yeah.
Even in the minds of most consumers. We just don't want to preclude that. That's my point.
Totally agree.
Is that not covered by the equivalence? When we mentioned that it's the equivalent, the equivalency at the top, and when you're looking
No,
at
I'm
the
agreeing with
recommendation?
that the sentence, if the technology provider is a non-lawyer, the consumer may have no expectation of confidentiality. That's not getting at my point at all.
No.
I agree with you. That doesn't follow.
No, it doesn't, because I would say anybody who's coming to this,
Yeah.
I'm looking at a very unsophisticated consumer coming to this, and they're coming to a product, and they're going to automatically assume that there is a level of confidentiality,
should.
and that's what we want to do, is say, where in the equivalency, if you went to a lawyer, there is confidentiality, we want to create a way that we would carry that confidentiality over to this product. However, if there is something that you're doing that with a regular breathing lawyer is not going to have a confidentiality, there will be no confidentiality. We're not creating a new confidentiality with the product.
Right. So how do we say that?
The baseline for me is that there are some programs for which there will be clearly an expectation of confidentiality. There may be some authorized programs for which there may not be an expectation of confidentiality. That's all I'm trying to say. It depends on the nature of the authorized program.
Yes.
So in the background material, in the more voluminous sort of several page background on this, we do go into some of those kinds of scenarios where essentially on a case-by-case basis, the sort of expert panel of reviewers would be able to approve a program or a provider or whatever delivering a service that doesn't provide that confidentiality. And the baseline is that no, you need to have that confidentiality, but they can waive that on a case-by-case basis.
Right. But I think as a con, it's fair.
Yeah, as a con, yeah, absolutely. Just to say there's more detail elsewhere.
The change I would make, I guess, is to say the recommendation may be overly restrictive, depending upon the particular, I'm trying to pick up Kevin's language now, legal services delivery system, whether there is or should be an expectation of confidentiality or privilege. Or whether there will be a reasonable expectation of confidentiality or privilege. So really, it depends on what we're authorizing in terms of legal services delivery systems, which can be very broad.
Right.
Does that get closer to?
Sounds good to me.
Between system and weather. Recommendation may be removed depending on the particular services delivery system and whether there is or should be.
And I think that's an important point to include in there as well. It's definitely stronger with that.
That's good.
That good, Mark?
Yes.
Daniel and Joshua, okay with you?
Yes, and are we just voting on the sort of the change at the end now?
No, I think we
all
vote
four, the
cons.
addition of all four cons.
Okay.
So I move to add all four cons in section B.
Yeah, second.
So the motion is to approve the report as amended.
Can we throw it all together and say all the background materials as amended?
Yes. Yes.
Okay. Further discussion? Okay, Mimi, I think we're ready for a vote.
Which one?
That, we can make non-substantive
Yes.
grammatical changes, thank you.
Yes.
Okay, Andrew Ruda,
Abstain. Articles, things like that.
Sam Bowden,
Proper English.
Simon,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang, Abhijit Shaban,
Yes.
Jean Clausen.
Yes.
Johan Droshagen,
No.
Margie Estrada, Lori Gonzalez,
Yes.
Reggie Grammy,
Yes.
Andrew Kutera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse. Yes. Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Abstain.
Dan Rubens,
Yes.
Mark Tuft,
Abstain.
Angelina Valverde, and Joshua Walker.
Yes.
Okay, we're gonna move on to agenda item C4, which is the Rules and Ethics Opinions Subcommittee. Adoption of proposed Rule 5.7, concept of adding a new rule on law-related services.
And that is from the Rules Ethics Committee Subcommittee, and we have Kevin hopefully on the phone, Toby here, and yours truly in the room to present it. Where this comes from is the fact that the Rules Subcommittee focused on the main rule that was identified in the Henderson report and what has been called out as the primary obstacle, so to speak, to collaboration with non-lawyer providers, technology companies or individuals in innovating new delivery systems. But there are other rules that could be considered that also have the same effect, perhaps not to the same degree as taking on the fee sharing or free splitting rule. And two in particular were part of the subcommittee's deliberations. One is 5.7, the law-related services rules, and the other were the advertising and solicitation rules, which are our second recommendation. But in both cases, we wanted to be able to include in the task force's tentative report and recommendations the concept of considering these changes to the California rules so that when they come back for public comment, if we do look at the package of the recommendations and we see that these more modest changes nevertheless are worthy of board adoption and implementation, then we are positioned to do that. We would have received public comment and we could adapt these essentially ABA model rules to fit the California rules and include them in the final report and recommendation. So the first one is the law-related services rule, a rule we've never had in California, a rule that is not, I believe, adopted by a majority of the ABA jurisdictions, but is a rule that could facilitate some delivery systems, some access and innovation, because it actually permits, it clarifies the lawyer's obligation to comply with the rules of professional conduct when providing something that is less than a practice of law service, a law-related service. It offers a definition of law-related services, and again clarifies to what extent the lawyer might be bound by things such as conflicts of interest or the duty of competent representation, etc. The Rules Revision Commission did not recommend it, but again, if we are going to be able to look at this later, we at least have to put it out for public comment as a concept that the task force or the board should consider adding a rule like 5.7, the California version of 5.7, to the California rules. And so we have developed materials, but the vote that was taken at the subcommittee level was to authorize Professor Moore and staff to work together to put it into the final template, since this was really the first discussion in earnest about this proposal. Toby, Kevin, do you have anything to add?
I would just say that in reviewing what's in your packet, that there's a lot of stuff in here that doesn't need to be in the report we're going to do. So a lot of the historical information and some of the other stuff that's in here will get deleted as the item is reduced down to fit into the template and say. So the purpose of it is just saying, yeah, we ought to look at this without having done drafting or wordsmithing or anything about it, just that this is a worthwhile thing to consider. Also worth noting that there is out for comment now and COPRAC ethics opinions specifically on this. And so that's part of the consideration is there's other ways of getting the word out about what we can do and can't do, like an ethics opinion that's out for public comment. And should we be looking at more than that and actually having a Rule 5.7?
Kevin?
Yeah, I have nothing further. I just emphasize this is primarily a request for information and opinions from the public and lawyers in California.
So, let me see if I understand what we're doing. The recommendation then that would go out for public comment would be something like consider adopting a California version of Model Rule 5.7?
That's precisely.
Is there a motion?
I'll move.
And a second?
Second.
Okay, discussion. Mark?
A couple of observations. The first one is that this recommendation really goes hand in hand with the recommendation of the ABS MVP subcommittee on D5. And if you read the pros in favor of that recommendation includes the observation that there is a very robust alternative legal services providers activities going on right now, which is a classic 5.7 type of activity where law firms are investing millions of dollars in entities with technology experts in our presenting and developing and using these various forms of artificial intelligence and their technologies right now and really in the future. So this is an important recommendation, I think, in the menu of various ways of addressing technology and practice of law. The problem is, I wish that we had more to offer in the sense that if I'm going to comment on this proposal, I'm going to wonder what we're talking about. Are we talking about just adopting 5.7 like the ABA has, which, by the way, was done without regard to all this modern technology and the need to have more efficient services and more closely aligned work with lawyers and non-lawyers? That rule was not drafted with that in mind. Or are we talking about a modified 5.7 that actually allows for greater associations and relationships with non-lawyers in this setting, which I would be very much in favor of, and which is going on right now all over the country. Thirdly, and my last point is, I would like to see COPRAC hold up on this draft opinion because it was also drafted without the benefit of a lot of our discussions and the ways that rule could be interpreted and applied to meet the charter that we have. So I'm very much in favor of this. I just wish we had something more to present to the audience that we're reaching out to in terms of it, because we have a lot of questions. But 5.7 really goes hand in glove a lot of what we've been talking about this whole time. I'm very much in favor of the concept. I just wish we had a rule.
Joanna?
I'm not comfortable putting out a recommendation as vague as this without actually having a proposal. It's just, the comments we get are not necessarily going to be helpful. It could be all over the place. And until we're ready to actually present a rule, I don't think we should be doing this. And Crispin Passmore provided some public comment on this and had some concerns as well. I'm not sure if everybody read that. Bridget forwarded to Adels, but I just think it's premature. I think we need to decide on our other recommendations,
Okay.
and to the extent rules need to be changed.
This is Kevin. Can I say something?
Sure.
I'd just like a clarification, perhaps from our Office of General Counsel. If we don't mention or have something in this preliminary report dealing with Rule 5.7, can we still go back to 5.7 after we get back public comment, or do we have to have at least a placeholder? That's my concern, is if we don't do anything about 5.7 now.
Randy?
So because we're talking about concept proposals framed as policy decisions as opposed to promulgating or recommending the promulgation of an actual rule, I don't think it triggers the State Bar's ordinary compliance to align itself with the Administrative Procedures Act, where you have to have a public comment period before you can actually adopt a change in the law within the jurisdiction of the lawmaker. And so this would be a rule that would be adopted by the board, approved by the Supreme Court, and so we typically put those out for public comment. But we don't have a rule, we're not offering a rule. I wouldn't say this is completely ambiguous, because what this is the Rules Revision Commission made a recommendation to the board, and it was included as a concept considered but not recommended for adoption. I think it was attachment K that went into this filing to the Supreme Court, and neither the board nor the Supreme Court saw any reason to reverse the commission and say, we want a rule. Neither regulating body came back and challenged that commission recommendation. So this is really an invitation for reconsideration. The task force is saying, we know we just have a rule revision. We know that we didn't include 5.7. Neither the board nor the Supreme Court asked for 5.7, but we would like to reconsider it. We want to put it back on the table in the specific context of access to justice and innovative delivery of legal services. And we want to consider this vehicle, 5.7, as one way to have a rule that could facilitate that. We don't know what the specific terms are. there's a lot of law and case law in California that's different from the terms of 5.7, and I think that's why the opinion is so long. But it really is just saying we would like the state bar to reconsider a Rule 5.7. You recently considered it, you did not go forward with it, but this task force thinks it's worthy, it merits reconsideration, and as a first step, we'd like to get some public comment on it and continue the consideration after we consider the public comment. As a technical matter, if we're still after the public comment period and we don't put anything out, I think we could still talk about it because we're not promoting or advocating for a specific rule. We're just asking the state bar to reopen the consideration of it. And so, Kevin, to be direct to your question, since we don't have a rule on the table, I think we could talk about it later, even if we don't include anything. But what I'm worried is that we're missing an opportunity. I mean, we're going to be right there at the ABA convention with a public hearing, and if we say we recently, quote unquote, rejected 5.7, but we think it could be considered anew in this context, give us input, I think that would be a good thing to pursue. And we can only do that really if we have it as part of our report.
Joanna, just use the word reconsider instead of adopt. Address your concern.
My problem is the phrase "some version."
Oh, I know, I just put it in there because this is just not for sure language, it's just, it sounds like you guys want to reconsider some
I don't know
concept
what we
of.
want to reconsider. Do we want to reconsider whatever that proposed rule was that the commission had put forward? If so, we should ask that be the rule that be reconsidered. Are we looking at just ABA Model Rule 5.7? But the term "some version" is just so vague. I mean, who knows what, I'm not sure what you comment on.
Andrew.
It may be difficult to do at this hour, but if there was consensus around the table, the recommendation could be consider adoption of a version of ABA Model Rule 5.7, which expands the definition of quote-unquote law-related services, or however we wish to amend the rule to make it California-specific, and in light of the many unique approaches that this group is taking, I'm just going to have to be succinct, but this is to get greater specificity of our recommendation. And I lost my train of thought, but somewhere to
include technology.
Somewhere to specify. So it is a law pattern. It would be a rule pattern after 5.7. It would be unique because we would be defining law-related services in a sui generis fashion, something no other jurisdiction has done. And yes, it's not specific, but I think that would garner some public interest.
So could the recommendation be to recommend or explore the adoption of a rule similar to ABA Model Rule 5.7, but which recognizes and accommodates the unique features of California case law? Something along those lines.
I think it also
because we do have the rich case law.
I think it also needs to include technology, you know. I mean, that sentence or the first sentence.
I was going to suggest, rather than that whole thing, just a rule similar to 5.7, consistent with California law, with existing California law.
And that includes technology.
Incorporates the use of technology consistent with California.
Mark, I think we're making progress on it, but I think you should simply say that the recommendation is to consider a version of ABA Model Rule 5.7 that fosters investment and development in technology-driven delivery systems consistent with California case law.
Boom.
Yep.
Consider a version of ABA Model Rule.
I think you have to say it again.
Yeah.
Okay, I'll play
Assuming you can.
Recommend adoption of a version of ABA Model Rule 5.7, which that fosters investment and development in technology-driven delivery systems consistent with California.
And fosters investment and development?
Yes. Because that's what ALSPs are. That's what's going on. That's millions of dollars being spent by lawyers and law firms with non-lawyers in the development of this technology. That's 5.7.
Okay, can you keep going for her, please? That fosters investment and development.
Oh, I'm sorry. Okay, fosters investment and development in technology-driven delivery systems consistent with California law. Well, I take out the consistent with California law. I don't think we need that. I don't think we need that, because you may want to change California law.
Yeah, I would say to take that out.
Yeah, I agree.
I guess consider adoption of.
Yeah, I would.
I mean, if you want to expand on it, it's really common. You could build on that and say, you know, through with non-lawyers or with non-lawyer entities or something like that. I don't think you have to go that far, but the point is 5.7 is law-related services that involves non-lawyers and development of ancillary business practices and services. That's what it's all about.
And presumably some of this could be incorporated in whatever the background materials are that are going to be developed by Professor Moore and staff. Jean?
I would just ask to recommend that in the background materials that the actual rule 5.7 is included, so that if it's going for public comment, I
Yeah, the
understand.
subcommittee included the version of the ABA model 5.7.
Okay. I think this was, I have no idea what motion that was. Was this Mark's motion?
I'll move that. No.
I just, there was a motion and a second, and I just want to make sure that that's a friendly amendment.
Absolutely.
Okay, so that's the motion we're talking about now. Further discussion? Yes, Bridget?
Do you think we should add to the end, just to address Mark's point, that may involve non-lawyers at the very end of that sentence?
Oh, be clear like that. You want to make that clear, that involves, you know, non-lawyer.
Could I make one suggestion at the end of that?
Sure.
It's not just technology-driven delivery systems, but technology-driven delivery systems that increase access to justice.
Perfect.
Or increased access.
But do we want to bring up non-lawyers or not?
Well, why are we limiting that to increasing access to justice? Because if there's going to be a change in Rule 5.7, that could impact other areas of delivering technology. It won't be limited to just access to justice. So I would have a concern with that, because we would want we want to see innovation and technology out there, and it's not just going to be limited to access to justice.
I agree.
Okay.
But I do like the
But
addition that it may include non-attorneys.
Isn't that our charter?
That might be our charter, but we wouldn't want to, if we're going to recommend that there be a change, you know, in the model rules in California, that might also change the laws in California. I would not be comfortable saying that I only want it limited to technology that increases access to justice, because you know, everyone out there who's utilizing legal services needs to have the best delivery of legal services, and a lot of times that is going to include, it is evolving to include technology-driven solutions.
While increasing access to justice might be the result,
yes,
as written in this rule, it suggests that we would be writing a model rule that would be limited to that, and I don't think that's what makes sense.
To pick up on the non-lawyer, you could add the phrase at the end, including in association with non-lawyer and non-lawyer entities. Including associations with, if you want, just short bit.
Further discussion?
I don't think that's exactly right, is it? Including associations with.
That's shorter.
It's on the fly, but.
Okay, further discussion. Okay.
This particular rule is focusing on law-related services,
Yes.
delivery of law-related services as opposed to legal services.
Although, just so we're clear, a modified 5.7 could push that envelope. I mean, what is a legal services versus a non-law related service? You get to include that in your analysis. It doesn't, I wouldn't want to
By
try
defining what
5.7.
law-related services are through the rule.
Right, I wouldn't want to just have a plain old vanilla 5.7 like the ABA has, because it doesn't deal with the issues we're talking about. I want to have it a little more expansive to allow for more innovation and association with non-lawyers.
Further discussion? Okay, we're voting on the recommendation as it appears on the board meeting.
So it's okay.
And what we're doing is, again, we're voting to send it out for public comment.
Right. And Toby, this is a friendly amendment that you're okay with? Okay, just checking. All right.
Right.
Andrew Ruda,
Yes.
Simon Boney,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang, Abhijit Shaban,
Abstain.
Jim Clausen,
Yes.
Johan Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, and Joshua Walker.
Yes.
Thank you.
Okay, as I understand it, the suggestion was that Professor Moore and staff get together to use portions of these materials and that are appropriate in order to support that recommendation, including coming up with their reasons why it's related to the charter and the pros and cons. Should we take a motion on that?
I would move to give them authority to make the changes necessary.
Second.
Okay, it's been moved and seconded. Any discussion? Mimi?
Just so some people, we can't.
Can't.
We have phone people.
Read the motion.
Joanna Mendoza moved, Toby seconded to authorize staff to draft the necessary portions currently necessary.
Okay, sorry. Andrew Ruda,
Yes.
Simon Boney,
Yes.
Tara Bird,
Yes.
Abhijit Shaban,
Yes.
Jean Clausen,
Yes.
Johan Drolshagen,
Yes.
Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuff,
Yes.
Joshua Walker.
Yes.
Okay, thank you very much. We're now going to move on, still with the Rules and Ethics Opinions Subcommittee to C5. Adoption of amendments to California Rules 7.1 to 7.5 on advertising.
Start that.
So, sort of ditto, the same thing we said about 5.7. We don't want to miss the opportunity to consider later the amendments that the ABA made to the advertising rules last August. Those all happened before the Rules Revision Commission completed its work, and so it has yet to be considered in California. One of the elements in those changes is a specific abrogation of a restriction on solicitation that actually might have an impact on online delivery systems. And so one of the new things that we picked up from the ABA model rules operative November last year was that a direct contact solicitation, which is prohibited, includes real-time electronic communications. The ABA changed that with their rules operative last year in August. It was a study first done by April and then picked up by ABA. And I don't think majority of states have picked it up yet in terms of adopting it, but some have. And we would be essentially reconsidering the rules that were recently adopted. And the first time was this past November. The first time we abandoned what is the longstanding 1-400 approach to advertising solicitation, and we picked up an ABA series 7.1 through 7.5 version of advertising rules. And so, brand spanking new rules, similar to the structure of the ABA rules, and we're going to revisit them and see if we can't bring them in line with the latest version of those rules. And it does, on the surface, look like major surgery, because the ABA rules have gone from 7.1, 7.2, 7.3, 7.4 to 7.5 to being only Rule 7.1 through 7.3. But what was really at work there in part was that they were compressing some of the standards. And so there was a separate rule on holding out a legal specialization and designations, and they have combined that with their other advertising communication rules. But they did, again, get rid of the restriction on real-time electronic communications, and that is right in the wheelhouse of what this task force is looking at in terms of changes to rules that could facilitate new online delivery systems. If you're talking about online legal matching services, you're talking about online lead generation, these are things that happen almost exclusively by electronic communication. And so the current advertising rules arguably put up a roadblock in terms of potentially characterizing that as direct contact solicitation. The revised ABA model rules would not. And so we will not be putting out an exact version or illustration draft or any draft of these changes. We would be putting out the ABA model rules as they currently stand and inviting comment on the extent to which, if any of these changes ought to be considered for changing our recently adopted new advertising rules.
I think one of the additional things that we talked about was the fact that the ABA's version was based on work done by April under Mark's outstanding leadership, which was even more narrow, even broader, if you will. It went much farther than the ABA did. And so we ought to include that in the discussion, is that we're looking both at the ABA, what the ABA did with it after their long process, and what April did after their long process, to see if any of that is useful in how we deal with the 7 series.
Can I, the recommendation that we just provided for the other rule, can we essentially do the same thing here? That we're adopting a version of this range of rules to foster innovation and do it essentially the same way and then get comments.
Yeah, I think the key distinction would be to also include language around the April background as well, not limited just to the ABA material.
And to be clear, you could throw in there the rules and proposals of other states. Like Washington has its own versions which improve a little bit on ours, and is pending approval before their Supreme Court. So you include looking at that as well. In terms of descriptions, it deals with more than just the delivery of legal services. It deals with the marketing and communication about legal services, and that's a very big part of our charter, is how do consumers get access to information about the availability of legal services through these modern means of technology. And it also has a much more modernized provision with respect to referrals and things of that nature. So it really is very innovative in that regard. So all that should be described in your presentation of this, but it's very important we include this.
But Mark, what about the recommendation itself as it's worded? Would you add something to that or change something?
Yeah, it's definitely a change.
Yeah, it's more than just fostering investment and development in technology and the delivery of legal services. It has to add to that the marketing and communication regarding the availability of legal services should be added to that, because that's what these advertising rules do.
And delivery.
Okay, could you also make a note that we're not adopting it, we're revising the current California rules?
So change the whole thing. Consider revising California rules 7.1 7.5 in consideration of, we can list the 3 things that have been mentioned: the new model rules, the April report, and rules recently adopted in other jurisdictions.
It's April 1st, there's two reports for
Other state, rules of other states.
Rules adopted in other jurisdictions.
Adopted.
So it's that part that I think is broader and goes to the marketing, communication, concerning your availability.
So what do you want to do? You want to keep it or take it out? Leave it.
Well, get rid of the Foster's assessment.
I would say that improve the communication regarding the availability of legal services through technology and client development tools.
Sorry. Regarding availability of legal services?
In technology, using technology, no, of legal services. What was the last phrase?
Using technology and electronic client development tools.
Client development tools?
I think technology is good enough.
Consider revising
Okay, it says, consider revising California Rules 7.1 through 7.5 in consideration of 1, ABA Model Rules 7.1 through 7.3, April reports, and rules adopted in other jurisdictions that improve communication regarding availability of legal services using technology. Andrew, did you have a question, comment?
No, I was just scratching.
Okay.
From a grammatical point of view, that there ought to be punctuation between jurisdictions and that improve, so it's not that only the things in other jurisdictions that improve.
Well, or you could move that improved communication up to, right after 7.5.
Yeah.
And have that come before, in consideration of those three things. Consider revising California rules of professional conduct to improve.
Two.
There we go.
Technology.
Mark, is there a year attached to the April report so we can be specific?
Yeah,
Was that the
there's,
2017 April reports on lawyer advertising and solicitation?
I think it's in the folder.
Yeah, the first report was June 2015, and the second one was in 2016. May have the month wrong, but there's 2015, 2016 reports.
I think that's close enough.
Okay, has it been a motion yet? No.
I'll move.
Andrew? Oh, Kevin, did you have something to add?
I'm sorry?
Did you want to add something?
No.
Okay, Toby has moved. Is there a second?
Second.
Okay, it's been moved and seconded. The recommendation is on the board. Discussion? Mimi, I think we're ready for a vote.
Okay. Andrew Rita?
Yes.
Simon Bowman?
Yes.
Tara Bird?
Yes.
Judge Wendy Chang? Abhijit Siobhan?
Abstain.
Jean Clausen?
Yes.
Johan Drolshagen?
Yes.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morse?
Yes.
Joyce Raby? Daniel Rice?
Yes.
Toby Rothschild?
Yes.
Alan Rodriguez?
Yes.
Daniel Rubens?
Yes.
Mark Tuff?
Yes.
Angelina Valverde and Joshua Walker.
Yes.
Thank you.
And everybody comfortable adopting the same general direction to the staff as we did with the prior recommendation, that is, we authorize them to put together the supporting materials?
I would so move.
Second.
It's been moved and seconded. Any discussion? Mimi, I think we're ready for a vote.
Andrew Rita?
Yes.
Simon Bowman?
Yes.
Tara Bird?
Yes.
Judge Wendy Chang? Abhijit Siobhan?
Yes.
Jean Clausen?
Yes.
Johan Drolshagen?
Yes.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morse?
Yes.
Joyce Raby? Daniel Rice?
Yes.
Toby Rothschild?
Yes.
Alan Rodriguez?
Yes.
Daniel Rubens?
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
Okay, thank you very much. There was in your materials, marked as agenda item E1, a general recommendation that the implementation body, whoever that is, be assigned to identify metrics designed to assess the impact of the ATIL's reforms on the justice gap in California. That had been suggested initially by Joyce, I think, and in the materials. Toby, do you want to address that?
Sure. So we have these great things we're doing, and the goal of them is to advance access to justice. But unless we do measurement of some sort to know what the current situation is and how these impacted over time, we don't know whether what we've done was, was worthwhile or not. So we really are suggesting that the implementation body, whoever picks this up from us next year, assess both the baseline and plan for effective evaluation of the changes that we're making, knowing that no evaluation is going to be perfect because there's so many other factors. You can't be sure that this factor is what caused the increases, but there are systems out there to attempt to make that kind of thing. Joyce suggested one, there's a lengthy piece in the package about, but I think what we're being asked to suggest, to recommend to the board for their charge to the new group, is that evaluation be a significant part of their work, including both baseline evaluation and ongoing evaluation. And that include the possibility that when the evaluation is done, as it goes forward, that if we see things need to be tweaked or dropped or changed, that be possible. In a regulatory environment, that's not easy to do necessarily. You're going to change the regulations along the way. But if we're not going to evaluate it and allow for changes after the evaluation, then no point evaluating at all. Just let it be, and maybe it works and maybe it doesn't.
Joanna.
I agree we need to maintain some type of metrics and data. I'm a little concerned with the way it's phrased because it's my understanding we're going to have another body that will determine exactly what rules need to be implemented. That if that's created by the Board of Trustees, it will be a very limited time, very limited project. And you're talking about something that's going to go on for a very long time. I think it should be the regulatory body that takes on any adoption of these changes needs to be doing it. They can assign it out accordingly, but it shouldn't be that whatever new implementation task force is created next year to do it and be ongoing for who knows how long. We need to make it bigger than that. Make it the regulatory body. We won't say the state bar or the Board of Trustees, but the regulatory body needs to do this.
Lori, did you want to address that, Toby?
Yeah, I guess my sense would be that the implementation body needs to include in its report back that, assuming there's going to be a regulatory body, that's not decided yet. Maybe that we decide that the board ultimately decides not to regulate or not to make these kind of changes. But assuming there's going to be some regulation of these new entities and of the new relationships, that the implementation body be sure to include in its creation, its description of the new body, of the regulatory body, that there be effective pre and post evaluation and all the other stuff.
Lori, before I get to your comment, Toby, are you making this motion?
Yes.
Is there a second?
Second.
Okay, now, Lori, discussion.
I'm going to echo a little bit, piggyback a little bit off Joanna. First, I do think that being careful who is going to decide the metrics is important. And I'm not sure who's going to be part of this implementation body yet, but it should be a diverse group, just like this group is, or maybe not just like, but it should be way diverse. If you're talking about data and statistics, because we've had a lot of discussion about data and statistics in this group, and we all seem to have a different way of dealing with those. On the flip side, as a con to this idea, for me, I'm a big fan of data, so I think we should track data. I think it's important and necessary. But what we're proposing, and depending on what actually comes out of this task force, some of these changes are heavily regulated, which is exactly the opposite of how you innovate. And so the more we are regulated in our solutions, the less likely the data will show how that created innovation. It could actually do the opposite, where it actually skews the data in a way that says, hey, these ideas are bad for innovation, but it may not be the idea itself or the concept, but maybe it was in how it was implemented. So I think I just kind of want to throw out both those concerns, and I think as long as those are being addressed or we're mindful of those, I'm never going to say let's not track the data.
Tara.
Yeah, I agree with Lori. My concern is that the changes that might be implemented, let's say there are very small changes that don't make much change because they took such a baby step that it didn't actually create a shift, and that could be used to make an argument that, well, we tried this piece and nothing changed, and therefore nothing should change. So I guess that's really the concern. That said, again, I agree with Lori. I don't see how we cannot assess it. But it just seems like it's just sort of scary to say, well, let's make a numbers decision here when we don't have any numbers here.
Mark, and then Joshua, and then Alan.
Yeah, I read the recommendation as asking that the implementation body be assigned to identify metrics designed to assess the impact of programs that we don't know what they're going to be yet. They're not that it's going to happen or that you must do it or that it will be effective or not. It's just saying that the implementation committee should be, and you can change the wording, that they should consider the availability of metrics designed to adequately and assess these programs. That's all it's saying to me. It's not mandatory. It's just they should take that into account to determine whether any feedback or data can be developed on the utility of these programs. I don't think that's harmful at all.
Can we just say upon implementation, metrics be designed, and then it doesn't identify?
I had some word suggestions on that.
Okay.
To Joanna's earlier point and this new point, I think if the implementation body can, identify, develop, and/or commission objective and diverse methods, metrics, and empirical data sources, something of that kind, right? So it's tasked with at least creating a process that's going to lead to an objective and diverse, kind of rigorous thing. Again, we can wordsmith a little bit, but the word I would use here to be sure that I really care about is empirical data, because empirical data involves both quantitative and qualitative data, and it's not just someone's opinion, right?
So give me what you're thinking.
Yeah, again, so this is just a suggestion.
Yeah.
I'm open to shredding this, but the implementation body shall identify, develop, and/or commission objective and diverse methods, metrics, and empirical data sources to assess the impact. I think you can kill the word design because it's implicit, but anyway, it's just a suggestion.
I like that. I mean, the one thing I would say is that at the end where it's saying on the justice gap in California, I would actually be interested to see how it just affects, the delivery of legal services, period. Because I think we will see, innovation in other areas as well. So I think by limiting the discussion here to just access to justice, we might be missing and losing out on a lot of really good information that can help drive the delivery of legal services in California, period.
Well, you could say delivery of legal services, including access to justice.
That would be fine.
Alan, and then Jean.
Yeah, just a quick comment. I like the suggested language about commissioning because I think there's a number of existing organizations that are probably much better suited than no criticism on the future implementation committee, but it's pretty tall order to identify specific metrics unless you're specifically trained in that practice. So my comment was just going to be in support of something along those lines where the committee be empowered to commission or outsource, this type of work.
Good. Jean?
And I would kind of piggyback on that, that they're responsible for identifying the source that will continue the monitoring and measuring and reporting out of those metrics and measurables.
Like a continuous, like a.
Yeah, so it's not, they're just not identifying and commissioning, it's who's responsible for continue to watch the trending and reporting out.
You're watching it and it's almost like an annual report or something like that.
So somebody wants to suggest some language for Mimi?
This duty shall be ongoing or something like that. Toby, do you have any thoughts?
But you don't know
We're
if
just
the
monitoring.
implementation body is gonna be they're just developing the
Right,
formula,
they're not
but
the
it's
one
somebody else who's gonna monitor the.
Yeah, this recommendation is intended to promote the ongoing monitoring, analysis, and improvement of access to justice and
Ongoing analysis of.
of the above analysis, maybe, instead of, so we don't have to repeat it. Awkward, but.
Further discussion? Andrew?
I think that maybe with that last little bit, we could say something along the lines of, don't write this down to me because it's rough. Something along the lines of, these diverse methods, metrics, and empirical data sources will be monitored ongoing, period. So instead of having it that this recommendation is intended, it's not that the recommendation, you can drop that language and actually just say whatever metrics and kind of processes that are put into place by that group should have that long-term vision that it would be tracked over time.
Such metrics or analysis shall be ongoing.
That implies that the implementation body.
Analyzed.
So I guess what, like they're creating it, and in the creation of it, it's
like a dashboard. Like you have a dashboard.
Correct.
Or it's an annual report
Correct.
or something like
Correct.
And they pass it off to whoever the appropriate entity is.
Yeah.
It's gonna be, this group's gonna be short term.
Correct, or that if they do their job properly, the process and metrics will be tracked organically via the methodology and processes they put into place.
Right.
So,
There's gotta be somebody charged with reading the data.
Yeah.
Mark?
Do you want to lock them into that degree? I mean, they ought to consider those things. It may be that a program is so self-evidently wonderful and it's done a great job, we don't have to track it anymore. I mean, do you have to really do this forever?
no, yeah, I think you need to track it they can set the timeline, but it should be a long enough timeline, especially because one of the biggest criticisms of any of these types of initiatives, like we're embarking on as a task force, is that, what's the true effect on access to justice here? And I think it's really important that we almost over-track rather than under-track.
Yeah, if you look at like some of, I think Toby's organization's statistics, for instance, like those certain data exist already, and they're not going to go away. I mean, the need's not going to go away, and we'll never get this perfect. And it's going to be we're always going to be sharpening the saw on this.
I just wonder who's going to pay for all this.
How about such metrics? Such metrics or analysis shall be monitored on an ongoing basis.
Okay, we ready for a vote?
I would just kind of quickly, if you look at the paper that Joyce attached in the materials on this framework based on the Drake equation that which deals with interplanetary whatever, that there's some good analysis there of how you do this.
Okay.
At least this one model.
Any further discussion? Bridget?
Can I just add one clarifying thing? I think maybe we should even say like number one. So we're asking this implementation body to, one, identify everything that you have there, and two, maybe establish a time frame or establish a method by which these are measured on a regular basis. Because I think what we're trying to get at, I still think the way it's worded right now implies that this implementation body is the one that's going to be doing this on an ongoing basis. And I want to be clear, we want it to be done on an ongoing basis, but not by the implementation body. So I don't know if that helps or makes it more confusing to everyone, but
which will be utilized by some other group to continuously monitor
No, okay, let's
data.
Number one.
I like the way Bridget had it before.
Okay.
Including access to justice, semicolon, and then two. I might need some help here, but establish reporting requirements for ongoing monitoring
That's great. And analysis.
and analysis.
And if we have
And
zero
leave the
budget
end
for
of that
this, we
period.
find it's gonna be schools and nonprofits and things, but ideally we help address Mark's point, right, that there's a function that carries us out.
Everybody ready to vote? Okay, me?
So this is a friendly amendment to your motion, Mark? You as well, you're okay with these edits? Okay. Andrew Ruda,
Yes.
Simon Bomey,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang, Abhijit Sivan,
Yes.
Jean Clausen, Johan Droshagen,
No.
Margie Estrada, Lori Gonzalez.
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Brady, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Daniel Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, and Joshua Walker.
Yes.
Okay, can we deal with this the same way we did with the prior two? That is, we authorized staff to develop the write-up that as the backup for this recommendation.
One qualification is that we do have the draft that's in the materials that was largely just pulled out of the email we received from Joyce. So if you use that as your starting point, send us whatever suggested changes you have to that, and we will modify it accordingly. But this was her off-the-cuff, quick take on pros and cons for her recommendation.
Okay, is there a motion?
So moved.
Second.
Okay, the motion is to defer to staff to prepare finalization of the materials, and everybody look at that and send comments if you have them. Mimi?
Andrew Ruda,
Yes.
Simon Bomey,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang, Abhijit Sivan,
Yes.
Jean Clausen, Johan Droshagen, Johan,
Abstain. Sorry.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Brady, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Daniel Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Okay, we're gonna go back to the UPL AI group and turn to agenda item B2, add an exception to the prohibition against the unauthorized practice of law permitting state-certified, registered, approved entities to use technology-driven delivery systems to engage in unauthorized practice of law activities. The agenda item B2.
While things get teed up, can I just ask a clarification question? For recommendations that may be related to other recommendations from other groups, I guess we're dealing with them all as they are on their own, so I wonder, because I'm going to be presenting some stuff from our group as well as there's other recommendations that may kind of have crossover with this, in terms of the discussion, I suppose we limit that to what is your recommendation on how best to deal with this from a discussion of these standpoints, at least for this purpose right now?
Randy, I guess the question is, a lot of these that are left may have some touch on each other. And the question is, are we treating each as standalone, not doing anything to sort of marry or make them consistent, and just putting out completely standalone proposals and getting comment on them, even though they may be inconsistent? And will there be, if that's what we do, will there be something that explains to the reader that this is intentional.
So we are being given the liberty to actually present these as a menu of options that could include things that are inconsistent. And so if you have a rule that completely eliminates the fee splitting prohibition and turns it into a client consent model, then that could be an alternative to having an entity regulation model if you feel that the main driver for promoting innovation is the ability to own and profit from the activity. And so, yes, if you're a member of the public comment and you're seeing an entity regulation model and a fee split model, you may be looking at them as an either-or proposition. And we're going to make that clear in the materials that you can look at these things as standalone. The ones that are entity regulation, though, where they're referring to the exception, the unauthorized practice of law for a safe harbor for a regulated or certified thing, those are the ones that we do want to tie together, because you don't want to have the disparate parts of the criteria separated from the main proposal. And so if we say we want something equivalent to privilege, if we say we want to have data security, which is different from privilege, those two should refer to the exact same thing. The task force's recommendation for an entity that is approved to engage in practice of law activities subject to appropriate regulation and would enjoy a safe harbor. And this is the first of the ones, I think, that is part of that tied together theme of entity regulation and can refer to the same thing. I don't think you have to explicitly say the other recommendation, but you should refer to the concept of the task force's entity regulation model. I hope that helps.
May I make a suggestion? Perhaps also the language within, once staff kind of gets this all together, it could say a further discussion of da-da-da is also found in such and such. And that way readers and folks who are providing public comment might choose to provide their public comment as it pertains to this and that, rather than individually. I just think I would recommend that we do an initial kind of sorting and language connection where things are tied to ensure that the public comments we do get are as helpful and as useful as possible.
To go a step further, we might even authorize staff to give the cross-references and
correct,
provide some gloss.
So I'm trying to figure out how this is going to be received. You're suggesting that each of these approved recommendations be included in what goes out to the public for individual comments, even though they may refer to the same type of activity, and even though they may use different words and have different provisions, but they're very overlapping, but they're in different ways the same thing.
Yeah, the current organization
this
of
one,
the
actually, you could redraft this, and it could be one of the D provisions very easily. The question is, are you putting out both?
We're putting out both, and the ones that are all entity regulation driven, we want them to refer to the entity regulation model that the task force is recommending. And so I want to say the most aggressive, but it is sort of the most aggressive change in the law that the task force as a policy position is staking out is entity regulation. I mean, the rest of the things, we're making changes to attorney conduct rules that would really only regulate the conduct of lawyers and indirectly affect the non-lawyers. But the entity regulation proposal is the biggest chunk of change in terms of existing California law and policy. So to the extent we can keep those all tied together by referring to, again, the task force's recommendation for providing a safe harbor from the authorized practice of law for a regulated entity, I think we should use that same reference to tie all of these recommendations together. Because the recommendation for data security has nothing to do with the abrogation of fee splitting. And so we're not going to try to harmonize those or see those as joint proposals at all. Those are completely separate things. But the data security ties directly into the entity regulation model, so it should refer to the entity regulation model.
Okay, just an observation, we do have a recommendation, which I don't think we've voted on yet, about having individual registration of legal service providers who are not lawyers. So we do have something out there that's not entity-based.
Yeah, and that's the one, early on, we had discussions about how close that is to the charter in terms of what we're doing. And we did have a discussion of how we're not defining either the practice of law or AI, but I think we will be talking about later a definition of, is it technology?
Yeah, they'd be like regulated entities. And so the SEC, for instance, defines a regulated entity or covered entity, right? And so it's a similar concept.
Right.
And fall within this group. We haven't defined what that entity would comprise.
So that is going to be the separation between that and a pure, what would be, for example, a triple LT, limited legal technician, individual, non-lawyer at large practicing law model. And so that one I would not tie together with the entity regulation. That is a separate thing, and I think I've said before, the Board of Trustees even has on their strategic plan a separate consideration of licensing individuals to do
This is the
limited
triple
legal
LT,
services.
yeah.
Triple LTs is something that the board, I think, said they want to consider by 2021 on the strategic plan. But it has come up in the discussions here, and we can include something to that effect, but I think it could confuse or muddy the waters of our entity regulation model, so I would keep it very separate. I wouldn't try to tie that one into anything else that's being recommended.
But isn't that's one of our recommendations, and under the D series, we haven't got there yet, but I'm just saying that we do have a licensing recommendation for individuals along the triple LT system, so I don't know how that fits in, but nevertheless.
So that one would be sort of like the aggregation of fee sharing and fee splitting. That's something you could do separate from the entity regulation model and shouldn't be using the reference to our safe harbor proposal. But the ones that do contemplate that should use the same reference when we approve them.
Okay.
So Randy and Judge Evan, are we suggesting that we might even have divergent ideas, that sort of different arrows,
Absolutely.
right, as options? Okay.
Yeah. That's
Okay.
where we seem to be headed.
Good.
Andrew, does that even come close to answering your question?
I'll answer this very carefully. Maybe. I think the different ideas that come up, what I would say is, to the best of the staff's capabilities, to say this may it may benefit the reader to also read such and such section and such section ahead of providing their public commentary on this specific topic. And that's all I'm asking for. I'm not asking for any comments afterwards, but hey, if you're reading this, you should probably read this before you go through, write up a whole bunch of stuff and then say, oh, this one is exactly what I wanted, or this, whatever that is.
Right. Okay, the presenter for B2?
Yeah, so this is kind of the guts of our subcommittee's recommendations. This is really the recommendation where we talk about a safe harbor. So we want to, rather than expand and define the practice of law beyond where it is today, we just want to sort of create a little carve out for the practice of law and say, well, entities that are approved or registered or whatever technology providers can operate in this area. So the recommendation is to add an exception to the prohibition against the unauthorized practice of law, permitting certified, registered, approved entities, whatever the language is, to use technology-driven delivery systems to engage in authorized practice of law activities.
Okay, my notes suggest that that's already been approved by the entire agency task force. So now the question is, let's move to the discussion of the pros, cons, etc. Do you want to address any of that, or just open it up for questions?
I think we did have a small change to the cons in this section. Wasn't substantive though. Yeah, okay, so briefly on the pros. So we want members of the public to be able to identify who has this safe harbor, who's authorized. We want folks to we want folks that are actually active in this market to have some commercial certainty, so they're willing to make investments in this area and actually innovate. And then we want to reduce the burden to the degree possible on the regulatory body. So we want this to be essentially self-funding to the extent possible.
So I think as we move forward, and I will just let you know I'm keeping my eye on the clock and we have a lot left to cover. I think what we should do is where there have been any, we're going to assume that everybody's read the materials, and where you have suggested any changes to the materials that were provided, maybe you could just quickly touch on those, and then we'll open it up for any discussion.
No substantive changes here.
Okay. Any discussion about the materials? Lori?
Just a note on a couple of potential, cons that I see in this idea. One, that the regulation process may actually not give us a great purview of all the potential innovation. It may, again, sort of back to the data idea, do the opposite of what we're trying to do. There may be so little interest in getting involved because it is just a very sort of beginning process, and depending on how hard the regulation is. The LLT program is a perfect example where as of this year, there are only 39 registered LLT individuals, and that's certainly not going to create substantial access to justice reform for that state. The other con is, and I will profess ignorance, so this may not be a true con. It's my understanding that this is still built into California statute, UPL is, and if I'm an outside business looking to come into this market, your certification may not be enough of a guarantee that some other way I may be attacked for coming into this space. So I'll leave that up to this group to correct me there, but if UPL is built still into the statute, that's one of the reasons we really didn't address that role at all. This may only create more confusion about who can practice what, where, when, how, and may not protect those entities, but give them a false sense of safety.
Yeah, I think just as with the privilege discussion, privileges are only created by statute. I think what we're telling the implementation group is whatever it takes to implement this, which may mean new rules, it may mean new rules of court, it may mean statutory changes.
Okay.
Just as privilege would require statutory changes. But that's up to the next folks to decide.
Yeah, we originally framed this as something that was much more of like just a waiver from prosecution by the state bar, but we actually took some of that language away and made it just more sort of general, and put the onus on the implementation team to figure out exactly what changes need to happen, including statutory changes. Yeah.
Perfect.
So Lori, to capture your first point, is it something along the lines of the regulatory scheme may stifle innovation?
Yes, I think that's perfect.
And Daniel, would you be okay with adding that to the cons?
Yeah, absolutely. It very well could.
Okay. Any further discussion on the materials describing this innovation?
This was a previously approved recommendation, but I think earlier we talked about this phrase, entities using technology-driven delivery systems, and we inserted the phrase legal services delivery systems.
True.
That would be something we would try to massage after the fact to make consistent across the entity regulation models. But since we have the opportunity to affirmatively vote it in here, I'd be more comfortable having that happen now.
I'd be fine with that change, and I think this has to be wordsmithed and turned into a defined term at some point.
Okay, Daniel, you want to move the recommendation?
Yes.
As revised on the
As
board?
revised.
And Joshua, you second? And is there further discussion?
I just want to add that based, Justice Edmond, on your last comment, I think we don't know what will ultimately happen with these recommendations. So having more than one arrow, an opportunity to innovate and improve access to justice, I think is helpful rather than detrimental, even if there's variant approaches to this. That's it.
Okay, Mimi, you want to take a vote on the recommendation?
Can I just ask a clarifying point? Are we just voting on, you're just moving the recommendation or the recommendation with the report as revised?
You know, if
Are
we
you
can do
okay
it
with
all
the
at
whole
once.
package?
Yeah, let's do it.
Okay, all right, so moved and seconded. Any further discussion about either the recommendation or the background information? Okay, Mimi will take a vote on it all.
Okay. Andrew Arruda?
Yes.
Sam Bomi?
Yes.
Tara Bird?
Abstain.
Judge Wendy Chang? Abhijit Sivan?
Yes.
Jean Clausen?
Yes.
Johan Drolshagen?
Yes.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morse?
Yes.
Joyce Raby? Daniel Rice?
Yes.
Toby Rothschild?
Yes.
Ellen Rodriguez?
Yes.
Daniel Newens?
Yes.
Mark Tuck?
Abstain.
Angelina Valverde? Joshua Walker?
Yes.
Thank you.
Okay, thank you very much. We're going to move into the D series, that's ABS MDP, and move to D2. Entities can be composed of lawyers, non-lawyers, or a combination of the two. However, regulation would be required and may differ depending on the structure of the entity.
So this recommendation has already been approved at large. What we're going to be discussing are edits in place as well as the package as a whole. How the recommendation relates to the charter has been left as was released in the materials. In cons, line 2, we added some language to clarify that is, I would say, not substantive. On page 2, we changed some non-substantive language around aspects applicable. We changed that to aspects considered with respect to. On page 3, we changed the same language. And then on page 4 and on page 5, we removed the language of the folks who wrote the information on background. One other note that I want to make is something that we did as a subcommittee that was different is that we provided some information that was attached on background, not necessarily to be voted upon. That's, as you can see here in B1, ATT1, and ATT2. What the language there is points also, we have it as points also discussed by the subcommittee. That we hope to be provided to the public for their education and on background. Originally, it contained language that also said pros and cons. We then changed that language to not be confused with the pros and cons of the actual recommendation. So we changed the word pro to arguments in favor and the word con to potential concerns associated, just for clarity's sake.
And
we also
that's the
amended
wrong
the
one.
con a little bit.
It's
sorry.
D, it's D2.
Yeah, I mentioned that.
Oh, D2, go to D2.
We were working on B2. We approved B2.
Yeah.
So what do you?
No, we're in D2, but I'm asking you to bring in language from D2. So you can just go to D2.
Oh, I'm so confused. What do you? Sorry. This actually is D2. It's just it's B1 from the subcommittee agenda. So don't worry about it.
That's correct. D2 is B1.
Yeah, it's fine.
And R2 is related to D2.
Definitely policy.
I know.
Let me just copy. Just start with this part. This is the first one.
We should be putting that language into the recommendation approved by the task
Oh, yeah.
force, because
you're right.
very often the ray line is different from the recommendation.
I just, Randy caught me off guard, so.
Sorry.
And I was trying to listen. Okay, go ahead, sorry, Andrew.
Not a problem. So the recommendation has already been approved. There was no changes to how the recommendation relates to the charter. There was no changes made in the closed section. In the con section, line 2, we added the words in the beginning of the second line, significant resources will be necessary to provide, and then it takes up robust. I make note that what we include in our materials, ATT1s and ATT2s, not just in D2 but in others as well, and that's information to be provided on background. We did change the language there on page 2. Originally it read aspects to all regulated entities and non-attorney individuals. It should now read aspects considered with respect to all regulated. And we also changed that same language on page 3. And then we removed the names associated with the folks who had worked on that. So we dropped Mendoza from option 2 and Passmore from option, Mendoza option 1, Passmore from option 2.
Okay, discussion. Well, let's see. The recommendation has now been amended, apparently.
The recommendation should not be changed.
Randy did his tweak, and
This is what we would have done after the fact, but if we have the chance, I wanted, if you can, look at it now, because this is the magic words that we're using to describe your entity regulation model. And I don't want to put words in your mouth if it's not correct, but this would tie your two recommendations together. They're both referring to the state certified, registered, approved entity that uses technology-driven legal services delivery systems.
I would prefer to not have that language in. I think having it as entities would leave it open-ended enough for public comment rather than having that additional language. If this is a discussion, I don't know if we're moved to discussion of this though.
Right. Well, yeah. Okay. So if there are no revisions being made to this, we don't need to talk about it. And so there's no motion necessary. If this is revised in this way, we had previously given staff the authority to make each of these things consistent before they send them out. What Randy is telling us is that this is the way he would make this consistent with the other recommendations. So had we not had this discussion, had Randy not made that change here, he would have done it on his own in order to make it consistent with the rest of the things. If you're saying now you don't agree with that, it ought to go back to the original, then we should have a discussion about that.
Yeah, I am saying that, and I think what my understanding of that the harmonization that the staff would do would, and that's why I think I was very clear about saying this also relates to this thing and that thing that you should read, because what I worry is that it puts the onus on Randy to understand and kind of interpret all the meanings of things, and while that might miss the case or just any staff member in particular. And so I think we were very thoughtful in the word choice, specifically when it comes to recommendations. And I fear allowing staff to change that, even in the overall goal of harmonization, might take away from what the goal was.
Is it fair to say that in the discussion of your group, it was not necessarily that every entity had to be state certified, registered, approved?
That's correct, and as a matter of fact, when we added in the ATT1 and ATT2 and throughout this particular D2 recommendation, we provide examples of how the regulation may take place, but we did not, we don't have a specific recommendation as to which one. It could either be one of those, it could be a hybrid of that, or it could be something that doesn't include any of that. So I'm worried about that.
Great.
Is there somewhere that you explain that what types of entities these are? Oh, I'm sorry. If I was a member of the public, you're asking me to respond to this. There are entities out there that are comprised solely of attorneys
There are entities out there that are comprised solely of non-attorneys. There are entities out there that mix attorneys and non-attorneys. But I think you're talking about entities that provide legal services. And that's not in the recommendation.
That language could, that is what we're discussing, entities which provide legal services.
And we talk about it further in the attachment that's now by background. Starting on the next page, we talk about this hybrid model where you've got attorneys and non-attorneys, and just non-attorneys. It's different forms of entities that we're considering.
But entities that are providing legal services, that's the key.
Yeah, but they're not necessarily technology driven, because a multidisciplinary practice doesn't have to be technology driven.
Right.
So we definitely wouldn't want that in there either.
But you would want to have language in there to make it clear that it's entities that provide legal services.
I think that the reason why we're getting into this confusion is if you read our recommendations in line, the previous one will talk, like, we kind of list that, and then this flows from that.
Right, and I'm reacting to what you had said earlier, how confusing that could be.
Yeah, I agree.
To not know that they were related.
I agree, so maybe we could
I
add,
agree.
yeah, we could add that language that, like you're suggesting, around the delivery of legal services, and that should help.
Right, okay.
I just think that the original proposed language is too restrictive from what we've been talking about.
Okay, so maybe take out all that blue language and say entities that provide legal services.
Yeah.
Yes.
Yes.
Mark.
You took out your language, Randy, but I thought, if I recall it, you said it was registered, certified, or approved, right? So those are options, right?
Right.
You would say, and
It's
certified,
making
registered, and
explicit.
approved.
The latter part of the recommendation said, quote, regulation would be required.
Yeah, I'm gonna get to that in a
So it
second.
was just trying to bring up front that the regulation that would be required would be some sort of approval process, whatever it might be.
But your additional language gave the three options, it can be registered, certified, or approved. And the recommendation says regulation would be required, so why is this a problem?
I just want to, I like how open the terminology, just having it as entities is, so that we don't have to necessarily even discuss that, and I think the confusion was, what entities are you talking about? And I think by the inclusion of the language, entities which are delivering, that provide legal services.
Well, that's okay, I'm talking about his language of certified, registered, or approved.
I just don't think it adds to it. I think if anything, I'd rather have it more open rather than descriptive. I'm open for a vote on that.
Because it may not be the entity that's regulated, it may be the individuals too, right?
Correct. That language presupposes, and it already gets people mentally putting things into certain
Oh,
boxes.
I see, regulation would be required.
That I'd like, correct, that's right.
I got it, okay.
It almost,
I missed it.
it takes people down a road I don't want them to go on mentally if they don't have to.
Okay, I guess that's the difference.
Okay, Andrew, do you move that recommendation as it is on the board?
Yes.
And along with the background write-up that was on the board?
Correct, as well as the pros and cons included and how it relates to the chart.
Right, okay. Is there a second?
Second.
Is there discussion? Joshua?
I just want to add that, I support this general concept that we shouldn't necessarily presume a monopoly. Our job is not to maximally protect monopoly pricing of attorneys. On the other hand, I think there's an argument that attorneys and judges have a unique role to play in the practice of law and the delivery of legal services. So I would just add that as a con, that it may be, even with the consumer interest paramount, lawyers and judges should have a unique role in the delivery of legal services. I'm not arguing that there should never be an approved entity that doesn't have lawyers or a judge, involved. I just want us to have that out there because it's an opinion we'll get back regardless of what we recommend.
I don't think that's a con so much as a commentary, because we discuss, in the more background materials that we may be talking about very limited areas and types of work they do. So I think everyone would agree lawyers have a unique role, and it's just, how are we going to define the role that's going to be broadened for other people? So when you say they have a unique role as a con, I don't see that as a con. I just see that as.
All right. Well, you may lose it if we do start, if regulation occurs, which enables services where lawyers are completely disintermediated, increases the risk that we blow something up that we just didn't see beforehand, right? So I think it is, it may be identifying an uncertainty, but I do think it's worth noting there. We can reframe the language.
I think that it certainly doesn't take away from anything. I think the fact is, we did have discussions around this concept a little as a subcommittee as well. And so for the interest of ensuring that the language is as inclusive and doesn't come across as, trying to persuade in the cons especially, I myself wouldn't feel uncomfortable with including it. I don't think, Joanna, unless you feel very strongly, but I don't think it takes away anything, but I do think it offers a con that might be, that some folks may have, a feeling that some folks may have.
Okay, I take, yes, Mark.
So there's one more comment. This change that you're making, I wish I could see it from here.
Yeah, make it bigger. You want to include this language?
Wait. Let's finish this thought first then, if you're going to a new comment. I take it, Andrew, that that's a friendly amendment as far as you're concerned. Joanna, you seconded it. Are you willing to accept it?
Such power.
Yes. Okay.
That's the problem with the
Mark,
monopoly
what's
regulation.
your comment?
Can you scroll back up to the top, okay, so that when you say that these
All we changed there, Mark, was that provide legal services.
right, so that now eliminates ALPSs and 5.7 arrangements.
Why is that, however?
Because they're law-related services.
That provide legal services and law-related services. How about we could add
Yeah,
that?
otherwise,
That's kind of why we just left it pretty open even to
yeah, I
begin
know,
with, but-
that's why we left it open.
Yeah.
But are we now narrowing it to just legal services?
No, we're not, we don't have to, that's a great point.
I'm gonna add this word.
You want to add and law-related services?
Yeah.
That's how I understood it.
Legal and.
Yeah, I think that's fine.
Or law-related services.
Or, yeah.
Yeah.
And or,
It should be and/or, yeah.
yeah, and or.
You're gonna do both.
Or two and counsel services.
Okay.
No, let's not use and/or.
It could be, you could
Well,
put
they
or
can-
and
But they
still
can do
mean
both.
either. Yeah, but or means you can do both.
Oh, yeah,
Take out the first service.
You can say or.
As long as you do one.
Okay.
Oh, yeah, we can get rid of the first services, that
Take out
provide
the
legal
first
or
service.
law-related services, yeah.
Yep, that works. Okay, Andrew, I take it that's okay with you?
Yes, big
And it's
time.
okay with you,
Thank you very
Joanna?
much.
Okay,
I'm fine with that.
terrific, thank you. All right, any further discussion? We're voting now on the recommendation as it is on the board, plus the pros, cons, background discussion, as one whole package. Mimi?
Okay, Andrew Rita,
Yes.
Simon Bowman,
Yes.
Tara Bird, Judge Wendy Chang, Abhijit Shaban,
Yes.
Jean Clausen,
Yes.
Johan Drosthagen,
Abstain.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Granny,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morris,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Abstain?
Alan Rodriguez,
Abstain.
Daniel Rubens,
Yes.
Mark Tuck,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
Okay, we're moving on to D3, same subcommittee, ABS MVP. D3 says non-lawyers will be authorized to provide legal advice and services as an exemption to UPL with appropriate regulation. That has already been approved by the entire task force. But now, as I understand it, Bridget, minor amendment?
Yes, so we just proposed inserting the word specified before legal advice in the recommendation,
D3.
just to make it clear that we do plan on limiting this in some particular way. We don't want to just open it up, so we wanted to add that. And then also just to make the comment that it could be confusing that the Ray line is worded a little bit differently, so just to make sure that that's consistent with the actual words of the recommendation as well. So should we vote on the amended recommendation
Well,
before?
why don't we see if we can
We'll go for the whole thing?
go for the
Okay,
whole.
I'm with you. Okay, so we did recommend a few additional changes to the information you have. So on the pros, I think it should be up there. On the last sentence of the pros, we just want to say finally clarifying, it's non-substantive, I would say, clarifying the role of non-lawyers instead of saying having some clarity in. And then at the end, enable entities to more efficiently, and we want to say, and with greater certainty, deliver legal services to consumers. With respect to the cons, we want to omit the word limited, just so that it's redundant. And then to replace the word tedious with challenging in that same line, to get rid of the quotes around overregulation. And the only other change, with respect to the attachments, is the same as we've done with the other background information from our other recommendations. These are just things that we have been talking about, and we wanted the public to know what we were talking about. We're not making any particular recommendation with respect to these options. But we did just have one little wording change on, we're just wanting to add the word specified again before legal advice at the very last sentence of the introductory paragraph. And that's it.
Okay, is that a motion?
Yes, it is.
Second.
That's for both the recommendation and the backup information. Discussion. Mark?
So Randy, is there any question whether or not this is within our charter? Because this is a non-entity recommendation that it's providing an exemption for certain individuals to provide certain activities that could otherwise be described as legal services under an exemption to UPL. Is this within our charter?
To the extent the charter under the UPL section says to consider the impact of the definition of the practice of law and the unauthorized practice of law and the delivery of legal services and expanding access, I think the point was already made earlier and in prior meetings that could include non-tech related, non-entity related reforms. And we just passed the recommendation that is, in my mind, a non-tech related entity reform. So this is just extending that to individuals. And my practical thinking is the board is the arbiter of their own scope of what they want to consider, and they may have had in mind when they adopted the charter that it would be entities only or tech related only. We're coming back with something that might be broader than that, but they are completely free to roll with it or to reject it.
So would triple LTs come under this? Are they seeing those types of individuals separate and distinct from this? Because I thought you could take the triple LT structure, not go so far as Washington did, but you could have something that has that as its recommendation. Is that something that you think the board would consider? Is that, I mean, we don't want to do something the board does not want us to do, but it seems to me that the triple LT would be included in this.
Well, that's included as one of the things that we've been talking about, one of the options in the attachment as an idea.
Or a version of.
I don't use the word triple LT, but we have this hybrid entity / individual regulation as an option. So I think that's covered here as something that we've been talking about.
Yeah, my own personal view when I considered the charter in its totality, I did not view it as including discrete licensing of individuals without any relation to technology driven as the key to the delivery system as being a focus of the charter. But if you parse the charter to refer to just reforming the unauthorized practice of law, it's almost inescapable that you could include something like this. And again, this is only going back to the board to go out for public comment, and they may or may, they're the gatekeepers, they may or not think that this is something that will enhance or detract what might have been the original vision, which was technology-driven online delivery systems.
Okay, but this does include technology driven.
It includes, but it's not limited to it. That's the concern.
Tara.
So, my concern is, I guess, with the last, my concern is with the last part with the appropriate regulation, because I'm wondering if whether the idea of identifying certain types of legal advice could be excluded from UPL. And what I'm thinking of is kind of basic stuff like, wills and trust, like the basic wills and trusts, whether to use a will trust, basic family law, but basically the stuff that the document preparers are coming into contact with every day, but if they cross over this tiny line, then they violate UPL. So I'm thinking of, where you kind of move that line and you clarify, look, you can provide advice as to, which tool might be better. Is that something that's considered by this, basically the unregulation of certain types of advice? Or is that not captured within?
I think the general idea was around the regulation stating what is and is not permissible up to certain points, and in that case, that would be captured. It wouldn't necessarily have to have a regulatory schema for every action, but that it would be clear that there would be those exemptions for certain tasks or activities. So that, with your example, there may be specific tasks or things that are, it still would be classified in the regulatory schema that non-lawyers would be allowed to do that and carry out that task.
Because if I'm putting on my public hat, I don't want any more regulation of anything, because I don't want to spend my money on more regulation. So the way I read this is like, no, I don't want more regulation, but if you take away that word, that sort of broadens my mind, so.
Yeah, I like your point.
Just to make sure we're on the same page, Professor Sandiford presented us with clear examples of non-lawyers having the ability to provide more than just a document and tell you how to fill it out. That they could provide additional information about the existence of a legal remedy or the existence, the fact you have a legal problem. I always view that type of activity being encompassed within this recommendation. It may well use technology, it may not, but you're trying to provide consumers with more than just, here's a document, go and fill it out, I can't give you any advice. I think that was one of the main points of her whole presentation. And so, from my own personal point of view, I thought this recommendation captured that, among other things.
I think what I'm hearing is the words "with appropriate regulation" can be read to kind of almost state that there's going to be more regulation needed in some aspects. So I think as a task force at large, we can determine here whether to keep that language with appropriate regulation. We can choose to remove it completely and put the period after UPL, or we could choose to change that language to something else that may work, is the way I'm seeing this right now. Does that make sense, Tara, to capture what you were saying?
Yeah, I would friendly amendment to remove that.
Oh,
I would be okay with that.
The reason that I have it in, and I realize maybe we could wordsmith it, but the appropriate regulation, it may mean, this is my point, is the implementing body can decide, maybe that's just a teeny tiny little bit, maybe that's just registration requirement. But to me, the point is we're not just gonna, I don't think we're recommending just opening this up, like you're exempt from UPL, go and do your thing. I mean, I think we're still trying to incorporate this within the regulatory scheme in some way, and that the modification appropriate to me is that we're letting people decide how much regulation that should really be and what level that should really be. But if we're not, I'm just trying to think about how removing that phrase would impact everything else that we've written in here already, because that was definitely what I had in mind when I was writing that.
And I do think that by adding provide specified legal advice and services, it's an exemption to me that language narrowed it for me. Like you're only going to identify a few things.
Mm-hmm. No, that's true. But again, if you are, then isn't that regulation?
Yeah, that is regulation. It's deregulation. We don't know yet.
Alan?
The one thing that I wanted to say about the specified legal services, I would like to see the word specified removed, just because we don't know what the future holds, right? So, for example, like a lot of our older, the advertising rules under 1400, were designed around 80s TV commercials and things of that nature, and they hadn't kept up, right? So, but we may find ourselves setting another committee to try and address this very thing by keeping specified. If we try, or the next committee that comes after us, the implementation committee, if they try to define that, again, nobody has a crystal ball, right? So for me, I'm kind of lukewarm about appropriate regulation as a phrase, but it's more the specified that draws concern for me. So just wanted to.
I think we need specified. I think everyone had agreed, at least in our subcommittee, I don't know if we talked about it in the full task force, that we weren't giving the green light for non-attorneys to appear in court and represent somebody.
Sure.
And so that alone is a specified, area that we're kind of carving out, saying only lawyers should be doing. But the problem is we don't have the ability to identify everything right now that we would only want lawyers to do and what could be open up to everybody else. But we want to make it clear it's not going to be absolutely everything. So specified kind of captures that to be determined aspect of it.
Okay, this is obviously a debate we can have post public comment, but the question is what version do we want to go out for public comment? And so, Bridget, this is your motion. You want specified in and you want with appropriate regulation in, or what?
What if we added with appropriate regulation and we added if necessary afterwards? Would that alleviate some concern, or is that just adding too many words here?
Why don't we do this?
Okay.
You made this motion, let's vote on this, let's
Okay.
see how it goes, and we'll go
Okay.
from there. As I understand the motion right now, it is this version on the board, plus the background information. This would be what would go out for public comment.
Okay.
Okay, we'll take a vote on that. Any further discussion? I don't wanna. Okay.
Right, so what the original motion was to approve the recommendation and the report.
That's
So
what
it's still in there, just making sure. Okay, Andrew Ruda?
Yes.
Simon Boney?
Yes.
Tara Bird?
Abstain.
Wendy Chang? Abhishek Shaban?
Yes.
Jean Clausen?
Yes.
Johan Drolshagen?
Yes.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morse?
Yes.
Joyce Raby? Daniel Rice?
Yes.
Toby Rothschild?
Yes.
Ellen Rodriguez?
Abstain.
Daniel Rubens?
Yes.
Mark Tuft?
Yes.
Angelina Valverde? Joshua Walker?
Abstain.
Thank you.
Thank you very much. UPLAI, agenda item B3. The regulator of state certified, registered, approved entities must establish adequate ethical standards that regulate both the provider and the technology itself.
Great. So, just wait till this is up.
Do we have a presenter on this one?
Yeah, we do. So again, the recommendation is the regulator of state certified, registered, and approved entities must establish adequate ethical standards that regulate both the provider and the technology itself. The reasons we mention both the provider and the technology is that, again, you might have a situation where you have one provider but a technological platform that's separate or distinct. We want to make sure that both are essentially covered. Dan, do you have other comments on this in terms of background?
Yeah, there are certain analogous ethical standards that would only apply to a provider, and we want to go beyond those standards in the case of some technologies due to the scale and impact that a technology can have compared to human performing legal services. So there are things like algorithmic transparency. We want to be sure that people are delivering algorithms in a way that is accountable. We want to be sure that confidentiality has an analog in security and privacy. So those are technological means that go beyond what is there just with the provider regulation.
To give you an example, if you think of sort of Napster, right, or pre-Napster, we had fair use sharing of audio recordings, which was widely approved. When you scale up a kind of a manual process, sometimes, at least according to the Ninth Circuit now, you can have a different phenomenon. So even if there's something that is perfectly acceptable for a human attorney to be doing, and she's doing XYZ, it may not be appropriate for a large-scale technological platform to do the same thing if they're using the data in other ways. So we just want to cover both bases.
Did you, as a subcommittee, make any changes to any of the discussion that followed B1?
I don't believe so. Nope.
Okay, Aunt Randy.
So this is a case again where we're using the phrase state certified, registered, approved, and then the magic word entities. For B2, if you wanted to conform it, and you don't have to, but you could say entities using technology-driven legal services delivery systems. That is the entity that must establish ethical standards that regulate both the provider and the technology itself. And I think it's implicit because it refers to technology. So if it's referring to regulating the technology, it would be consistent with the other recommendation in describing the approved entity as one that is a technology-driven legal services delivery system.
Yes. Go ahead.
Yeah, I think we're all nodding our heads. That makes sense.
Okay, those are friendly amendments. So I'm not sure we got a motion for both the recommendation and the background discussion. Joshua?
Moved.
Second.
Okay, it's been moved and seconded. Lori?
So this is one that I don't think I can, from my standpoint, we are very undetermined about who's going to regulate a certification process for potential entities. What I do know is that this process has been very excruciatingly long, and the idea that ethical standards would be set for technology in this same format with this same kind of time frame sort of defeats the entire purpose, in my mind, of what technology brings to the table. So in terms of building ethical standards, I think that's very vague. You know, I like you believe there should be regular standards set, but I'm not sure that the regulator of this certification program, which is very different, is the right person to do that. And I think that's something way down the road. I feel like that's a process that may have to be implemented if there is a problem. But this feels like, you know, a just in case, way ahead of time that may end up causing a whole lot more problems than it cures. And Dan and I actually, you know, we talked about the idea that when Google shows up, it can do a whole lot more harm potentially if something goes wrong than an individual. But on the flip side of that, if Google shows up, it can do a whole lot more good as well than one individual. So I think we are taking away the actual benefit of technology if we ask regulators who are just creating a certification process for, you know, entities to come here to also set ethical standards for things they may not understand.
So, you know, I think we're using the word here, adequate ethical standards, and there's always going to be a balance between the regulatory burden and, as Washington showed, right, between the regulatory burden and getting access to and protecting the consumers. The issue, there's a tactical issue as well that I think we should be aware of, and that is we may have the best recommendations in the world in terms of completely revolutionizing blank slate design, the practice of law and how it gets delivered, but if it doesn't get approved, if there is an untimely and violent reaction from the bar, from attorneys itself, that may limit, the ideal may be the enemy of the decent, right? And so what you see in a lot of our recommendations is this implicit reference to tradition, the existing bodies of law. It's not to destroy or deter innovation. It's to protect consumers first and foremost. But second, I think tactically, we can have variant types of recommendations, right? I think as Randy recommended. But if we don't give the bar some ability to reference traditional ethical rules, one, it could hurt consumers in ways we can't conceive of right now. And second, we may hurt our ability to get any kind of improvement in. And so that's our feeling. I mean, we definitely recognize your concerns, and we talk about it a lot. It's in our cons. But I'd still recommend, personally, moving forward with kind of adequate ethical standards. But again, happy to discuss more. Dan?
Yeah, so I think there's a lot of detail on this in the background, like 15 pages of detail, very painful detail, and we, I think we go into a lot of the reasoning for each one of those standards that we propose. There's just not enough room in the recommendation at this level to sort of detail that, but there is a lot more behind this.
Yeah, we do have to open up the conversation. I think the cost of reducing the cost of compliance for the providers is a huge topic of conversation that we need to attack and really focus on and look at it in real life, right? Look at the empirical data. But I think that one of the things we've tried to do is, or we can try to do, is come up with simple technologies. For instance, security, it should be like, if you hit this standard, you're good.
Yeah, it's like a checklist.
Right.
And let me, just because I know we have a lot more to do and there's a lot of time, there's probably nothing that's gonna happen right now that's gonna change my ultimate opinion of that wording. And so I'm happy to just kind of say, hey, this is my concern, and then give the floor over to someone else.
Okay, any further discussion? All right, I think we should vote.
Okay, the motion is to approve the recommendation and report as revised.
Yes. So
Sorry. Andrew Ruda,
Abstain?
Simon Bowman,
Yes.
Tara Bird,
Yes.
Judge Wendy Chang, Abhijit Shaban,
Yes.
Jean Clausen,
Abstain.
Johan Trollshagen,
No.
Margie Estrada, Lori Gonzalez,
No.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
No.
Toby Rothschild,
Yes.
Alan Rodriguez,
No.
Daniel Rubens,
Yes.
Mark Tuff,
Yes.
Angelina Valverde, Joshua Walker.
Yes.
Thank you.
Okay, we're moving on to more of UPLAI. B5, regulated entities should be required to provide enhanced privacy and data security protections.
Yeah, again, here, there are unique problems to technology. We want to recognize that and essentially address those problems with unique solutions as they are needed. I believe we did not make any changes to this one, so this is pretty much as it was in the materials.
And what's been suggested is just the unique
D5.
default. We don't have to put in the technology, the technology-driven.
I don't know. Do we?
Instead of regulated entities, we could replace that term with
Standard language we've been using.
Yeah, I think that's probably a good idea.
Okay.
And then following that, I would move to approve the whole thing with the pros and cons.
I'm sorry, I know.
I think you
Sorry.
wanted that part of the meeting. I think you wanted from the beginning.
Entities.
So Randy's language.
Well, isn't that what we want?
Yeah, totally.
Certified, registered, or approved.
Oh, yeah,
Exactly.
slash.
whole, yeah, okay, that works. Okay,
So this is substantially the same as was in the original document, so I move to approve the whole thing.
Second.
okay, so move and second, Mark.
Is it clear, Randy, that we are excluding law firms from this recommendation? Are they included?
It is not our intent to include them.
Well, but I think they're entities, they're certainly regulated. And we've already talked about the fact that a law firm can be an organization that's authorized to practice law. So I think they are included.
I would disagree with that because what this is going to become is a defined term of someone who has a certification and a
Probably
safe
not a law
harbor.
firm.
What's that?
It's probably not going to be a law firm.
It's probably not, it could be a law firm, but they wouldn't need to be for the most part. So this would be a non, I think
It's
it's
a
a
professional law corporation would be registered. I'm just asking the question because you become every law firm, they have to have enhanced privacy and data security protections, which.
I believe that is not the case because this would be an entity that's certified to practice law, and if you're a law firm, you wouldn't need it.
Well, doesn't it, I can't read this.
I mean,
I would say, but
I would
only
love-
if the law firm created
If they create
technology,
something,
they
yes.
would do that. So for instance, my law firm right now is creating technology, that technology that we're creating to provide legal services would have to be
That would have to
regulated.
get certified.
Yes, because
but
we'd have to
not
get
the
that
law
certified. The law firm would not be, we're talking about the technology.
Yeah,
And-
so
and
here
I
we're
would-
not talking about law firms. Even if a law firm creates it or creates the
We're not
investment.
talking about the law firm, we're
separate.
just talking about the technology. So whether it's a law, whether it's the law firm or not, it's the technology we're talking about.
And I would love to mandate, some broad sweeping privacy and security
Right.
standards across all law firms in California. But that's probably not our scope.
For background in the public.
That's a different committee,
I
right?
really
I might
but
be doing
like,
that with this recommendation.
And again, Dan is a non-lawyer technology company, so again, he's imposing something potentially on himself here.
Yes.
You want to talk about why?
Yeah, I think as it relates to forming a healthy industry, I think we need to be careful and thoughtful in the way that we move. Not move fast and break things, but move carefully and serve the people, serve the public, protect the public from harm.
I'll just say all law firms use technology, so
Yeah.
it's, I think there's a good chance that you read this to say this applies to them.
I mean, we can clarify that this is not intended to apply to law firms generally.
Or we could leave it out, and if somebody should decide to, somewhere down the line, do that, it might not be a bad thing. I mean, for somebody who works in a law firm, to have a standard of data protection that we have to do that's given to us would not be a bad thing.
It could be cheaper.
But I'm saying is that I don't think that we need to exclude law firms, that if somewhere down the line, a court decides that this applies to law firms as well, why not leave that open?
Well, and I know time is short, but let me tell you, professional law corporations have to be registered. They do use technology. It's a risk management issue, but if you're gonna mandate it, it then affects their registration status. I don't think that's what you intend.
No,
Yeah,
that's
and
not
I think it would be better to write something somewhere saying it's not intended to cover law firms.
The law firms are defined very broadly to include entities are authorized to practice law. So I think you've got a pretty broad recommendation.
We could add a parenthetical after systems that says, again, we can debate this, right? If you just want to go ahead, Bree.
If you read this in connection with your concept of this being a defined term, this all stems from our original carve out from the unauthorized practice of law, which doesn't apply to law firms.
Right.
So we either could clarify that again here, or you make this a capitalized term that's initially defined in that initial recommendation with the carve out, because that's what this is all talking about.
Can staff clarify
the safe harbor?
If again, there's agreement on the concept that we're not intending to primarily include law firms, right? Can staff just clarify that to solve the Mark's issue?
I think by defining it as you described.
That was sort of the
that
intent
should
of
take-
using those
Yeah.
consistent words, that they are all interwoven. Every time we refer to the state certified, registered, approved blah, 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 each of the things that we're recommending for that new entity would all be required.
But I think
If they're all
if these UPL AI proposals are all grouped together when they go out for public comment, and it is a defined term, ideally maybe all caps, not all caps, but every word initially capped, then it would be clear that this is a defined term that doesn't include all firms.
Yeah, it could be like registered legal technology.
So,
or something like that.
Move to approve this as amended.
Just before that happens, it's a comment that shouldn't derail things. One thing that I just want to make reference to is one of the worries that I have here is that we're going to hold these entities to a higher standard that we even hold law firms and folks that are already providing information. So I don't think we are, and I know the discussion was around that. I think that's a really important thing, whether we capture that in the commentary, et cetera, will be important.
So,
Joshua, was there a second?
Well, yes,
so Andrew, just, that's actually our intent, is to hold these technology companies that are centralizing and concentrating this risk, hold them to a higher standard, or to a minimum standard. Ideally, law firms come up to that standard someday, but that's not our.
I would say in general, our goal is not to discriminate in any way between the different types of providers, whether it's like, we don't want to prejudice lawyers, we don't want to prejudice non-lawyers who are doing the same thing. However, there may be, what Dan is referring to is a particularly acute risk if a massive ISP gets, 50% of Santa Clara's or LA County's, legal consumer information data, right? It might create some unique risks as well as some compliance economies of scale. So it might, anyway, does that kind of cover the concern?
Joshua, did you second this?
Yes.
Okay. Lori, did you have a comment?
I do, I'm not gonna comment on the proposed rule itself because I think my vote's already made up on there, but I would like to suggest an additional con, and that is that by holding technology companies to the same or higher standards in terms of ethical obligations, you may confuse consumers on what type of legal services they're getting or whether technology is equal to or better than a lawyer, which I don't think anyone in this room believes is true. So wordsmith that how you want, but the idea is, I go to a nurse practitioner versus a doctor. I understand they don't have the same obligations, and I'm cool with that because it gets me faster and cheaper. I just don't want to have that same sort of idea here, where technology companies somehow are confused as better than or equal to lawyers because they're being held to better than or equal ethical standards.
I'd like to weigh in on this. In the ABS MVP subcommittee, our recommendation about entities being able to engage in practice of law, we talk about there's all these different things in our background materials that we would want to have considered. Data, privacy, that is all of those things to be considered by the implementing body, whoever that is. I think we may be jumping the gun here. We're already asking that organization to consider those things. We don't have to commit at this time.
Okay, I'm not at all sure where we are.
I think we can move to vote.
Yeah.
Well, the question is, are we adding a sentence that says, by holding these entities to the same or higher ethical standards, consumers may be confused on the types or quality of services that they will receive?
I think I'm okay with that change.
Yeah.
Yeah.
Okay, we'll add that sentence. Joanna, I'm not sure what your comment went to. Are you suggesting some change?
The recommendation itself, even being.
Okay, so that was a speaking against the recommendation. Okay, are we ready for a vote? And this is on the recommendation and the entire package.
Okay, go back up so we can. Oh, sorry.
Last comment, my last comment, I just want to mention that, again, if we have something blow up and it's a very large scale innovation and you get, it's like a plane crash, right? And so that was one of the other reasons that we wanted to be particularly careful with this new type of body. It's not to deter innovation, it's that we don't want a plane crash that in turn chills it years down the road.
I'm just gonna throw out that you're doing the opposite though to the potential that it would blow up and increase access to justice at that same scale. So you can't, risk is on both sides, the way risk is going to work in that moment. If you
We
deter
definitely made a
that.
choice that a large-scale technology provider can handle this cost a little better compared to the risk of the airplane crash. I agree, it's a trade-off.
I promise we will debate this
Yes,
after we
sorry,
get the public
sorry.
comments.
Yeah, sorry. I'm ready. I'll shut up.
Okay.
All right, Andrew Ruda,
Nope.
Simon Bomey,
No.
Tara Bird, Judge Wendy Chang, Abhijit Sivan,
Yes.
Jean Clausen. Abstain. Johan Drolshagen,
No.
Margie Estrada, Lori Gonzalez,
No.
Bridget Grammy,
Yes.
Andrew Kuchera,
No.
Joanna Mendoza,
No.
Kevin Moore,
Yes.
Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
No.
Toby Rothschild,
Yes.
Alan Rodriguez,
No.
Dan Rubens,
Yes.
Mark Tuft,
Abstain.
Joshua Walker.
Yes.
Does that carry?
What was the result?
I'm not sure I have an answer.
7, 8.
No, 7,
3.
8.
7, 8, 3. 7 yes, 8 no, 3 abstain.
Okay, so it does not pass.
Let me double check.
So they will not go up for public comment.
Okay.
Yeah, so do I.
Item number 15, B6. The regulatory process contemplated by recommendation numbers XX and X should be funded by application and renewal fees. The fee structure should be scaled based on factors such as nonprofit status, revenues, profits, and/or how much the product addresses the access to justice gap.
Right, so we're not specifying how that scale or fee structure should be composed. We're just saying we should think about these things all together. There will be a fee, and generally it should be somewhat scalable with revenue, and we should also think about how access to justice and the overall use of that product fits in, but we don't know how that's going to be. That's something for the implementation committee.
In general, I'm not in favor of things that scale based on revenues and profits. I think if you can make a bigger profit, you should be entitled to keep them and not have to pay that towards your renewal fees. And I'm not sure how we measure how much the product addresses the access to justice gap, and I'm not sure that a regulatory agency should be the one to decide what that means. You know, there's so much, so many different people need this increased access, and if you make something more efficient that doesn't address that justice gap in the same way, that doesn't mean that you haven't really significantly helped the legal population as a whole. So those are two things that I don't know that we want to be putting out there. And also because things like this tend to inflame, comments like these tend to inflame the public, right? They read it and they're like, yes, let's give access to everybody. But the people that are going to be innovating also need to have the revenue. So I'm just hesitant to put terms like this out there because it's kind of like when you put something on the ballot that says money goes to teachers or firemen. Everyone wants money to go to teachers and firemen, and it passes, no matter what else is in that proposal. So those are my thoughts.
Thank you. Yeah, I think those are important things, and I think we addressed some of that in the cons. The goal here, our goal here was to communicate that we want to not put the identical burden on a company like Google that wants to enter this market as a small startup, 1 or 2 people that wants to jump into this market and try something innovative.
Yeah, I think actually in the other situation was you might have a $10 billion a year company that's paying the same fee as a small nonprofit, right? And so the goal was to enable small players to actually get included. The factors are not dispositive, right? So you would, just because you got revenue and you're a very profitable entity, we don't want to deter someone from entering this market because they're exposed greatly. It's just something that could be considered. If you have a one-size-fits-all approach, you might deter, like, let's say someone wants to write an AI or a technology tool that helps with habeas corpus filing and analysis. That's an underserved market. You may not find a for-profit entity that wants to go in, but it's hugely important, right, constitutionally and otherwise. So how do you encourage that? We need to potentially subsidize some of it, and that's the intent behind this.
So just to be clear, I'm not totally sure what the express purpose of this is. If it's that this regulatory process should be funded by application and renewal fees, period, I agree with that as a proposal that should go out. But if the greater purpose of this is to ask the public what they think about nonprofit status, revenues, profits, and how it addresses the justice gap, I'm not okay with putting those concepts out for public comment. So.
Yeah, I think there's
Well, I think the overall goal is to have flexibility, that the regulatory agency that is going to be, or the next group that's going to be taking our proposals and moving forward, that there be flexibility when they come up with the, how they're going to require the, whatever fee or registration fee that they have to pay, to have that flexibility. I think it's something that we all deal with on the business side, that I know that, there is some sort of a scale for my firm versus, a global firm. It's the same thing here. We want to make sure that a nonprofit is able to get in there. We also know and understand that there'll be technology that comes this way that will not be access to justice, but might be, we don't want to limit it to that. We know that there will be some for-profit or other things that come out of here that are very innovative, and why should they not, be able to pay as well? So I think it's just to provide that flexibility. I can see where, the terms, could come into play and people will, glom onto them and not be able to see, the rest of it. So I think we could definitely wordsmith in that, but I think we just want to provide flexibility.
In that type of language that, it may be flexible depending on factors, period. I think I'd be more agreeable with, but I'm just not in favor of this particular language.
I think we
And
would
that
do that.
that could be in the commentary.
That's my recommendation, is just simply change the language based on thresholds as determined by the whatever, committee this goes to for implementation, so that it isn't as narrow as already trying to niche into those thresholds of nonprofit revenue profits. So you're leaving it a little more broad for them to develop those thresholds.
How about should be scaled based on multiple factors? Heather?
To be determined by.
To be determined by the.
That gives you flexibility.
Yeah.
Yeah.
Maybe. It could be may, that's what I was gonna say, instead of
Yes,
should.
sorry, maybe. So just so you know, the background for this, and something that may pop out otherwise, is there was a recommendation that came up that said it should just only be revenues and profits. And I didn't like that at all, because I think that can chill commercial activity as well. So if we leave it completely open-ended, we might end up in a worse situation. So we'll leave it flexible.
One thing that I don't want to open a can of worms, but when you incorporate a company, whether it's going to be a huge success or it's going to be a massive failure, you end up going through the same process, right? Like from a incorporation standpoint. Right. So I don't know why we have to kind of have that change in this case. Like, that an entity can grow to $10 million in revenue and they pay the same registration fee, and one may pay the same and be a bust early, but I don't see the need.
Yeah, I do agree. I think, again, the goal is to help the entities that are nonprofit and that just don't have they're just different in nature, right? So just to give flexibility. So I made language change to help us there.
Okay, so what language change are you talking about? The
We've
fee
got it.
structure may be scaled based on multiple factors to be determined by the implementation body, is that what we're?
Yeah, or implementing body.
What?
Is it implementation body or implementing body? I'm not sure.
Do we even know, should we be referring to them?
I'm not sure we need to say who's gonna do it.
Yeah, we could just make scaled.
Okay, that's fine.
Multiple factors, period.
And everybody okay with that level of?
I'm fine with moving on that.
To be determined. You're right.
Other comments or just?
Yeah.
And do we have any changes to the pros and cons in this one?
Any changes, pros and cons that went out for public comment or for review by the committee?
Take the E out of judgment.
Sorry.
Can I just get a I really had an internal debate about whether to go after that E.
I couldn't help myself.
It's fine.
So,
Dan?
yeah, how currently are, like, what fees are lawyers charged currently to be a part of the bar? How does that work? So the way I'm looking at this is, obviously, we don't want to grant. Thank you. We don't want to grant, obviously, it's unfair to grant powers to technology companies and machines that lawyers don't currently have. If, as far as regulation goes, they definitely have to be regulated as much as lawyers in certain ways, and that's just really unfair if they're able to practice law in some regard.
What's that? The servers are about to leave BT provision.
Yeah.
Okay.
So,
Okay, folks on the telephone, we're getting feedback. If you could mute your, if you could please mute your phone until you speak, it would be very helpful.
I know.
Did
you fix it?
Where's the gavel?
Okay.
So my question is, how currently, what kind of fees do lawyers pay to the bar? And
Spreadsheet? Well,
comparing
you
that to
still
this,
got a bullet.
that's the background
You
that would
still
really
have a
help.
bullet before you put it anywhere.
Johan.
I think it's Johan.
Hey, Johan?
Yeah, used to be off.
Yes, I'm here.
Johan?
Yes.
I think we can hear you talking.
Do not say take nothing. No, I'm sitting in a room by myself.
Oh, okay, sorry. We can sure hear somebody. Simon?
This is Simon. I'm in a room by myself as well.
Doesn't sound very
The controller of the web.
Who's the guy from the public?
I'm confused because you said that she still needs to cancel them and then
Nick.
everybody emailed.
was on this morning that was
Nick.
put us
Nick.
I talked to, I'm creating.
Bullet points.
Nick.
There's Lori. Nick?
Spreadsheet, bullet
Nick.
point, we can hear you.
Just in the bed.
Nick?
Yeah, and then some receptionist called me back.
But they're not used to be offline yet.
Hey, they are.
Oh, they are.
Yeah.
Yeah, the WebEx controller can mute.
Okay.
There we go.
All right.
Perfect.
Perfect.
Still got it.
Can we knock them out?
Can we
Still
shut them
got it.
off?
No, you can't.
This is just the law firm visitors, not even the stats.
Can we shut everybody down and then
I
have
gotta give them
our
overwhelming
ones that
proof,
want-
try and get
How
them
about
to.
Well, you could do that. No, he'll still be on the line.
Well, if we disconnect completely.
Why don't we disconnect completely and then have our folks call back?
You wanna create I'm saving all of this.
Still be.
You can create a spreadsheet that has a spot for visitors and then profile views, et cetera.
reach it.
Lori.
Just send them a
Oh, you did?
Twitter.
I don't think I can, I don't recognize the voice. I don't know who
Oh,
it is.
that's not.
I don't know if it's, I don't know if it's him.
Kevin Moore.
Person and the member of the public is not.
Is it the Los
Simon,
Angeles bar or
or
no?
State.
This is the state bar.
Okay.
Go for it.
Okay, we've got a moment of silence. Daniel, I think the
Yeah.
way lawyers' fees work is you are charged a flat fee and it's the same for everybody in certain age groups, I think, isn't
Well,
it?
actually,
Does it vary based on?
It's scalable based on.
There's fee
income.
scaling, yeah.
And we're-
I'm actually looking at it right now. If you earn less than $40,000, you're eligible for up to 25% off on your fees.
Okay, all right, so that's really helpful because
Set by the
hearing this,
legislature.
say again?
It's set by the legislature to answer.
Okay, perfect. So, I mean, that helps a lot with this, because I don't want to impose something upon technology that's not being imposed upon lawyers or vice versa.
Okay, so you're okay with this language that's on the
But we
board?
still are, because we're not telling lawyers and law firms they have to pay into an access to justice fund in order to practice. But we are for these new entities. And so it begs the question, if we really want to, I know that that's not I'm just saying, it doesn't seem.
This isn't an access to justice fund though, it's to enable you to not be sued or prosecuted for practicing law, right? And
Okay.
Right. It's enabling you to get.
This is your safe harbor.
Yeah,
Okay,
that makes
making it
sense.
something valuable, yeah.
Okay, so it would be similar to the same structure, and the amounts would be similar to what's contemplated by the other registration. Okay. It's,
Where we were coming at it was that, you know, if we're not limiting the technology to just access to justice, that we need to have a scalable system, because we could have a company that comes in with a great technology for access to justice, and we want to give them more scalability to get that technology out to the public of California versus another technology that is for profit, that is going to be utilized by corporate America. It's still a technology, and they need to have the same UPL protection, because we just know that'll be opened up. So that we want to have enough leeway, you know, in the process of coming up with the fee structure to take into account the companies that are really going for access to justice, whether that company is Google, who comes out with a great product that will reach access to justice, or a small nonprofit. We just want to make sure that there's some scalability there.
No one's picking on any particular entity in this conversation, of course. Just...
Lori? My only comment is that I think this is really something that could be handled by the implementation board. I think this is too early, and we could, in our efforts to do something that's helpful, may actually backfire and have the opposite effect, so.
One of the questions will be, how is this gonna get funded?
Yeah.
So
Right.
People are gonna ask this question, which is why we have a recommendation.
The idea is not to have this be something that the legislature then has to fund. This is designed to be self-funding. That's really what we're saying here.
Okay, it's been moved and seconded, this version of the recommendation and the whole package.
Nobody moved it.
I'll move.
Daniel moved,
I'll second.
Joshua seconded.
Thank you.
Okay, any further discussion?
And this is to approve the recommendation with the report.
Correct.
Just
Okay, Mimi?
Okay.
I'm sorry, we saw the cons, someone mentioned the pros and cons, and.
We added,
we're good.
yes, it's amended.
Okay, full enchilada.
Okay. Andrew Ruda?
No. Enchilada.
No? Did you say?
Yeah, no.
Simon Bomey?
No.
Tara Bird?
Yes.
Judge Wendy Chang? Abhijit Sivan?
Yes.
Jean Clausen?
Abstain.
Johan Drolshagen?
No.
Margie Estrada? Lori Gonzalez?
No.
Bridget Granny?
Yes.
Andrew Kuchera?
No.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morris?
Yes.
Joyce Raby? Daniel Rice?
No.
Toby Rothschild?
Yes.
Alan Rodriguez?
No.
Mark Tuff?
Sustain. I mean, sustain. Oh, I made an objection somewhere.
Relevance?
Sorry. Dan Rubens?
Yes.
Mark Tuff?
Abstain.
Abstain. Joshua Walker?
Yes.
Thank you.
Okay, passes. We're moving on to B7, and you guys will finally be off the hook.
All right.
B7 is regulated entities should not be limited or restrained by any concept or definition of artificial intelligence. Instead, they should be limited by the concept of legal technology, which is defined as technologically mediated solution. Take it away.
So I can start with that. There was a concern, there's two things. So I can talk about the general AI thing. Even within the artificial intelligence field, there isn't a clear definition of what this means. Second, AI is evolving constantly and every day. So if the most expert practitioners in the field, many of which we've consulted or worked with in the past or work with now here or internationally, can't define it in a really clear and concise way, in a bright line way, we probably shouldn't try to. And like every other rules versus standards debate, if we have a bright line rule, it'll get gamed. And probably pretty easily. Dan? Yeah.
And then, so the other reason we thought of this is there can actually be some really great technology solutions that have nothing to do with AI. However, that may or may not be defined, and we don't want to preclude those. We want to encourage innovation, however it comes to us. So instead of defining something that's sort of wishy-washy and very future-looking, we decided to define it in terms that we can all sort of wrap our arms around today, which is legal technology, or technology that does something related to sort of law as we define it today.
But on the other hand, on the flip side, we have no scope for what we're doing. The prediction was offered, right, through various quarters that we're DOA, right? That it's just, if we try to take on too much in the reform process or innovation process, we just won't get anything done. So the concept of legal technology came up. It's highly imperfect, it's vague, it's better than having, we can do any kind of innovation whatsoever because we're likely to fail, was the argument going in. So again, I don't know if this constrains anything else, but in terms of this, if we reference a legal technology, if we reference the idea that it incorporates in some way judicial or legal or expert thinking, we at least have some basis for controlling scope. If we go after everything, again, this entire effort could be a waste of time, and we want us to make sure that we're doing something positive as opposed to nothing. That's the background.
Yeah.
Pros and cons.
So very briefly, I don't think we made any adjustments to the pros and cons in this.
No.
So that's as it was circulated. So I will go ahead and move the recommendation as it was amended in our, we did make a change this morning, yeah.
You did? This is the version I got off from whoever was working on it.
Oh, no, okay, never mind. We had approved this in our previous committee meeting, so moved as published.
And then you're moving both the recommendation and the write-up.
Correct.
And can I ask a question? Is this one of the situations where we would put in that state bar certified da-da-da-da-da-da?
Yes.
Just to see what it would look like, let me just show you.
You've got that right there.
Yeah.
Thank you.
Although,
so moved now as amended.
yeah, and I think that, again, we can have variant concepts and suggestions. It's not restricting other stuff.
Okay, Mark.
Why not just stop your recommendation at the end of the first sentence and not get into a definition of legal technology, which you say is vague and is not a well-defined term?
Yeah, so I understand that. We did want to have some limit there, rather than sort of saying that we can regulate anything. Just sort of thinking about overreach, regulatory overreach. We don't want to be accused of regulating the entire legal technology market. We're wanting to regulate what's traditionally the sort of functions of a lawyer, whatever that means, but executed by technology.
Whatever we recommend is going to take a job to get through, and again, it's completely open-ended. What we've learned is that it just reduces the probability of getting any innovation change. So that's the background.
But didn't we discuss earlier today that some of these innovative steps we're talking about may or may not involve technology?
But I don't think this constrains those concepts. I think this only constrains the defined term.
Proposal.
It's separate. So if you look at the one I voted for this morning or earlier, for instance, it isn't constrained by this defined term, for instance. It's just entities. But in the construct of this subcommittee, that's what we're talking about. It's not talking about other constructs.
The second sentence is, instead, regulated entities should be limited to the concept of legal technology.
And we can say it's such entities, instead such entities.
Yeah.
Okay.
I'm sorry, what?
We're changing regulated to instead such entities.
Oh, so I say such entities. I still think the first sentence would do the job.
I think particularly when we've added the technology-driven legal services delivery systems, already puts the technology into that limit.
I think the point that was being made earlier is that technology is so broadly defined that you could have a virtual law office, which is just the interface. They don't have a brick or mortar location, but they just exist as a website, and you communicate via email or Skype. But that is not a delivery system that fits the paradigm of one of the justifications for this entire task force, which is there are things happening now and will be happening in the near future that will be unregulated unless we step out and try to consider the public protection ramifications of that. And so if there is some technology, it doesn't have to be AI, but it's doing exactly what's described there, substituting technology judgment for lawyer judgment and giving essentially legal advice, then we don't want that to be unregulated. We want to be able to bring that into the fold. But that should encompass the virtual law office practitioner. They use technology, but it's not a technology driven. So I see this as clarifying that defined term of art that we're going to be using for describing the technology entities that would be approved.
Jean. I just have a clarifying question. If we need the parens in there, the parentheses piece in there or not, does that also cover cloud technologies, or does it matter, or should we remove that? Because is it too narrowing?
I think we just wanted to make sure it included software/data-centric platforms. It's for clarification, and maybe it's slightly redundant. But that came up in the drafting process, and we wanted to give a sense of what a technology-mediated solution would be. Again, it's fairly broad.
So it's not just Skype.
Yeah.
Okay.
If it's lawyer on Skype, it's got to be more than lawyer on Skype. It's got to be someone carrying out the analytic function automatically, essentially.
I just wanted to make sure it wasn't narrowing it just to a software related.
No, that's an example, not a restriction.
If it's an example, should it be an EG instead of an IE?
Yeah.
Thank you. I made that point.
I just wanted to share in response to Toby's and Mark's concerns. We empathize with you. Our original recommendation was just that first sentence, but in our last meeting, Leah Wilson attended, Randy also, and Leah in particular expressed the thought that if we don't have some sort of limiting concept, that it'll be a harder push with the Board of Trustees and perhaps further down the line. So this was our attempt to, again, make clear that we're not talking about just any use of technology, email or telephones.
Karen. Yeah, I think I initially was reading it differently. I initially was reading it that we're not trying to define artificial intelligence. But I'm sort of concerned that as written, we could be incorporating technology that already exists. How does like Lexis not fall into this, right? Isn't that technology-driven legal services?
No. So that's why we have that last part of that middle sentence, defining like what we're talking about there as far as the analytic function, understanding, insight of an expert attorney or member of the judiciary. So we're not talking about just like any like legal research or anything like that. We don't want to sort of spread our tentacles into like normal legal tech. We want to say this is just in the area that we're expanding, that we're doing the carve out in traditional legal practice.
How about if one of those large entities developed a system that was like predictive analytics or whatnot that does use this, would then they have to fall under this? I do feel like there's questions as to.
Only if they wanted the safe harbor from APL.
Right, because they've got that risk today.
They do.
Yeah, potentially, right? If you reach out beyond a certain point, you might reach it, but we're not changing that. What we're offering is a safe harbor through certification. The last sentence gives an example. That was, if you go back to Judge Chen's memo on practicing law, applying case law to a specific case is one of the things that's specific to it. So if you go to Lexis today or Thompson or what have you, it's not going to tell you this case law applies, or you should draft your contract in a specific way, or that this is illegal. Potentially, we're considering things that could do that. They're regulated and controlled. So we're trying to make clear and flesh out that it's actually analysis that's happening, and that's more applying law to a specific case.
Well, two comments back to that. If you look at a practice guide, it does tell you what law should apply. And if it takes this much explanation to understand what that paragraph means, makes me feel like it's not written as well as it could be to explain what your point is, because I think it should be something simple. And I see what you're trying to say, but I'm not sure that this says it in the best way, and that concerns me, because if we have this much trouble, what's the public gonna think? So I'm just wondering if there is a way that we could, quickly and easily edit this so that it's clearer.
We're happy to make it clearer if people have specific suggestions and consider those.
You almost think like it should just be stated more succinctly that it's technology-driven legal services that are replacing an attorney. I know that's not the right words, but that are carrying out an attorney function. Because you started off with saying that we're not constraining ourselves to the definition of artificial intelligence. That's what I think that this paragraph is about. You're telling me it's not about whether artificial intelligence is or is not one of these programs. You're telling me that this is about replacing the attorney function. And so I think those issues need to be
Okay, so instead such entities should be limited by the concept of legal technology, which is defined as a technologically mediated solution. I can take or leave. I mean, the parenthetical, I think I'm open on. Technology mediated solution that in some way replaces the traditional analytic
But it should be
function
up
of
in
a
the
judge
first sentence.
or whatever. Go ahead.
It should be up in the first sentence.
Well, first, the first thing we needed to do is not define AI. So that's
So
Should be the
in the charter,
substance of your
it
recommendation.
specifically calls out that we're supposed to evaluate AI. I mean, the name of our subcommittee is AI. So
yeah.
I mean, we're just trying to say we're going beyond
And
just
then,
AI.
is it your recommendation that
No,
you're not
no,
defining
because-
AI and leave it at that?
The reason we need to add something here is we're taking away. So the assumption of the trustees was, in some respects, that the task force, our charter, is that we have something called AI, and then we need to have some way of using that and leveraging it for access to justice. If we're taking away that concept because it's not a good term, you have to give them something to constrain the scope of what we're doing. Otherwise, if we're all powerful, we have no power. I mean, we're not going to get things through. Heather?
No, I was gonna say, it's looking at the fact that it's technology, but a specific type of technology, because it's not email, it's not, text messaging, it's technology that's actually delivering the service to the consumer. It's not just every type of technology, and that's, we don't want LexisNexis brought into this, we don't want a lot of the technologies that are out there. I mean, we have, full organizations set up around legal technology. It's not all legal technology, it's a very specific type of technology.
What about legal technology that provides direct legal assistance?
That's fine too.
I like that.
That's fine too. Do we know what that means? Because that could be the LPA.
Or technology that provides legal
I just don't
services.
think this says it in a way that makes sense to me.
Well, which is defined as a technology mediated solution, right? The parenthetical, again, I think that's open for debate. Technology mediated solution that in a material way replaces the analytic function of an attorney. Period. This may include the technologically mediated application of law to a specific case.
If we say replace and attorneys read this, that's not going to go.
How about the
That in
forms?
some way embodies? Embodies or employs.
I think that's going to be hard to define.
True, but it's probably better than nothing, right?
Carries out.
So we're adding words here, not taking them away. That's the only thing.
What if, again, that in a material way embodies the traditional analytic function of an attorney? Period.
I think you can lose in a material way.
I wouldn't.
know that adds anything.
If it embodies in a tiny way, we don't necessarily need to cover it, right?
Yeah.
So there has to be some sense of degree.
But we have to, keep in mind in that respect that these are people who are coming to the regulatory body, whatever that is, to get the safe harbor. So it's people who are coming to us to seek that. So I don't think someone who's doing something so minuscule is going to seek safe harbor as well. So we might not need that.
Okay, yeah, again, I'm open mind on that. Let me just say that materially embodies the traditional analytic function of an attorney.
And then you're saying delete the rest of the paragraph?
I do like the last sentence because it's just one example. The traditional analytic function of an attorney, I would maybe after function, I would add of an attorney. Kill the comma. And
I
they
feel
could
like this
kill
is
expert.
very lawyerly and not focused on the understanding of the tech companies that we're trying to, target.
Again, open to other language if you have a specific suggestion.
I wish I did.
In the sentence after attorney.
And I don't know if we need or member of the judiciary either. I think we can delete that.
Yeah.
Because here it's not. We're not going to replace it.
And I think the parenthetical should go. I think you've already said that.
Great.
We can kill that.
Lose as many words as we can.
No.
See, that actually doesn't sound lawyerly to me, it sounds like techie to me. Technologically mediated solution, I have no idea what that means.
No, I'm not sure either.
But I don't think that's a lawyer
Tech-
term,
tech-
that sounds like a high-tech kind of.
Techies don't sound.
Well, then who says that? What does that
No
mean?
one sounds that.
I don't even know, understand
What
what it
happens
is.
when you put techies and lawyers
entities
together?
should be limited.
New language.
Could you simply
Yeah.
say, why don't you just say which is defined as
But
solution?
what was meant by
Yes.
technologically mediated solution? Does that mean taking facts from a client and?
Delivering legal services through technology, but we didn't want to limit it to, or we didn't want to
That makes
include
more sense.
things like delivery of a legal service via, just.
If you're sending stuff through the mail, right? If it's replacing a lawyer's judgment through just mails or ears or something,
Then can you just
Yes.
change it to instead says entity should be limited
What?
by the concept
Oh,
of
just
delivering
getting
legal
as a-
services instead of
Getting rid of the
Heather,
technology
do you have
mediated.
something you want to contribute?
we're trying
We're going
to
back
come
and
up
we
with
get,
something that.
because we're bringing in the
because you
concept.
need a label of legal tech. It's
We're
more
bringing
so regarding the
bringing in
delivery
some of the
services.
conversation that we
Gene, what was the
had in the
suggestion?
subcommittee meeting outside of this. But really what we're trying to say is that we don't want to be constrained by this term, artificial intelligence, that can't be defined and is going to continue to evolve. So, just a suggestion would be the state certified entities, we don't want to be restrained by that term, is what we're trying to say. And then we were just chatting about whether or not can we then get rid of the rest of the paragraph, and it was saying no because of the concerns that Leah and other people had in our subcommittee that none of you were there for. So I think we're being constrained at the moment by conversations that you were not privy to, and we're trying to resolve all of that.
This makes a lot more sense with these changes to me personally. It's shorter and it doesn't have such long words.
We gotta get rid of this.
Justice Edmund.
If we keep it the way it is now, we need to get rid of this because now we're just throwing it in that one.
Andrew.
I'm just concerned because of the time that we have left.
I'll top that.
And I feel that I really don't want to be like the person who's voted no on like that much, and I'm probably going to vote no on this, but I just feel like we might have to move forward with a vote. And
This may include, I just think,
Can we go with this version though?
just delete technologically mediated. So this may include the application of law.
I would throw out there, so after artificial intelligence, instead, such entities should be limited by the scope of delivery of legal services, or something to that effect. Because you're not trying to limit technology, you're trying to limit the legal services that it's providing. I think too many times we try to throw the word legal in front of technology, and it's really not about that. It's about using technology to deliver those services. So maybe since you're trying to prevent or limit that, it's more related to the services versus the technology itself.
Yeah, I agree. Again, the thing we're trying to use is to give Leah a tool, give the bar a tool to say, this is not all things for all people. We're talking about a set of functions that is like a lawyer making a judgment. So that's why we're using that term. It's imperfect, but I think the danger is that DOA otherwise.
Would it maybe instead the scope of the regulation should be limited?
Yeah.
We're talking about
If you
regulation of.
Sure, that's fine.
take out radio technologies, make it limited by technology solutions that materially embody the traditional analytical function.
That's fine too.
The problem I have with embodies the traditional analytical function is a practice guide does that. I mean, somebody has done the analysis for you. It's right there. It's embodying that. I think you're really talking about
But this is direct to consumer.
A technology that performs the traditional functions of an attorney.
Yeah.
Providing advice, using
So
judgment,
performs
applying
over
law to facts, that type of thing. And the other thing is you're trying to elicit comments here from the public. So it seems like I agree with Tara, if you have something a lot simpler that's really going to spur conversation, I think that would. If you said a technology that performs the traditional functions of an attorney. They're going to get a lot of comments like, what is that? What doesn't include this? And then maybe will lead to a more nuanced conversation.
So performs is plural.
I think in that light, you would want to drop that last sentence. This may include, it may include a lot of things.
Yeah.
That's fine.
I agree with
Okay, get rid of the word
Abhijit.
solution
The
in
last
that sentence.
sentence seems unnecessary to me.
Okay.
Take out the
That's
last
fine.
Last
Last
sentence
sentence
goes.
goes.
There you go. Oh, look at that.
Okay, that's
Okay,
a
you
lot
guys okay
shorter.
with that?
To
I think
technology.
we're fine.
I like that.
Yeah. Technologies that perform.
Okay, Mark.
What you're really talking about is technology that substitutes or replaces the traditional functions of an attorney, because perform, lots of technology that today performs traditional functions, document review,
Yeah, I think you need to
contract
edit that.
preparation. It's way too much. The gestalt of this is you're gonna have technology that takes the place of or substitutes for. I don't like those words either, but I'm saying that's the
So
concept.
instead of perform, substitutes for?
Yeah,
Oh
I'm
my
just thinking
God,
tactically.
you're getting
that's
closer.
gonna be.
On the traditional analytical, what's wrong with analytical?
I also don't know why, maybe this is just me, the word traditional, I mean, just you can drop that too.
Yeah.
Because I don't know if the public knows what that means, I don't.
Or replace traditional with analytical.
I think we need analytical.
Analytical, you want that back in?
I do as well.
Because if you LexisNexis just.
Because that's really what it is.
That's right, it is the
It's
analysis of.
analytical, yeah.
Sure.
If it, otherwise, it would be fill in the form.
Right, okay. Everybody okay to move to a vote?
Yep.
We're voting on the recommendation and the backup. Mimi?
What? Sorry. I need a motion and
Moved.
a second.
Seconded.
Okay. Van Raven, Joshua Walker.
All right.
Andrew Rita,
I'm gonna abstain.
Simon Boney,
Abstain.
Tara Bird,
Yes.
Judge Wendy Chang. Abhijit Shaban,
Yes.
Jean Clausen,
Yes.
Johan Droshagen,
No.
Nacho Estrada, Lori Gonzalez,
Abstain.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza.
I don't know.
I don't have a box for that.
That would be an abstain.
Abstain?
Yeah, that's the only, yeah.
Kevin Moore? You pass out.
I've been.
Okay, Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
No.
Toby Rothschild,
Yes.
Alan Rodriguez,
Abstain.
Daniel Rubens,
Yes.
Mark Tuff,
Abstain.
Joshua Walker.
Yes.
Thank you.
Okay, it passes. We are on our last two. The first is C2, the next is C3. This is from the Rules and Ethics Opinions Committee. It's adoption of Rule 5.4 into alternatives. Start with C2.
All right, oh, see, I don't know what order they are.
It's alternative 1 and alternative 2.
Okay.
So let's start with alternative 1.
Alternative one, yeah. So just so that you all know, and I don't know if you want to do these completely independently, but alternative 2 is a reduced, or there's less in that, but the same concepts because we're talking about the same rules. So that's something to keep in mind. We've described the 2 as this one Alt 1 is a narrow fee splitting model, and Alt 2 is a client consent model. Did we have it, none of this was approved yet?
No.
None of it was approved.
Oh, okay.
And did you make any changes to the materials that were sent out?
No. No, they didn't.
No.
So these are
Oh,
basically.
no, we did, actually, there
No,
was that
that
E1 section?
Oh, we made some changes to the pros and cons, maybe?
Yeah.
Yeah.
I think it was under B1, was it B1? Hold on.
We just added some pros and cons, or some cons.
We added a con, that's what we did.
Yeah. We added 2 of them that are similar, basically that, so our intent with this was to take this sort of a middle ground between the MDPs and the, the regulation of a law firm. This is not that. This is somewhere in the middle where the lawyer still ultimately has the responsibility and is still liable to the state bar, or, still responsible to the state bar. The state bar does not have any authority over the non-lawyer, and there's no other regulatory entity that has authority over the non-lawyer. So the lawyer in this relationship still bears all of that responsibility, but they may fee share if they meet these certain requirements.
Okay, so is it your suggestion that both alternatives go out together? I mean, we'll address one at a time, but you're
Yes.
suggesting that both go out in the 2 alternatives.
Correct, but they are separate and distinct.
We should be able to send it out. I don't know if we'll absorb any feedback on it. Be able to send it out.
Can't change anything.
Okay, so let's start with Alt 1. Tara, are you moving them?
Yep, I'll move.
The recommendation and the write-up?
Correct.
And is there a second?
I'll second.
Okay, it's been moved and seconded. Discussion. Okay, we're ready for a vote.
Okay, the motion is to approve the recommendation and report as drafted or presented. Andrew Rita?
Yes.
Sammy Bowman?
Yes.
Tara Bird?
Yes.
Judge Wendy Chang? Abhijit Shaban?
Yes.
Jean Clausen? Yes. Johan Drolshagen?
Yes.
Matthew Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore? Heather Morse?
Yes.
Joyce Raby? Daniel Rice?
Yes.
Toby Rothschild?
Yes.
Alan Rodriguez?
Yes.
Dan Rubens?
Yes.
Mark Tuck?
No.
Angelina Valverde? Joshua Walker?
Yes.
Thank you.
And Alt 2, it's been described. Broader, less restrictive.
Lori, did you want to add anything?
Yeah, just one thing, the materials that went out for Alt 2 had no cons. We did add in cons to that. And also I wanted to point out that the way Alt 2, it will need some work by the staff. The discussion points in the Alt 2, there are several paragraphs before we get to the pros. Those are actually meant to reference back to the charter and the work, those kind of things. We did remove an entire paragraph, and so I want to point that out as well. Can you scroll up to these? We removed that one entire paragraph. So we've deleted that paragraph as well, which discussed, was a little bit of a discussion about the ADA's proposed rule and what that did. So those were the substantial changes. I think those are pretty big changes from the materials we sent out, but otherwise, it's just as we sent out.
Yes.
Maybe it's a philosophical question, but how are the alternatives being presented? Is it, here are 2 options, we welcome with equal interest your feedback? And that's it?
So, yeah, I can give a little, the background on this was
I'm just where, I do know, sorry, I don't mean to cut you off, and I know it's late, I don't want to present, keep anyone here longer than they are. Traditionally, when we put out rule alternatives, there's an explanation. Alternative 1 is what was offered by the Supreme Court, and alternative 2 has been, contains slight revisions by the Rule Revision Commission.
I think we've done that in the
things
material,
like
I'm hoping we've done that in the materials. Really, the idea was, there's a version of this rule that is based loosely on previous ideas that have already been presented in some form by the ABA. And alternative 2 is a much more client-centric focused idea that basically is not limited in as many ways as alternative 1. And we thought that at the very least, public discussion would be useful, and the data that we could get from the 2 versions could be helpful to the task force and beyond.
And the presentation is totally agnostic as to any preference that this group may have. Thank you.
Mark?
Just for the record, the proposal you're referring to by the ABA Commission was never presented to the ABA.
Right, we've eliminated the paragraph that suggested it was, that.
Yeah, I mean, it never got off the ground, so there's no analog for that.
All deleted.
So it's new stuff.
Need a motion?
I'll make a motion.
Second.
Okay, it's been moved and seconded. Discussion. And the motion is for both the recommendation and the write-up, correct?
Yes.
Can you show us the cons that you've added again, just real quick?
Sure. The basis of those cons were actually there's no mechanism for regulating the non-lawyers, and that there was no concrete evidence that this proposal or data that would increase access to justice. Those are our 2 cons.
Okay.
I'll just make one more observation.
Yes.
Heretofore, this subgroup had recommended recommendations that we consider 5.7 and the advertising rules without an actual proposed rule. Here, there are alternatives to actually propose revisions to 5.4, which raise many, many issues. So one alternative would be just to simply say what you did with respect to 5.7 and the advertising rules, that we ought to consider amendments to 5.4 to accommodate these alternative entities, but not have the draft, because the draft is, in the rule drafting business, there'd be a lot of work done on this.
Although respectfully, we did a lot of work, and Kevin was on our team.
Well,
And so, I mean, there was a lot of work into that.
Let me
Open to
throw out-
criticisms, but it wasn't something that we put together, last week. It was months ago.
Yeah,
Or,
let me throw
months
out
ago.
that the concepts we understand, these are big changes. We understand that on both sides. The rules, as our subcommittee has drafted them, these rule changes, we put a ton of discussion and effort and thoughts, both from committee members and people who aren't on the committee. The language is on purpose for a reason, and we are hoping that it spurs a lot of discussion.
I suspect it will. Randy?
And we really did look at the language being developed both for the competence comment and the 2 alternate versions of 5.4 as illustration or discussion drafts. Very similar with what we did with our State Bar MVP task force, what the ABA has done in some of their resolutions, where the expectation is you're not going to understand what we're getting at unless we give you something a little bit more concrete to work off. But we're not saying this is our baby, this is what we want you to adopt. We're saying this is the basis that we're using to explain the concept. And so it's not a far cry from what we're doing with 5.7 and the 7 series, but the vehicle we're using for those are just the ABA drafts. The vehicle we're using for these, we've tried to Californianize a little bit so that the audience has a better idea of what we're, the concept of what we're recommending.
I would feel very comfortable if staff would make a concerted effort to make that clear
Definitely.
in the introduction to these things, that this is not a stance by this committee as with respect to any of these.
Right.
These are going out for public comment because we want the input. Andrew.
Yeah, I just wanted to say that I think Rule 5.4 is kind of the 800-pound elephant in the room in terms of blocking access to justice. And the scope of what could be done with the rule to improve that is very broad. And there was some passion on lots of sides of this issue in our subcommittee, and I think there are excellent arguments on both sides of where to fall in that scope of amending the rule. And I think what we would really appreciate is some public comment on a couple different ways that we could go with it. And that would really help. I mean, we're just a small group of people trying to figure out what to do with a very important, very broad potential revision to the rule.
And also in Alt 1, we specifically identified a few questions that sort of take us to a place potentially between Alt 1 and Alt 2, where we say, are we limiting it, specifically asking, are we limiting it too much in Alt 1? And then you turn the page, well, here's another one. Is this too limited? Is this not limited enough? And so by doing both versions, we hope to get the maximum amount of feedback from the public.
Further discussion? Okay, it's been moved and seconded, both for the recommendation and the write-up. Mimi?
Okay, Andrew Ruda,
Yes.
Simon Bomey,
Yes.
Tara Berg,
Yes.
Judge Wendy Chang, Abhijit Sivan,
Abstain?
Jean Clausen,
Yes.
Johan Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy,
Yes.
Andrew Kuchera,
Yes.
Joanna Mendoza,
Yes.
Kevin Moore, Heather Morse,
Yes.
Joyce Raby, Daniel Rice,
Yes.
Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Dan Ribbons,
Yes.
Mark Tuck,
Abstain.
Joshua Walker.
Abstain?
Thank you.
Where to begin? I can't begin to thank you all enough for all the work that went into this effort. It really was remarkable. I thank you all very much for your time. Unfortunately, I am going to have to dash, so I don't miss my plane. Let me just say for a second, for all the work that we all do in this process, these folks do like 16 times the amount. They are remarkable. And the amount of work that they're going to have to do to get in the next couple of weeks to get this to the Board of Trustees by July 12th with the amount of notice that has to be given is just going to be monumental. So to Randy and Andrew and Mimi and everybody else on the bar staff, we thank you. And we'll all answer your calls if you call us with further questions, because we did a lot of work in a short amount of time today. So thank you all so much. And I look forward to seeing you in August, which is the next time we get together, unless you happen to come to the Board of Trustees on July 12th, 11th, July 11th. All right. Safe travels home, everybody. That's right.